Who won't smoke with me? Who won't smoke with me? Who won't smoke with me? Nigga, who won't smoke with me? 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 Nigga, who won't smoke with me? Who won't smoke with me? I'm tryna fuck a nigga lawns up. They be like, no, don't put them damn guns up. Fuck that. Say big brother, bring on guns out. Wanna smoke? We get the spinning while the sun out. I ain't never letting out pump gas with my gun out. Scream out what's happening to get the bus until it run out. All these niggas hiding like what they got, it ain't no fun out. 6'6" too big as hell to knock a nigga lungs out. 1, 2, 3, 4. Kick your toe, get on the floor. 5, 6, 7, 8. Don't make no noise, I'll eat your face. 9, 10, 11, we ain't gon' say that nigga won't fuck with G. I'ma kill 14 niggas if 13 bitch niggas play. I think my Draco might be sick. Why? Cause he blow niggas. I just got a brand new lolly. There's a faux nigga. Call me an auto yes man. I don't know niggas. You can send your best man. You gon' lose your best hitter.
What the fuck is that? Hey!
What the fuck is
Come on, Lil Dirt. Come on in, baby.
That's how I step on
Come
niggas.
on, Lil Dirt. Come on, here you go.
They be on my page like Slap Vaughn, I know they trolling me. Outside with y'all pick on me, be on, I keep the folks with me. Got it back in blood, y'all just don't know that's how it supposed to be. Caught him for a feature just to kill him, cause we know he's who the fuck is that?
Hey!
Don't look out the window, don't forget the strap. I be on they ass when I see ops, I do forget I rap. I be on this shit wherever I'm at, I learned that from the rap. He gon' drink whatever nigga sell him just to say hi. They be like he wasn't even with that shit whenever a nigga die. Mercy won't always lie to y'all whenever a nigga die. Send a nigga stable as they check just to keep y'all quiet. Bro, no stump his ass. Better do what Nardo said, cause niggas die for pumping gas. Why you act like that shit so exclusive, bitch? That's public ass. Ain't no nigga we don't fuck with, come around, we stump his ass. Nardo voice, creep up out that cut, we like, Nardo voice, catch it before he won that gun on. Hey, who you kill? Steady talking like you did a drill. We gon' kill you sober, who done told you that I need a pill?
Yeah, dear stepper, put my toe on that boy. You Mickey Mouse, bitch, you went and told on that boy. All my guns come with a switch, cause I'm fucking rich. I don't type no tweets or throw no fists. Get shot in your shit. Old nigga steady tryna diss. Fuck up by my dick. Caught him leaving bingo with his bitch. And we sent a blitz. Nardo tryna fight me by the stick. It's his turn to blitz. I can't even roll my ass and shit. Pussies don't exist. 1, 2, 3, 4. Niggas mad I fuck they hoe. 5, 6, 7, 8. Pussies that got hit this case. 9, 10, 11, 12. Don't got L's, they gotta chase. 13, 14, 15, 16 hollow tips, they hit his face. What the fuck is that? What the fuck is that? Hit that little bitch front or back. Pest control, who called about rats?
Who won't smoke with us?
Hey!
Who won't smoke with us? 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 Nigga.
I be with real killers. I'm a rapping street nigga. Copy paste delete niggas. Can't wait till we see niggas. Who won't smoke is free. On the oppa sweet swish. Hop out middle of the street. Hit him soon as he fall off his feet. Kill him. Been out all week. C3 RIP. Pick my shooters, I'll eat it. You can tell that we rich. Pull up all and swish. Been on all the hits. Now I'm all legit. Shout out a wig. Bitch. 1, 2, 3, 4. Fuck the ops, them niggas hoes. 5, 6, 7, 8. Slamming race with GDK. 9, 10, 11, 12. No man still ain't go to jail. 100K checks in the mail. Put that away just for bail. All the crack we used to sell. Auntie house still got the smell. Fans be negative as hell. Fuck that shit, I just prevail. Hey, y'all hold 100 shells. Aim that bitch, shoot everywhere. No limit, I never care. Spin they block, they never there. Plus, what the fuck is that? What the fuck is that? Cost a fucking check. Wow, touch my fucking neck.
Hey! Y'all, come on. We got to get this cardio under. This is going to be a paperwork thing. So this is the extended version of the music. Yeah, I'm your YouTube Jasmine Crockett, baby.
Now we can settle this like you got some plans.
Yeah. I'm your YouTube Jasmine Crockett.
I don't want no issues, bro. I don't want no smoke. I don't want fights. I don't want to do nothing, bro.
That's what I be saying.
Like, please, bro.
Who want smoke with me? Who want smoke with me? Who want smoke
Hey,
with me? Who want smoke
it's
with me?
everybody's baby daddy. Hey.
Who want smoke with me? Who want...
Ah,
Okay, let's get down to the facts. Pussy, I'm dripping red.
Uh-huh.
Don't let this R&B shit fool you niggas get ripped to shreds.
Uh-huh.
Quavo talking like his dogs, nigga, you a bitch with dread.
Ooh.
Can't wait to see the day that you back up all of that shit you said.
Uh-huh.
What's all that bullshit you talking? You ain't no hundo, nigga. You the weakest link out of your clique. Let's keep it a hundo, nigga. You fuck my ex-hoe, that's cool. I don't give no fuck, little nigga.
Uh-huh.
Cause I fucked your ex when you was still with a bitch. I'm up, little nigga.
Uh-huh.
They say revenge is sweet.
Uh-huh.
Now think about that shit. Don't let that lie go over your head. I might just sing about that shit.
Sing it,
I had
Chris.
a thing about that.
Sing
There's
wild,
something
nigga.
sweet about that shit. I got some tea about that shit, but I ain't gonna think about that shit. I ain't playing chess with a checker player. I'm a ticking bomb on a detonator. I shit on niggas, I'm a defecator. I put amigo on a ventilator. Stop talking about beating girls. You was beating bitches on the elevator. We seen the taste, that's devastating. You doing bad. You a bitch and your music trash. Actually, they set me next to your lame ass. I was truly mad. All I kept thinking about was breaking your face, but I gave you a pass. You lucky I ain't wanna fuck the money up, boy. I would've broke you in half. Quit trying to be tough, you ain't like that. Why you keep showing off? Quit talk about drugs, you the only pack that I've been smoking on. I just hit my plug, told him come back, I'ma need more than one. Your last album was a weed trade, just some bullshit that we roll up on. You know what's on, put you to bed. Night, night, that's Sudafed. Show me that I'm tender, bitch. Trying to prove what you just said. R.I.P. take off, he the only real one that got true respect. Crazy how when he died, everybody really wished it was you instead. Oh shit! You tripping, Chris, don't say that, don't lose your head. You just turn to big bad when these fuck niggas never knew revenge. This what happens when a fuck nigga push a real nigga out to the edge. This what happens when a dumb nigga gets fame and it get to his head. You gon' kiss this ring, nigga. Big fuck you on my middle finger. I tattoo my trigger finger. Bring real beat to your dinner table. My middle stay, it ain't never stable. I know this shit gon' sting, nigga. I run your ass through the ringer, nigga. You just got bodied by a singing nigga. Bitch.
Who want smoke with me? Who want smoke with me? Who want smoke with me? Who want smoke with C? Who want smoke with me? Who want...
Yes, honey. We're gonna get to the subject of records and beefs that go to the goddamn lawsuits. Like what? Oh, Drake is real tender. I got that paperwork, dog. Yes, I do. Yes, I do. That TD Jake's paperwork dropped on through there today. Got that paperwork, dog. Yes. We won't speculate over him. Well, now we have Sarah, the Rita. Okay? And this is what I named her. Yes, honey. One more and we're gonna be on the go. Hey baby. I said come on, women's empowerment. Come on. Women's empowerment. Yes. Y'all make sure y'all find that like button over on Twitter. It's the heart.
Not knowing where I was or when I was coming back sent you crazy. I kept my spies on you, though. I didn't like what they reported back. Thought you were smarter than that.
Come on, kiss your muscles.
You had to have known this was strategically designed architecture. Architecture that only I have the pink print for. Nevertheless, you took the bait.
Come on, come on, come on, y'all.
Hey, yo, look like I'm going for a swim.
Hey.
Dunked on him, now I'm swinging off the rim. Bitch ain't coming off the bench, while I'm coming off the court fully drenched. Here goes some haterade, get your thirst quenched. Style doing him in this Burberry trench. These birds copy every word, every inch. But gang got the hammer and the wrench. I pull up in that quarter milli off the lot. Oh, now she trying to be friends like I forgot. Show off my diamonds like I'm signed by the rock. Ain't pushing out his baby's telly by the rock. Hey, yo, I been on, bitch, you been con. Bentley tints on, Fendi prints on. I mean, I been on, X-Men been on. He keep on dialing Nicky like the prince on. I been on, bitch, you been con. Bentley tints on, Fendi prints on. Hey, yo, I been on, Laura been crop. PlayStation Lee, drop the Benz off. Oh, I get it. They painted me out to be the bad guy.
Yeah.
But it's the last time you're gonna see a bad guy do the rap game like me.
Hey, tell him, nigga, what happened?
I went and caught the chopsticks. Put it in my bun just to pop shit.
What?
I'm always in the top shit.
That's right.
Box seats,
Bitch,
bitch,
fuck
fuck the
the gossip.
gossip.
Hey.
How many of them could've did it with finesse? Now everybody like she really is the best. You played checkers, couldn't beat me playing chess. Now I'm about to turn around and beat my chest. Bitch, just King Kong. Yes, this King Kong. Bitch, just King Kong. This is King Kong. Chinese ink on, Siamese links on. Call me 2 Chainz, name go ding dong. Bitch, just King Kong. Yes, I'm King Kong. This is King Kong. Yes, Miss King Kong. In my kingdom with my Timbs on.
How many championships?
What? 6 rings on.
6 rings.
They need rappers like me.
What? They need YouTubers like me. So they can get on their fucking keyboards and make me bad guy Angie. Hey.
Hey, yo, I been on, bitch, you been con. Bentley tints on, Fendi prints on. I mean, I been on, X-Men been on. He keep on dialing Nicky like the prince on. I been on, bitch, you been con. Bentley tints on, Fendi prints on. Hey, yo, I been on, Laura been crop. PlayStation Lee, drop the Benz off.
It's my lifestyle. It's my lifestyle.
Give me the password to the fucking Wi-Fi.
Hey. Come on.
Hey, yo, I been on, bitch, you been con. Bentley tints on, Fendi prints on. I mean, I been on, X-Men been on. He keep on dialing Nicky like the prince on. I been on, bitch, you been con. Bentley tints on, Fendi prints on. Hey, yo, I been on, Laura been crop. PlayStation Lee, drop the Benz. Just King Kong, yes, this King Kong. Bitch, just King Kong, this is King Kong. Chinese ink on, Siamese links on. Call me 2 Chainz, name no ding dong. Bitch, just King Kong, yes, I'm King Kong. This is King Kong, yes, Miss King Kong. In my kingdom with my Timbs on.
How many championships?
What? 6
6
rings on.
rings on, baby. Hold on, let me. Oh Lord, I just got some more paper. Hold on for a minute, I just got something else. Here there, y'all. Hold on. Where do I go at? Oh, they gonna have to let Lil Durk out now. They can't be locking up everybody. They just lock them up. Hold on, let me see what this is.
Now this the hot shit. Jimmy Snooker off the top rope, super fly shit. I get in the tub with all my ice on some pop shit. Either way, you set the bottom line on the top, bitch. You should know I rock it, twisted, it ain't even out yet. For the jury at the grocery store, I'm obnoxious. For the home and closing on another, I know I'm blessed. Everybody wanna be gang,
Ain't no spots left.
bad bitch contest, it wouldn't be a contest.
Ooh, smoking dope.
I'm connected. I don't know what's longer, man. My blacklist on my checklist. I don't know what's colder, man. My heart on my
my necklace. Pretty when I wake up, I'm a bad bitch. At
Breakfast,
do my
slide on the op. Hating didn't work, so they lied. Hey,
These bitches looking hurt and they
right.
I know they wouldn't
Listen, if they die, I said,
ooh, 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 new Chanel on
hey,
my body.
hey.
Ooh, some so poppin', I don't ever gotta get introduced. One thing I never call a bitch for is the truth. Can't wait to get that bitch with you. Ooh, checks coming fast, sound like swoosh. Ooh, get him to the straight, 100 proof. I know that killed you hoes before, it must be deja vu. It's either that or I'm catching body
This that pop music.
Come on,
This that
Dirk.
drop location, drop a op music. This ain't for them niggas in the house. This shit for Glock you. And don't talk down on trenches hoes who known to be a cock you. This that pill talk. Gotta bust his head, he cut on op music. Who said you game? Who said you could come around this bitch and hang? And I fucked your baby mama, and they ain't said a thing. Came outside in 2020, pull up in that 21. I pick my side, switches fully, and I'ma die for 21. I got plenty cars, I hit plenty stars, and then it come. I said it plenty times, I pay for bodies, I ain't pay for none. You think I'm finna leave my bitch for you? She fucked you too. I know that Vaughn hit her, she put up on my block and Jimmy Choo. Schmirk.
Ooh, checks coming fast, sound like swoosh. Ooh, get him to the straight, 100 proof. I know that killed you hoes before, it must be deja vu. It's either that or I'm catching body number 2.
Piggy swear you ain't scared when you heard yeah appear. I'ma hop about the bushes, me and Pusha kill your man. I'm just saying now I start to get used to the pain. Till one day I said, fuck it, bro, mama suits on the plane. Why you playing? Reaching the game, losing hand. Where you stand? Where was Shay at? Where was them at? Where you done that? Where you live at? Another headline, where you had at? Nigga, go home, where your kids at? They be on my nerve, they be on my nerve. When we lost Verge, I was on the verge. I just hit the Louis store, had to spurge. We just made a silent movie with no words. Guess who topping now? God got me now. Guess who at Balenciaga? Guess who shopping now? They can stop me now. I've been popping now. Cardi, where your sister at? I need Henny now. I flew in and out, 150,000. Now even when they shout, gotta shout me out. So ahead, go ahead. Not even close. All of y'all is number 2.
Ooh, checks coming fast, sound like swoosh. Ooh, get him to the straight, 100 proof. I know that killed you hoes before, it must be deja vu. It's either that or I'm catching body number 2.
Yeah, 1 minute. Wait a minute.
There's a lot of drama between you and your beautiful wife, Cardi B. Let's talk about some
We're not going to listen to that. All right. I am done. Okay. Oh, I got the email. Oh, shit.
Okay.
I'm coming, y'all. I promise.
Yeah. Look, me versus you and you know they pick it. Cheap and expensive, you know the difference. You know that it's hitting, you know what it's giving. Hair, nails, on a bear. I could survive in the coldest conditions. Hoes better know they tone when they spin. Bitches is washed, soap in the dishes. I apply pressure like ball constrictors. One bitch, two bitch, old bitch, new bitch. None of y'all bitches not gon' do shit. I'm in Miami, I'm on up on cruise ship. You in Miami for also room shit. When I step a stampede, put on neck, can't breathe.
They ain't gonna hit my pod.
Diamonds on, I see my
I'm
eyes.
slicking up.
I'm like, what in the fuck? If you scared, then just say that whole enough is enough. There was just in my DMs, ain't no trust in these
Come on, y'all hit my pod. I remixed it.
If you
I'm slicking up. I'm slicking up. I'm slicking up. Hey.
is enough. There was just in my DMs, ain't no trust in these sluts. I'm about to call up Diamond, bitch. Not if you buck. I'm like, ooh, child, cool down, too hot, too wild, new clear, new style. How you fucking with me? Give me one shot and I'm raising the glass. Give me 2 shots and I'm shaking this ass. Give me 3 shots and I'm ready to fuck. 5, 4 shots and be ready to splash. To me, so I gotta pop it. I'm sending on business, I'm ready about it. Bitch, keep talking, I be big in they pocket. Girl,
Tell me about
I'm
it.
litty, I'm pretty, I'm running the city. I'm shitting on bitches in every department. This ass heavy, thick like peanut butter. Bitches jelly about it. Got a lot of winning, a lot of scoring.
Hey.
Cardi Brian, Cardi Jordan.
Hey.
These bitches all losers.
Hey.
Can't do it's not important. Look, hey, I'm getting better and better.
Better.
I do not see no competitor.
Better.
You know the gang hit that pussy. Said it was
Better. Better.
everybody can see me in fashion, can see me with money. These bitches is bugging. Either these bitches blind or I'm invisible. Bitch can see me at night. When I hop out with stampede, put on neck, can't breathe. Lucky charm, bang.
Here go my part.
I see my
I'm
teeth.
slicking up.
I'm like, what in the fuck? If you scared, then just say that whole enough is enough. They was just in my DMs, ain't no trust in these sluts. I'm about to call up Diamond, bitch. No, if you
Slicking up. Slicking up. Slicking up. Hey.
is enough. They was just in my DMs, ain't no trust in these sluts. I'm about to call up Diamond, bitch. No, if you fuck.
Yes, honey. Yes. Okay. Enough of the foolish men. Okay. Let me save this over here. Sorry, y'all. It's the paperwork flying in like a plane, child. Okay. All right. All right. Let me put that up here. Here. Okay, y'all, honey. Let me. Pull this stuff up. Oh, Caitlin Collins. Oh, Lord. She going to be over there at the White House. Yes, honey. Today, this is your YouTube Jasmine Crockett, baby. How y'all doing? What is up? What's up, home team? Listen, we got a lot to get. These people still going back and forth, child. This Diddy mess. It's crazy. I just don't get it. I mean, I get it, but I just don't get it. Like, come on. Mm, That's the 22nd. Yes, man. Yeah. Do y'all want to hear? I'll tumble for you. I'll tumble for you. I'll tumble for you. I'll tumble for you. That just came in my head. I gotta give you. You have so much shit in your head. Yes, child. Yes. I think when you have a big brain, I think you can do that. Oh, I got to put up a poll, honey. I'll put on the poll, everybody on this side. This is crazy with this Drake crap. Hold on. What? Supposed to have this up. Yeah, I see y'all. I have an interesting poll over him by Drake. I am just curious to see what y'all feel about it because this is some ridiculousness. This is some ridiculousness, baby. Let me finish pulling up this paperwork. It's 87. Where's that at? Okay, so I need 90 and 91. I got it. Listen, y'all. Ninety. And my heart started beating triple time. Why? I can't figure out just what to do. Cause you, with you, I get so funny. Honestly, funny. Something is so funny. Won't you just stay with me? Nobody knocks me out of the and it's funny why you're not next to me. I try hard. Okay, now we're gonna put on Sarah the Rita. Let her talk, y'all. Let me tell you something so funny, y'all. Cause Sarah just starts to read, honey, and I don't know how to. It's the reader that comes with the system, and it's generic, right? So like you can't stop it where it is or whatever. I don't know what kind of reader these people be using, where it can stop and whatever. And I don't know how to implement no darn AI on no reader and stuff. Cause they got that type of stuff too, where you can put it on the paperwork and whatever, and it's AI. I don't know how to use all that. But let me tell you what's so funny, y'all. So anybody know, when you be pulling paperwork. Of course, R. Kelly is our main split, right? So I'm gonna check that every day because we still waiting on what the people gonna say. Now I told you, like after 6 months, this is generally how it goes, right? After 6 months, as an attorney, you can assume that they denied it, and you just move on about your business. I think that's how it goes. But is that Supreme? Wait, what court is that? Yeah, Supreme, right? No, what step is he on? Appellate court. I think it's right. I think that's right. I think it's 6 months. Anyway, it goes on a list, right? And usually, you can assume that they denied it, and you can, I think you can move on, or you can ask the court for permission to move on, right? I'll tell you, appeals, and that's not what I do. Okay, learn about all that, but I think that's how it goes. So I go in to check it, right? I go in to check it because I want to see if there's any updates. Let me tell you what happened. So I went to put in his name and stuff, whatever. I didn't give the computer um the correct information, right? I gave him the correct. Well, I didn't give him the correct identifications and stuff, right? Put it like that. It come giving me a case that was already closed. I went in under attorney, and I was somewhere else. It took me somewhere else, right? And in the attorney's profile, I went in there, and I saw where there was a close date. I just instantly looked at the close date. I didn't look to the left to see who was closed for, right? And when there is a close date, that means that a decision or something done been made. I went to Honda. Order came in. Yeah. I said, oh shit, that ain't, oh man, I'm in the wrong thing, baby. I'm trying to tell you, your girl's still a little, I'm trying to get knocked the rust off, but still. And I said, let me check. I got went and did it right. I said, oh hell, it's still open. Damn. Oh boy, I got happy. Ooh, I got happy. I was like, oh, we got it. It's me. This is we too old, y'all. I was so happy. I was so happy. I said, yes, Lord, I'm finna break it. I'm finna read it. I'm finna read it. I just want to know what's gonna happen. Shit, whatever. Now Mo said I have no idea where she is. Okay, but hey, we got to continue. Now, where's my read aloud? I wonder if I can find me a read aloud that I can.
November 25th, 2024. Via ECF. Honorable Arun Subramanian, United States District Judge, Southern District of New York, 500, Pearl Street North, New York, New York, 10007. Re. United States v. Combs, 24 CR 542, S. Dear Judge Subramanian, Defendant Sean Combs respectfully submits this letter in response to the court's request at the November 22, 2024 hearing for further briefing on the contours of the types of communications that Mr. Combs is able to engage in, consistent with this court's order and Rule 23.1, and the First and Sixth Amendments. TR.62. For months and months, government agents, plaintiffs' attorneys, and others with questionable motives have been polluting the airwaves with false and outrageous claims about Mr. Combs. This non-stop drumbeat of negative publicity has destroyed his reputation and will make it virtually impossible for him to receive a fair trial. Mr. Combs is not required to sit idly by and acquiesce to all of this. He has a right to a fair trial and a constitutional right to speak out on his own behalf. The government's arguments that asking his children to post birthday wishes on Instagram and that he is not entitled to publicly express his opinion that this prosecution is racially motivated are, quite simply, an unconstitutional effort to silence him. Mr. Combs sought only to stop a wave of publicity he perceived as prejudicing potential jurors and injuring his reputation in the community. Gentile v. State Bar of Nevada, 501 U.S. 1030, 1043, 1991, plurality opinion. His communications directed at the public are protected speech under the First Amendment and cannot justify denying bail or indeed preventing him from engaging in constitutionally protected public relations efforts, so long as they comport with the carefully tailored legal limits imposed by the controlling authorities described below. Mr. Combs' communications regarding potential public statements and social media posts constitute speech protected by the First Amendment. The most demanding scrutiny applies when deciding the issue. In United States v. Trump, the D.C. Circuit assumed without deciding that the most demanding scrutiny applies to pretrial speech restrictions on criminal defendants, and that Case 1:24 CR 00542 as Document 85 filed November 25, 24 page 1 of 8. Honorable Arun Subramanian November 25, 2024. 2. Only a significant and imminent threat to the administration of criminal justice will support restricting a defendant's speech. 88F.4th 990, 1008, D.C. Sir 2023. The court considered but rejected application of the less exacting substantial likelihood of material prejudice standard articulated in Gentile v. State Bar of Nevada, which considered a professional disciplinary sanction on a criminal defense lawyer pursuant to an ethical rule. Gentile's standard relied in part on lawyers' special duties and roles as officers of the court, c. 501 U.S. at 1066 1074, and the Supreme Court has never decided what standard of review applies to a criminal defendant's own speech. Because Mr. Combs is a criminal defendant and is presumed to be innocent, he has a greater constitutional claim than other trial participants, including counsel, to criticize and speak out against the prosecution and the criminal trial process that seek to take away his liberty. Trump, 88F.4th at 1008. Accordingly, the court should apply Trump's heightened standard when considering Mr. Combs' speech here. For the same reasons, Local Criminal Rule 23.1, and this court's gag order, which employs the substantial likelihood formulation, is only enforceable to the extent it withstands Trump's higher level of scrutiny with respect to the speech at issue, although, to be clear, as explained at the November 22 hearing and infra, the communications at issue would not violate the court's order or the local rule anyway. Point 1. To the extent the government disagrees as to the standard, it is no response to rely on Gentile's observation that the speech of those participating before the courts could be limited because of a supposed distinction between participants in the litigation and strangers to it. 501 U.S. 1072-73. This argument is most apt when applied to those who voluntarily invoke the court's jurisdiction. But defendants are involuntarily present and thus cannot be said to consent to a restriction on their speech. Erwin Chemerinsky, lawyers have free speech rights, too. Why gag orders on trial participants are almost always unconstitutional. 17 Lloyd. L.A. End. LJ 311, 324 N.89, 1997. Indeed, a criminal defendant awaiting trial in a controversial case has the full power of the government arrayed against him and the full spotlight of media attention focused upon him. United States v. Ford, 830 F.2d 596, 599, 6th Sir 1987. B. The government must satisfy a heavy burden. The Second Circuit has held that, per se, proscriptions of certain types of speech in the trial context are overbroad and violate the First Amendment. United States v. Cutler, 58 F.3d 825, 835, 2d Sir 1995. Thus, when enforcing rules such as Local Criminal Rule 23.1, the court must examine the specific speech in light of the record evidence to determine if it risks undermining a fair trial. ID 2 Local Criminal Rule 23.1 D. S. General Categories of Presumptively. 1. In United States v. Ford, the Sixth Circuit applied an even more exacting clear and present danger test to a gag order on a criminal defendant. 830 F.2d 596, 598, 6th Sir 1987. Ford found no legitimate reasons for a lower threshold standard for defendants seeking to express themselves. ID. Although Trump rejected Ford, Mr. Combs nevertheless preserves the argument that Ford's standard applies. The court need not decide these issues, however, because Mr. Combs' speech is clearly protected under the less exacting standard articulated in Trump, as well as the even lower substantial likelihood standard.
Wait a minute, I don't know what happened. Please don't tell me that shit stop. Okay, I'm gonna have a fit.
Standard outlined in Gentile. 2. Cutler interpreted a previous iteration of EDNY local rules that proscribe generally any statements by counsel that a reasonable person would expect to be disseminated by means of public communication, in connection with pending or imminent criminal litigation, if there is a reasonable likelihood that such dissemination will interfere with a fair trial or otherwise prejudice the due administration of justice. 58 F.3d at 835. That standard restricted even more speech than the substantial likelihood language used in current Local Criminal Rule 23.1 in the court's gag order, and is unconstitutional under Trump. Case 1:24 CR 00542 as Document 85 filed November 25, 24 page 2 of 8. Honorable Arun Subramanian November 25, 2024. 3. Prejudicial speech are not dispositive of the question. CID regardless, as explained at the November 22 hearing and further infra, the communications at issue do not violate the rule. The party seeking to justify a speech restriction bears the heavy burden of demonstrating, in advance of trial, that without prior restraint a fair trial will be denied. Nebraska Press Association v. Stewart, 427 U.S. 539, 569, 1976. The record must show the specific words have an extraordinary power to undermine or destroy the efficacy of the criminal justice system. Trump, 88 F.4th at 1013, quoting Gentile, 501 U.S. at 1075. It must establish the imminence and magnitude, as well as the high likelihood, of harm to the court's core duty to ensure the fair and orderly conduct of a criminal trial and its truth-finding function. Trump, 88 F.4th at 1016. The court's findings must appropriately be grounded both in record facts and common human experience. ID at 1014, quoting Nebraska Press Association, 427 U.S. at 563. Where risk of prejudicing the jury pool is at issue, the record must establish a nexus between the speech and the potential for prejudice to the jury. Venire. Marceau v. Lafayette City PAR. Consolidate Government, 731 F.3d 488, 494, 5th Sir 2013. In making these determinations, the court should consider such factors as the speech's phrasing, timing, setting, and meaning. Trump, 88 F.4th at 1027, see also Marceau, 731 F.3d at 494 and .4, considering timing, Gentile, 501 U.S. at 1044, explaining that exposure to information concerning a case 6 months before trial is less likely to result in prejudice because it will fade from memory long before the trial date. The court should also consider the forms of media at issue and their circulation, as the mere presence of extrajudicial comments in some forms of media does not, by itself, establish the potential for prejudice of the jury. Venire without a more thorough examination of that potential. Marceau, 731 F.3d at 494 and .4, United States v. Brown, No. CR 23-00090 Psalm 2024 WL 166862 at *5 D Hawk. January 16, 2024. No restriction justified in part because there has been no showing of what percentage of the jury pool even reads any news outlet or other source through which prospective jurors might be exposed to pretrial publicity. See, the speech at issue does not risk undermining a fair trial. The government's cited examples of Mr. Combs' speech do not even come close to the side of the line that's improper illegal conduct. TR.15 Rather, the examples concern core protected speech. The government argues that Mr. Combs' children's social media posts showing them gathered to celebrate his birthday evidence obstruction and violate this court's gag order. DKT.69 at 19 to 20. The government further argues that statements that Mr. Combs is a revolutionary and that the prosecution is racist could be obstructive. While the government conceded that a PR campaign or a marketing strategy is unobjectionable, it claims the speech is punishable here because Mr. Combs made comments such as wanting to reach for this jury. I just need one. TR.15. In other words, the government argues it is the defendant's stated intent that he wants to influence the jury that is problematic. TR.16. The cited examples do not even remotely implicate the types of possibly prejudicial speech that courts have previously considered. This is not speech about witness testimony or cooperation that imperils the availability, content, and integrity of witness testimony. Trump. Case 1:24 CR 00542 as Document 85 filed November 25, 24 page 3 of 8. Honorable Arun Subramanian November 25, 2024. 4. 88F.4th at 1013. Nor does the speech target known or reasonably foreseeable witnesses concerning their potential participation in the criminal proceeding. ID at 1012, CF United States v. Bankman-Fried, No. 23-6914 CR, 2D Sir 2023, DKT.32.1, affirming order revoking bail because speech to commit a criminal offense such as witness tampering, which requires proof of persuasion that is corrupt, falls outside the zone of constitutional protection. Mr. Combs did not make public statements in an attempt to discredit testimony for the prosecution or make evidence available to the news media. Shepard B. Maxwell, 384 U.S. 333, 359-60, 1966. The speech does not concern any attempt to publish court-ordered discovery. Gentile, 501 U.S. at 1073, discussing Seattle Times Covey Reinhardt, 467 U.S. 20, 1984. And this is not a case where the party's expression was itself obstructive. Trump, 88F.4th at 1015. Nor does the speech involve other sensitive considerations that have justified restrictions, such as the publishing of minor victims' images or content likely to inflict public ridicule and embarrassment on victims. United States v. Terranova, No. 23 CR 516, Kim, 2024 WL 429, 5508, at *16, EDNY September 26, 2024. Moreover, the speech at issue does not come near any of Local Criminal Rule 23.1, d*s categories of presumptively prejudicial speech. It does not concern IN formation, likely to be inadmissible at trial. Rule 23.1, d*6, see also Shepard, 384 U.S. at 360, discussing risk of information disseminated. That was clearly inadmissible at trial. Nor does it concern the identity, testimony, or credibility of prospective witnesses. Rule 23.1, d*4. Point 3 and it falls far short of any type of threat likely to risk prejudicing the trial. See Trump, 88F.4th at 1010. Mr. Trump issued a warning, if you go after me, I'm coming after you, and targeted grand jury witness by stating he shouldn't testify, that he was a failure, and a loser. Mr. Combs' speech falls on the opposite side of the line and is clearly protected. Anticipated speech about being a revolutionary or about a racist prosecution involves thoughts that this prosecution is politically motivated or that he is innocent of the charges against him. Core protected speech. Trump, 88F.4th at 1028. Indeed, criticizing the Department of Justice and the prosecutors is not proscribed. ID. To the contrary, see criticism of government is at the very center of the constitutionally protected area of free discussion. Rosenblatt v. Baer, 383 U.S. 75, 85, 1966. Mr. Combs' anticipated words were directed at public officials and their conduct in office. There is no question that speech critical of the exercise of the state's power lies at the very center of the First Amendment. Gentile, 501 U.S. At 1034, plurality opinion. The plurality opinion in Gentile is further instructive on this point. The plurality concluded that statements that the state sought the indictment and conviction of an innocent man as a scapegoat, likening the police department to crooked cops, did not demonstrate any real or specific threat to the legal process. 501 U.S. at 1034, 1058. Rather, the plurality concluded such statements have the full protection of the First Amendment. ID at 1058. Such criticism questions the judgment of a public prosecutor, and because or 3 to the extent Local Criminal Rule 23.1, d. 7, proscribes a New York opinion as to the accused's guilt or innocence or as to the merits of the case or the evidence in the case, that is clearly too restrictive when applied to a defendant's own statements. See, example Trump, 88F.4th at 999. Noting that district court's order did not prohibit asserting that defendant is innocent of the charges against him. Case 1:24 CR 00542 as document 85 filed November 25, 24 page 4 of 8. Honorable Arun Subramanian November 25, 2024. 5. System grants prosecutors vast discretion at all stages of the criminal process. The public has an interest in its responsible exercise. ID at 1036. As for Mr. Combs' children's birthday wishes, that message was entirely innocuous, for it could not possibly produce an interference that is material. Trump, 88F.4th at 1027. Nor was the message made with the knowledge that such interference is highly likely to result, or made intending to delay or obstruct the justice process. ID. It is no response to cite Mr. Combs' subjective hope that his birthday message would reach the public, including potential jurors. Mr. Combs' reputation is drowning in a sea of negative publicity prompted by the government's prosecution here as well as dozens of civil suits, and he is free to defend himself in the court of public opinion, which is all the statements cited by the government evidence. Terranova, 2024 WL 429, 5508. At *16. Indeed, as noted in Mr. Combs' reply, a core assumption underlying Gentile and the First Amendment is that press comment is sometimes necessary to protect the rights of the defendant and to defend his reputation, because a defense does not begin inside the courtroom door and one cannot ignore the practical implications of a legal proceeding for the accused. 501 U.S. at 1042-43, 1058, plurality opinion. Even in a case where the speech at issue directly targeted known jurors, the Second Circuit did not uphold restrictions on the speech. See United States v. Quattroni, 402 F.3d 304, 312, 2d Sir 2005. Finding order prohibiting press publication of jurors' names and addresses during pendency of trial to be a prior restraint in violation of the First Amendment. The government is essentially arguing for a standard in which the entire press community and civil plaintiffs and the government itself can wage war against Mr. Combs' reputation, but Mr. Combs can't even try to influence public opinion himself in response. That is simply not the law. D. Less restrictive alternatives to detention adequately mitigate any risk. Even if the speech at issue comes close to the line, which again it doesn't, before deeming it impermissible and punishing Mr. Combs, the court must consider less restrictive alternatives. Alternatives such as searching voir dire and emphatic jury instructions are more than adequate here, and trial courts should resort to these alternatives whenever possible prior to gagging speech. See Nebraska Press Association, 427 U.S. at 563-64. Or, as the Second Circuit has held, each alternative measure must be explored and ultimately rejected as inadequate individually and in combination as a remedy for prejudicial pretrial publicity, because some combination of preventive measures short of a restraining order usually achieves this goal. Application of Dow Jones & Co., Inc., 842 F.2d 603, 611, 2d Sir 1988. With trial still months away, less restrictive alternatives are clearly available to mitigate any purported risk that the cited statements will undermine a fair trial. Brown, 2024 WL 166862. 4. A separate right is also implicated by the birthday posts, for a parent's interest in maintaining a relationship with his or her child is protected by the Due Process Clause and is a fundamental liberty interest. United States v. Myers, 426 F.3d 117, 125, 2d Sir 2005. Case 1:24 CR 00542 as Document 85 filed November 25, 24 page 5 of 8. Honorable Arun Subramanian November 25, 2024. 6. At *3-4, the well-established doctrines on jury selection and the court's inherent management powers provide an alternative, less restrictive, means of ensuring a fair trial. 5. The government's stated rule is overbroad and vague. At the hearing, the government was unable to answer the court's question concerning the meaning of obstruction, and it had no response to the fact that its cited obstruction precedents are clearly distinguishable here. CTR Point 28, discussing United States v. LaFontaine, 210 F.3d 125, 2d Sir 2000, and United States v. Gotti, 794 F.2d 773, 2d Sir 1986. Indeed, when asked, the prosecutor said obstruction, I think, it's broad. I don't think it has to be just what fits into the narrow categories of statutes in Title 18, TR Point 14, but failed to cite any authority for its argument, and failed to articulate any clear or ascertainable standard. The government's position invites the court to adopt a test so vague that it fails to give ordinary people fair notice of the conduct it punishes, and so standardless that it invites arbitrary enforcement. Johnson v. United States, 576 U.S. 591, 595, 2015, A Court Sessions v. DeMaya, 584 U.S. 148, 155-56. 2018, it bears emphasis that in Gentile, 5 justices agreed that the Nevada Supreme Court rule at issue was unconstitutionally vague. 501 U.S. at 1082-83, O'Connor, J., concurring. And, in addition to being unconstitutionally vague, the government's proposal would chill otherwise constitutionally protected speech. 2. Mr. Combs' other conduct is protected by the Sixth Amendment. As outlined in Mr. Combs' reply brief, the other communications cited by the government reflect Mr. Combs' efforts to investigate and prepare his defense, including with counsel's participation, nothing more. His intent in requesting contacts with potential witnesses, for example, is clear from the record. I'm telling you, to hook up with my lawyer, because that's not part of our job. I'm not obstructing, no laws, nothing. DKT.69, EXN at 517-530. The statements cited by the government evidence neither an obstructive intent nor actual obstruction. To be clear, if released, Mr. Combs will accept any condition that instructs him to avoid all contact with an alleged victim, and with a potential witness, as permitted by the Bail Reform Act. 18 U.S.C. 3142, C. 1, B, B. In other words, despite having a constitutional right at the end of the day to assist his lawyers in getting witnesses, Mr. Combs will avoid all contact, directly and indirectly other than through counsel, with any persons who may be a victim or witness in the investigation or prosecution. TR.48, see also Trump, 88F.4th at 1010, Mr. Trump, accept as his pretrial release condition that he cannot speak to witnesses in the case about political matters or otherwise. While detained, however, and in the absence of such a condition, the status quo remains that Mr. Combs has a constitutional right to assist his lawyers in reaching out to witnesses. 5. Per the unconstitutional conditions doctrine, the government may not deny a benefit to a person because he exercises a constitutional right. As a corollary, the government cannot condition a benefit on the requirement that a person forego a constitutional right. See, example United States v. Within, 610 F.3d 168, 194, 2d Sir 2010. Denying bail because Mr. Combs exercised his First Amendment freedoms while detained would be an impermissible unconstitutional condition, and the court must first resort to less restrictive alternatives, such as release with robust conditions, and searching voir dire. Case 1:24 CR 00542 as document 85 filed November 25, 24 page 6 of 8. Honorable Arun Subramanian November 25, 2024. 7. United States v. Persico, No. S84, County Route 809, JFK, 1986 WL 3793, at *2, SDNY March 27, 1986. The court is mindful of a pretrial detainee's need to make telephone calls to potential witnesses, CFL CRIMR 23.1, E6, including as an example of a statement that presumptively does not involve a substantial likelihood of prejudice of parties' request for assistance in obtaining evidence. Imposing any limitation on that right while Mr. Combs is detained will significantly hamper his ability to assist defense counsel and impair his defense. See Strickland v. Washington, 466 U.S. 668, 690, 1984.6. *****. For the foregoing reasons and those set forth in Mr. Combs' prior submissions and oral argument, this court should grant bail on the proposed conditions or any other conditions the court deems appropriate. Respectfully submitted. /s/Alexandra A. Shapiro Alexandra A.
Okay. Made it down to the bottom of the page. So this was pretty much is laying out their argument as to why Puffer should get bond, right? I see that they cited a lot of Trump case law in here, so it must mean that there's a precedent set, right? And Trump was successful in those decisions, right? So I see that they cited a whole bunch of Trump. Let me see if there's anything we need to touch on. I was listening, but I wasn't listening. I know. Mr. Combs communication. Okay, and I told you, I keep reminding y'all that Fifth Amendment, that First Amendment, I'm sorry. First Amendment rights. I told you, it is showing up and showing out all through the court system to be used as a defense, right? Whether or not it is legitimate or not, it depends on how you see it. Okay? And again, remember I told you guys that because the law is written so broad, right? And obviously, the ones who constructed majority, especially the amendments, they're no longer here to ask. So interpretations is what they will do if they don't judge, if they don't say that, hey, with regards to the particular circumstance that we're looking at, the language is plain, right? When the language isn't plain and custom fit to a particular situation, and that's when interpretations come in, and they play a big part of our American law. So big that I told you that when it's not statutory law, it is common law. Whenever it's interpreted, okay. Let's see. They say the government must satisfy a heavy burden. They said the Second Circuit has held that per se proscriptions of certain types of speech in the trial context are overbroad and violate the First Amendment. Okay, so that's strange. I just spoke how broad the language of the law is. And again, that's when interpretations are heavily relied upon, right? And I guess this particular case law is dealing with someone who was pro se. And when you agree to be pro se, the court take you through an assessment to see if you understand what that means, right? And understand that, hey, we cannot give you advice, we cannot do this, we cannot do whatever, you're on your own. However, and it's like it's not a fair balance to me, because these people will say they per se, and then of course sometimes they want to get in there and play that game of the sovereign citizen and all that extra shit. And one of the little excuses when it gets down, because in with regards to the law, you're supposed to understand it. All right. So they'll play the little game as a sovereign citizen and say they don't understand, or whatever. Then, because, and what happens is, if they do the I don't understand game through a trial or a decision or something like that, then when it comes upon appeal, they're going to appeal, but I didn't understand. So I don't know, that's not really um, something that I've had the pleasure of dealing with, because a lot of times you see them playing them games when they're trying to get out of paying. When people trying to get out of paying something, right? Taxes, child support, that type of shit. They'll run that sovereign citizen shit, strong man, whatever, all that extra stuff. And they'll play that game because they know that's not a legal defense. And they know a court appointed or a paid attorney isn't fixing to use that as a defense, okay? Because we like our license, right? Can't use that. It's not a legal defense. So what they do is get in there, play the game, and all that, and child. And I call it exploiting the law. A lot of times, and lawyers do it too. Exploit the law. The First Amendment. I believe that at some point that's going to be abused. So let's see what else it says. It says, thus, when enforcing rules such as local criminal rules 23.1, so whatever the local rules. And when they say local rules, now they're talking about not the federal rules I be hollering out, like 403 and all that type of stuff. Talking about the local rules, talking about within the local jurisdiction, right? So it's going to be New York. I don't know if New York is broken down into, yeah, it's probably, I don't, some places have local and, I mean, county and city and state and all that, and then some just have state and feds, okay? So it all depends. But they said local rule 23.1, the court must examine the specific speech in light of the record evidence to determine if it risks undermining a fair trial. Item 2, local criminal rule 23.1D. These general categories of presumptively. Okay, so what's 2? Coder interpreted a previous iteration of EDNY local rules that prescribe generally any statement counsel that a reasonable person would expect to be disseminated by means of post communication in connection with pending or imminent criminal litigation if there's a reasonable likelihood that such dissemination will interfere with a fair trial or otherwise prejudice the due administration of justice. The standard restricted even more speech than the substantial likelihood language used in current local criminal rule 20.1 in the court gag order and is unconstitutional under Trump. Oh, okay, they're saying pretty much what Diddy said did not violate the rule according to this case law Cutler that they used in this particular letter motion. Okay, so the party seeking to justify a speech restriction bears the heavy burden of demonstrating in advance of trial that without prior restraint, a fair trial would be denied. Okay, so they're saying that the government has a heavy burden in proving that restricting Diddy from getting online and doing the happy birthday thing. Remember that was the issue. That it would um, that it would interfere with his trial, right? That it would like I think at issue here is the fact that the influence of a jury in his favor. Okay. So I mean, and I heard another attorney say how they write up their paperwork and just how much stuff they put in it. I mean, they find every case law to put in it. They would want to run Judge Whitaker over there at YSL crazy. They be like, Hey, don't put all that in this hit couple things and let it go. She like to keep it simple, stupid. Mm-mm. Let me see. They're saying the speech does not undermine the trial. Okay, they're saying the government argues that Mr. Combs' children social media posts showing them gathered to celebrate his birthday evidence obstruct and violate the court's gag order. The government further argues that statements that Mr. Combs is a revolutionary and that the prosecution is racist could could be obstructed. While the government conceded that a PR campaign or a marketing strategy is unobjectionable, it claims that the speech is punishable here because Mr. Combs made comments such as wanting to reach for this jury. Oh, okay, I just need one. Lord have mercy. I mean, both of them have a point. Okay, both of them have a point. Okay, they have a point. Let me see what else. Just going through to see if there's anything that needs further explanation. What is this? Let me see what this is. Okay. What is this? I don't think it's Florida. Let me see about New York. That don't make no sense. Okay. So it is in New York. It's a New York law. Like I thought, right? I'll put it in. It says local criminal rule 23.1 in New York has a substantial likelihood language that restricts speech. This means that the rule prohibits the dissemination of information that could interfere with a fair trial or prejudice the administration of justice. Local rules are a set of rules that govern how courts operate, blah, 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 blah. So that is a New York rule. So maybe New York is just broken up into just state and feds. So this is what it is. Okay. Okay. Moreover, the speech at issue does not come near any of the local rules 23.1D's categories of presumptively prejudicial speech. Okay. That's what they say. Okay. So let me see. And they kept referring to that all these decisions were plurality opinions. So, and back in the day, I used to tell well, of course, you want to find case law where the there was a party that that the party that you're citing or the case law that you're citing actually won, right? That's common sense though, but I just want to make sure you know that. And this was done by a plurality of decision, which means that that's the opinion that received like most of the votes or most support. Okay, not all of it, but just most of it. Okay, which is different by calling it a majority. When it's a majority opinion, that means that more than half received it. Okay, like just say, just say if it's 9 judges, 5 out of the 9, that means that that's a majority. With the plurality, it's like just say if you have 9 judges, you have, let me see how to break this up. 4 that agreed. Well, yeah, 4 that agreed. Well, I'll put it like this: you had 5 that agreed. No, no, no. 4 that agreed. 2 that disagreed. Totally disagreed. 2 agreed with the decision. Well, 3 that disagree with the decision, but didn't agree with the rationale behind it. That is what make it plurality, right? Sometimes people get plurality and majority confused. I was just trying to give you some, you know, then when you see it, because sometimes, well, all the time it's going to list like, oh, how many judges agree with the decision. And if you could do it, if you sit up there doing the ad, and you're gonna say, "Well, damn man, that's the majority." No, it's not always. Just not always. Technically, is the majority. If you have the 3 that agreed, I mean that agreed with the decision, but not with the rationale behind it, then that would make it a concurring opinion. They agreed, but with the outcome, they didn't agree with the rationale behind it. Let me go on for confuse you anymore. And again, remember way back in the day, I told you a good motion always gives solutions to the problem, right? They do more than just address it. It gives solutions. All right. You don't wanna leave it up to the judge. You want to kind of guide him in that direction in which you want it to go, as well as provide some support, right, in the way of case law that says, hey, well, this is what happened here in these um, particular cases. This was decision, and we submit that the circumstances here, what's at issue here, is very similar than as what was at issue in these other particular cases, right? Let's see if there's anything else. Okay. So that was from Diddy's attorney. All right. Moving on. What else? So this is 86. So all right. So they are referred to. Response to the court. Okay. So let's hear this. Not good old fashioned see if there's any footnotes to this thing. Let me pull up this particular one. Okay. This is 86. Government. Oh, it's not gonna let. Okay, never mind. I can't pull it up. I'm gonna have this read on. So,
Page 3. My UND. November 25th, 2024. By ECF the Honorable Arun Subramanian, United States District Judge, Southern District of New York, 500, Pearl Street North, New York, New York, 10007. Re. United States v. Sean Combs, 24 CR 542, as. Dear Judge Subramanian, the government respectfully submits this letter in further opposition of the defendant's renewed application for bail and following the November 22, 2024 bail hearing in the above captioned matter. At the hearing, the court requested that the parties address whether the defendant's conduct constituted obstruction for purposes of the Bail Reform Act. In addition, the court ordered the parties to address whether the defendant's conduct violated the court's October 25, 2024 order, the order, and Local Criminal Rule 23.1 and what communications the defendant would properly be able to engage in on a prospective basis. November 22, 2024 TR at 62. For the reasons set forth below, the defendant's conduct both past and present constitutes obstruction, and his recent efforts to influence the jury pool are in violation of Local Criminal Rule 23.1 and in contempt of the very order incorporating that rule that this defendant demanded. The defendant's arguments that any of this conduct is protected by the First Amendment are similarly baseless. Moreover, as detailed in prior hearings and briefly addressed below, The defendant's history of obstructive conduct is part and parcel to his decades-long pattern of violence, which must be considered along with his obstructive conduct to fully assess his dangerousness under the Bail Reform Act. A holistic view of his obstructive and violent conduct that is still happening presently makes clear that there is no way to rebut the applicable presumption of detention in this case. The bail package presented by the defendant does not come close to ensuring the safety of the community, including from the defendant's ongoing efforts to obstruct this case, nor does it adequately protect from risk of flight. For all of these reasons, the defendant's renewed application for bail must be denied. 26, Federal Plaza 37th floor, New York, 10278. U.S. Department of Justice. United States Attorney, Southern District of New York. Case 1:24 CR 00542 as Document 86 filed November 25, 24, page 1 of 13. Page 2. I. The defendant's conduct constitutes obstruction of justice and poses a danger to the community. A. Obstruction. The court asked the parties to address the definition of obstruction in the bail context, under which obstruction of justice has been a traditional ground for pretrial detention by the courts. United States v. LaFontaine, 210 F.3d 125, 134, 2d Sir 2000, concluding that pretrial defendants' attempts to influence witness testimony presented danger to the community that would support detention. While the Bail Reform Act does not define obstruction of justice, district courts have interpreted obstruction in the pretrial detention context broadly to include willful actions that jeopardize the integrity of judicial proceedings. CID, citing cases, point 1. Many of the defendant's obstructive acts, discussed further herein, easily fall within that broad categorization and show a persistent, brazen effort to improperly interfere with this criminal case. Importantly, obstructive behavior supporting pretrial detention need not rise to the level of criminal conduct. See, example United States v. Saribola, number 94 CR 236, CSH, 1997 WL 158366, at *2-3, finding that defendant's threat to a family member, which resulted in revocation of defendant's bail, constituted obstruction of justice because defendant willfully obstructed or impeded the administration of justice. See also United States v. Kwok, 23 CR 118, at 2023 WL 302, 7440, at *4-6, SDNY April 20, 2023, applying preponderance of the evidence standard and finding that defendant posed a risk of future obstruction when he had violated orders of another court, used burner phones, made public accusations about his criminal prosecution, and provided obstructive messages to followers via video and social media posts. And in cases in which obstruction is part of the charged offense conduct like the present case, courts have detained on the basis of risk of future obstruction. See United States v. Hoye, 2014 WL 572,525, at *3. SDNY February 13, 2014, where defendant was charged with conspiracy to suborn perjury related to other counts in the indictment. Court found that strict pretrial supervision and electronic monitoring of the defendant would provide little protection against future obstructive conduct. Here, the defendant's actions fall easily within this definition of obstruction. Indeed, there is significant evidence that the defendant has engaged in multiple acts of obstruction during the time period relevant to the charged offenses and poses a serious risk of continuing obstruction. As set forth below, these acts include multiple acts he took in an effort to stave off the instant criminal charges, as well as acts he continued to undertake even after the indictment was returned in order to dissipate the potential evidence against him. 2. 1. Obstructive conduct is defined broadly in other contexts as well. For example, under the United States sentencing guidelines, obstructive conduct can vary widely in nature, degree of planning, and seriousness, and includes conduct not criminalized by statute. See USSG 3C 1.1, Application Notes 3, 4. 2. Evidence from the charged period is consistent with the defendant's decades-long pattern of obstruction. which the government continues to investigate. For instance, in the defendant's prior 2001 state criminal trial, in which he was acquitted in connection with a New York City nightclub shooting, the defendant's then driver testified that the defendant attempted to bribe him $50,000. Case 1:24 CR 00542 as document 86 filed November 25, 24 page 2 of 13. Page 3. The racketeering conspiracy offense in count 1 alleges acts of obstruction, as set forth in the indictment, see DKT number 1 at 13, C, D, F. In 2016, the defendant bribed security officers with $100,000 in cash to destroy evidence of a brutal assault on a female victim while they were at a Los Angeles hotel for a freak-off. See November 22, 2024 TR at 20. In 2016 the defendant bribed hotel security officers $100,000 to make the original video go away. In doing so, the defendant relied on intermediaries to reach out to security staff and help carry out the cover-up. This act is alleged as part of the bribery racketeering conspiracy predicate. After a victim filed a civil lawsuit in 2023 alleging among other things that the victim's participation in freak-offs was not consensual, the defendant made multiple efforts to interfere with victims and witnesses by feeding those individuals false narratives regarding the defendant's criminal conduct. For instance, the defendant caused intermediaries, former and current security staff to repeatedly call a former employee, Employee 1, who had witnessed firsthand the defendant's abuse of the victim. The intermediaries told Employee 1, in sum and substance, that what she had observed was a normal relationship. Around the same time, and as highlighted at a prior hearing, the defendant recorded 2 phone calls with a different victim, Victim 2, in which the defendant attempted to feed Victim 2 a false narrative regarding Victim 2's involvement in freak-offs, namely that they were consensual. See September 18, 2024 TR at 21 to 22. The defendant has evidently deleted messages between himself and key witnesses, including a grand jury witness and Victim 2 in this criminal case. One of these witnesses is Witness 1, a male commercial sex worker who participated in freak-offs, and received a grand jury subpoena during the investigation. November 15, 2024 Government BR. At 9 to 11. After defense counsel represented unequivocally at the prior bail hearing before Judge Carter that the defendant would not reach out to grand jury witnesses, it became clear that the defendant had done just that. Phone records and electronic evidence shows that the defendant contacted Witness 1 repeatedly leading up to and after his appearance in the grand jury, and then the defendant apparently deleted the messages from his phone. See November 22, 2024 TR at 34. Here were further communications and there were text messages through this entire period, including to state that the weapon used in the incident was his, and did not belong to the defendant. On November 18, 2024, Jamal Barrow, the defendant's former Bad Boy Records protege and his co-defendant in that case, made public statements about taking the fall for the defendant in the incident. Barrow further stated publicly that following public allegations against the defendant contacted him to make sure that, in sum and substance, they were still on the same page. The defendant has denied his involvement in the shooting and has sent a cease and desist letter regarding Barrow's statements. Case 1:24 CR 00542 as document 86 filed November 25, 24 page 3 of 13. Page 4. August 2024, that were deleted. 3 in the lead up to his arrest, the defendant similarly appeared to have deleted messages with Victim 2, including relating to the significant monetary payments he was continuing to provide to Victim 2. While in pretrial detention at the MDC, the defendant has used multiple unauthorized means of communications, which make it difficult or impossible to monitor the defendant's communications. While the government's substantial investigative efforts have identified some accounts that the defendant is improperly using, and the government has obtained and produced those communications, the government has no way of knowing whether there are other POC or Contact Me ASAP accounts the defendant is using of which the government is not aware. Put simply, when the defendant uses other inmates' accounts, his communications are very difficult if not impossible for BOP and the government to track and monitor. Such barriers to monitoring the defendant have real, significant consequences given the defendant's extensive efforts to taint the jury pool from the MDC, even in the communications the government has been able to identify. See November 15, 2024 Government BR at 17 to 21, November 22, 2024 TR at 57 to 60. Even after defense counsel represented that the defendant had stopped using Contact Me ASAP, he has continued to use the Contact Me ASAP account of at least one other inmate, sending messages to a family member as recently as November 24, 2024, see November 22, 2024 TR at 37. With respect to Contact Me ASAP, he stopped using it November 16. While at the MDC, the defendant has instructed family members and third parties to contact multiple potential victims and witnesses. The defendant has provided these instructions to others by using unauthorized means of communication which, as described above, are difficult to monitor and often using coded language. The potential victims and witnesses that the defendant has instructed others to contact include former romantic partners and former employees, most of whom have experienced or witnessed the defendant perpetrate significant violence. At the November 22, 2024 hearing, defense counsel argued that these contacts went through attorneys, however that is simply not the case. For example, the defendant asked a family member to call victim 2. Separately, the defendant had a family member three-way dial a co-conspirator and the defendant and co-conspirator used coded language, discussing a certain who has to now end. 3. Defense counsel stated during the September 18 bail hearing that the defendant did not reach out to grand jury witnesses. I dispute that wholeheartedly. He didn't do it and he wouldn't do it. And he wouldn't do it because he has the sense not to do it and he wouldn't do it because we wouldn't let him do it, you know. September 18, 2024 TR at 42. Then, at the November 22, 2024 hearing, defense counsel conceded about the deleted messages. I don't know the factual answer in response to the court's inquiry regarding the circumstances of these communications. November 22, 2024 TR at 33 to 37. Case 1:24 CR 00542 as document 86 filed November 25, 24 page 4 of 13. Page 5. There was no indication that attorneys were involved in these contacts between victims/witnesses and third parties. See November 15, 2024 Government BR at 17 to 21. While at the MDC, the defendant orchestrated a social media campaign around his birthday for the express purpose of influencing the jury in this criminal case. In the multiple calls leading up to the birthday post, all of which occurred on unauthorized communication channels, the defendant meticulously planned out the post. The video, depicting 6 of the defendant's children singing him happy birthday while speaking to the defendant by phone, was initially posted to the defendant's children's pages, but the defendant was not satisfied that it would reach the correct demographic. The defendant told a family member that he had been tracking the analytics and directed the family member to post the video to his personal page because the defendant's social media followers are. In another call the same day, the defendant talked about the reach of his social media post and said, see November 15, 2024 Government BR at 19 to 20. District courts have detained pretrial defendants on obstruction grounds unless. See Quack, 2023 WL 302-7440, at *4-6, finding the defendant engaged in obstructive conduct warranting pretrial detention when a message posted on one of defendant's social media accounts accused prosecutors of bias. The defendant encouraged followers to harass victims in the case, and defendant previously used burner phones to conceal communications with co-conspirators. United States v. DeGrave, 539 F sub 3D 184, 207-08, DDC 2021, finding the risk of future obstructive behavior. Identified an articulable when defendant deleted messages, asked others to delete messages, and began communicating via encrypted messaging application. At the November 22, 2024 hearing, the defendant attempted to distinguish his own obstructive conduct from more violent examples of witness tampering. See November 22, 2024 TR at 28. These distinctions are unavailing. The defendant is charged with leading and founding a racketeering enterprise that on numerous occasions committed acts of violence including trafficking, kidnapping, and arson. Some of these acts were done by the defendant and others were done by his intermediaries acting at his direction. Any obstruction or tampering by the defendant must be viewed through the lens of that underlying violent conduct, as well as the lens of the defendant's enormous influence and power. Moreover, the Second Circuit has explicitly noted that both violent and nonviolent witness tampering supports detention on the basis of potential obstruction. LaFontaine, 210 F.3d at 132, W. Witness tampering by either violent or nonviolent means has supported detention or revocation of bail. Likewise, other courts in this district have rejected arguments like those advanced by the defendant relating to public relations strategies built on discrediting witnesses and improperly influencing prospective jurors. In the context of bail revocation, Judge Kaplan found that a similar pattern of obstructive conduct warranted detention in United States v. Samuel Bankman-Fried, S. 522 CR 673, LAC, SDNY. That case is instructive because unlike here, the defendant was charged with a nonviolent crime specifically perpetrating a multi-billion-dollar fraud related to Case 1:24 CR 00542 as Document 86 filed November 25, 24 page 5 of 13. Page 6. His operation of cryptocurrency companies that he founded and controlled and was initially released on a $250 million personal recognizance bond, subject to conditions, including home detention. DKT 224, August 11, 2023 TR, at 25 to 26. However, after the defendant, I, reached out to a witness on an encrypted messaging service, 2, used a VPN, which prevented the government or pretrial services from obtaining evidence of the websites he accessed, and 3, funneled diary entries of a key cooperator to the press, the government moved to revoke bail. See DKT No. 184, the court agreed with the government on the basis of the defendant's obstruction, finding that no condition or combination of conditions would assure the safety of the community and the consequences of witness tampering. DKT 224, August 11, 2023 TR, at 38.4 the court rejected the defendant's alternative proposal, a gag order on communications with the press, finding that it was not a workable solution longer term, particularly with someone who has shown a willingness and desire to risk crossing the line in an effort to get right up to it, no matter where the line is. ID.AT 38 to 39. Finally, it cannot be ignored that the defendant's proclivity for obstruction appears to have continued as recently as last week in court, when it appeared that the defendant provided falsified documents to the court during a hearing convened to address his accusations of government misconduct. At the November 19, 2024 conference, defense counsel represented the following about the condition of the defendant's legal notepads prior to the notepads being photographed during the MDC sweep. On top of the legal pad he's handwritten in blue handwriting the word legal. All these legal pads say legal. November 19, 2024 TR at 34, see also ID at 42, T-hat page was in a legal pad and at the top of the legal pad it was marked as legal. Days later, in response to the court's order dated November 20, 2022, see DKT number 77, defense counsel admitted that the word legal was written on the notepads after the notepads were photographed during the MDC sweep. Now, there is a photo of a legal pad that was in the materials that the government gave us, whatever it was, earlier this week, that does not have legal on it. So it has to be the case that as of the day of the search, November 1st of this year, that legal wasn't written on every legal pad. November 22nd, 2024 TR at 4. The inference is clear, after the BOP sweep, the defendant wrote legal on the top of at least one legal pad to support his argument that the materials in the legal pads were privileged. This continued obstruction while he had a pending bail motion, no less should certainly be viewed in the context of all the defendant's other acts of obstruction for purposes of this bail determination. For in that case, the government moved under 18 U.S.C. 3148, arguing that there was probable cause to believe that the defendant had committed a new criminal offense, witness tampering, while on bail. The district court agreed, which decision was affirmed by the Second Circuit. See Note 23 to 6914, 2D Serb. Case 1:24 CR 00542 as Document 86 filed November 25, 24, page 6 of 13. Page 7. B. Dangerousness. While there is ample evidence based on the defendant's obstruction alone to deny the defendant's motion for bail, the defendant's conduct in this case must also be viewed in the context of his overall dangerousness. In contrast to many of the cases cited above, there is a statutory presumption in favor of detention, given that the defendant here is charged with sex trafficking, and it is thus presumed that no condition or combination of conditions will reasonably assure the appearance of the person and the safety of the community. See 18 U.S.C. 3142, E. 3d. In addition, the defendant is also charged with participating in a racketeering conspiracy as the leader of a violent enterprise that exists to protect his reputation and carry out his will. That enterprise enabled him and assisted him in carrying out both premeditated and spontaneous acts of violence against numerous victims, including kidnappings, assaults, arson, and sexual violence. The defendant and other enterprise members carried and brandished firearms, including when the defendant kidnapped a former employee at gunpoint. Over the years, the defendant's physical and sexual abuse has taken many forms, often in the context of long-term romantic relationships. Throughout, there was a common theme: the defendant repeatedly and consistently forced and coerced women to satisfy his sexual desires. Often behind closed doors, the defendant engaged in acts of violence against women, including throwing them to the ground, dragging them by their hair, kicking, shoving, punching, and slapping them. He manipulated, coerced, and extorted women, including by plying them with drugs, threatening to withhold financial support, and threatening to disseminate sex tapes that the defendant had made of their sexual encounters. He intimidated women, including by displaying firearms, threatening them, showing up at their homes unannounced, and attempting to beat down the door on one occasion with a hammer. Beyond his romantic partners, the defendant also physically abused his personal staff. Former staff members have described the defendant threatening to kill them, throwing objects at them, and being struck, punched, and shoved by the defendant, and seeing him do the same to others. This significant history of violence must be taken into account when viewing the defendant's obstructive activity. Taken together, there can be no doubt that the government has proven the defendant's dangerousness by clear and convincing evidence. 2. The defendant's conduct violates Local Criminal Rule 23.1 and the court's order. The court also asked the parties to clarify whether the defendant's conduct, specifically his recent efforts to influence the jury pool through an orchestrated social media campaign, is in violation of Local Criminal Rule 23.1 and/or this court's gag order incorporating the obligations of the rule that was imposed at the defendant's own request. As set forth below, it is both a local rule violation and contempt of this court's order. See 18 U.S.C. 401, 402. A. The court's October 2024 order and Local Criminal Rule 23.1. On October 25, 2024, at the defendant's request, the court entered the order requiring, among other things, for the government, defense counsel, and the defendant himself to comply. Case 1:24 CR 00542 as Document 86 filed November 25, 24, page 7 of 13. Page 8. With Local Criminal Rule 23.1. See DKT number 50 at 2. Under Local Criminal Rule 23.1, a. Parties are prohibited from releasing or authorizing the release of non-public information or opinion which a reasonable person would expect to be disseminated by means of public communication, in connection with pending or imminent criminal litigation with which they are associated, if there is a substantial likelihood that such dissemination will interfere with a fair trial or otherwise prejudice the due administration of justice. The local rule lists several examples that presumptively involve a substantial likelihood that their public dissemination will interfere with a fair trial or otherwise prejudice the due administration of justice. See Local CRIMR 23.1 D. These include any statements regarding the character or reputation of the accused. See Local CRIMR 23.1 D. 1. And any statements regarding information that is likely to be inadmissible at trial and would, if disclosed, create a substantial likelihood of prejudicing an impartial trial. See Local CRIMR 23.1 D. 6. B. The defendant's social media post violates Local Rule 23.1 and the court's order. Within 2 weeks of the court's order, the defendant instructed a family member to create the birthday social media post, directing them to ensure that it's that and is it. On November 4th, the defendant's birthday, the social media post went live on the defendant's children's accounts. As described above, the post depicted 6 of the defendant's children singing him happy birthday while speaking to the defendant by phone. Then the defendant had it posted to his own account for the explicit reason that he wanted to better taint the jury pool. He informed the family member. The defendant's intent could not be clearer. He expressly wanted to interfere with the jury pool in this case through a targeted, public, social media post, and he caused his family members to make the post. The statement, even if also arguably part of a public relations campaign, is squarely prohibited by the court's order and Local Criminal Rule 23.1. The post falls comfortably within Local Rule 23.1 D. 1, which prohibits the defendant from releasing statements regarding his character or reputation, and Local Criminal Rule 23.1 D. 6, because it relies on information inadmissible at trial, namely the defendant's family circumstances. See example United States v. Battaglia, No. S905 CR 774, KMW, 2008 WL 144826, at *3, SDNY January 15, 2008, precluding evidence of defendant's family and personal status as not relevant to the issue of whether defendant committed the crimes charged. And even if it did not fall into any of the presumptively prejudicial categories outlined in the rule, a public statement expressly designed to interfere with a fair trial can be presumed to violate the rule. See limitations on prospective statements by the defendant. The court also directed the parties to provide guidance as to the parameters of future public statements made by the defendant. Here, the court's order sets clear and stringent limitations on the public statements that the defendant may make about the case, prohibiting statements that relate to subject matters that presumptively involve a substantial likelihood that their public dissemination will interfere with a fair trial or otherwise prejudice the due administration of Case 1:24 CR 00542 as Document 86 filed November 25, 24, page 8 of 13. Page 9. Justice, as outlined in Local CRIMR 23.1 D. In accordance with the rule, public statements related to the following, among other things, would be presumptively prohibited: the identity, testimony, or credibility of prospective witnesses. See Local CRIMR 23.1 D. 4. This would include, for example, any public statements identifying witnesses or victims in the case or statements regarding the veracity of those witnesses or victims, including, but not limited to, Victim 1, as defined in the indictment, Victim 2, and Victim 3. Information that is likely to be inadmissible at trial and would, if disclosed, create a substantial likelihood of prejudicing an impartial trial. See Local CRIMR 23.1 D. 6. As discussed above, this includes any information that has no bearing on the defendant's guilt or innocence and may tend to elicit the jury's sympathy, such as statements relating to family background, children, health, age, or any other similar, irrelevant, personal factors. See United States v. Stroming, 838 F. Apex 624, 627, 2D Sir 2021, or statements regarding the conditions of incarceration or potential punishment. See example Shannon v. United States, 512 U.S. 573, 579, 1994, quoting Rogers v. United States, 422 U.S. 35, 40, 1975, United States v. Mustafa, 753 F. Apex 22, 37, 2D Sir 2018. Information regarding the character or reputation of the accused. See local CRIMR 23.1 D1. This would include publicizing information regarding specific good acts that would be inadmissible at trial. See United States v. Rivera, number 13 CR 149, CAM, 2015 WL 172-5991, at *2, EDNY April 15, 2015, precluding evidence of charitable giving. Nevertheless, the defendant is permitted under Local Criminal Rule 23.1 and the court's order to make statements that presumptively do not involve a substantial likelihood that their public dissemination will interfere with a fair trial or otherwise prejudice the due administration of justice as outlined in Local CRIMR 23.1 E. See example Local CRIMR 23.1 E. 4, 5, 7. 3. The defendant's attempts to interfere with his criminal proceeding are not protected by the First Amendment. Finally, the court also asked the parties to address the defendant's First Amendment arguments relating to the gag order that the defendant requested and that was entered on his consent. In short, the First Amendment does not protect his efforts to interfere with this trial or prohibit the application of the order to his statements. It is well established that criminal defendants do not have unlimited rights to speak. United States v. Trump, 88 F.4 th 990, 1007, D.C. Sir 2023, Reggie denied, 2024 WL 252,746, D.C. Sir January 23, 2024. In the context of an ongoing criminal case, a party's First Amendment interest may be outweighed by the constitutional right to a fair trial, permitting a court to proscribe prejudicial extrajudicial statements. See, example Shepard v. Maxwell, 384 U.S. 333, 363, 1966, Gentile v. State Bar of Nevada, 501 U.S. 1030, 1075, 1991, noting that few, if any, interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors, and an outcome affected by extrajudicial statements would violate that fundamental right. As the Trump case makes clear, a criminal defendant does not have a right under the First Amendment or Case 1:24 CR 00542 as Document 86 filed November 25, 24 page 9 of 13. Page 10. The Sixth Amendment to make statements to obtain a trial prejudiced in his favor. ID at 1003, see United States v. Brown, 218 F.3d 415, 424 N.9, 5th Sir 2000, the defendant is entitled to a fair and impartial jury, not a jury whose views have been deliberately manipulated by outside influences to be biased in his or her favor. Citation omitted. Accordingly, courts have on numerous occasions in cases involving substantial pretrial publicity upheld or imposed restrictions on a defendant's speech aimed at influencing witness testimony, either directly or indirectly. See Trump, 88 F.4 th at 1012-13, or where that speech was reasonably likely to interfere with a fair trial or otherwise prejudice the due administration of justice, particularly where the defendant proclaimed a willingness to seize any opportunity to use the press to their full advantage. Brown, 218 F.3d at 429, see also United States v. Simon, 664 F. Sub 780, 795, SDNY 1987, F. Sub Nom. Application of Dow Jones & Co., Inc., 842 F.2d 603, 2d Sir 1988. The defendant's extrajudicial communications in this case are not, as he alleges, classic protected speech. DEF reply, DKT number 80, at 12. Instead, the defendant's explicit attempts to, for example, and establish a narrative about constitute improper efforts to interfere with the integrity of the proceedings, which courts are obligated to protect against. See Shepard, 384 U.S. at 361, Trump, 88 F.4th at 1003. C. Arts must take steps to protect the integrity of the criminal justice process. Each of these comments evinces the defendant's willingness to seize any opportunity to use the press to their full advantage. Brown, 218 F.3d at 429, an attempt to obtain a trial prejudiced in his favor. Trump, 88 F.4th at 1003. These efforts are not protected by the First Amendment. The defendant nevertheless claims that these types of communications are constitutionally protected because they merely represent the defendant's thoughts that his prosecution is politically motivated or that he is innocent of the charges against him, and constitute protected speech. DEF replied at 13. This is untrue. They are part and parcel of the defendant's repeated attempts, in clear contempt of this court's order and in violation of Local Criminal Rule 23.1, to use his family and associates to make public statement to obstruct and subvert the integrity of these criminal proceedings. See Local CRIMR 23.1, D, 6-7. There is nothing constitutionally protected about such speech, and the court does not have to wait to intervene until the defendant has been successful in impacting these proceedings. As the D.C. Circuit stated in Trump, it cannot be true that a court's hands are tied until evidence of direct causation materializes as SU. Proof would be hard to come by, and requiring a court to conduct a mini-trial on that inquiry while readying a high-profile case for trial would itself divert and delay the criminal justice process. 88 F.4th at 1014. The defendant also appears to claim, based on his reliance on United States v. Trump, that he is constitutionally permitted to make public comments that the instant prosecution is politically motivated or that he is innocent of the charges against him, or comments similar in kind. But, while instructive on certain points, the D.C. Circuit's Trump is, in essential ways, inapposite. The court in Trump faced the unique task of balancing the right of a current candidate. Case 1:24 CR 00542 as Document 86 filed November 25, 24, page 10 of 13. Page 11. For the presidency to speak publicly about his charges against the public's right in a fair trial. 5 C. Trump, 88 F.4th at 1002, noting that based on the candidate's position, there was a strong public interest in what he has to say, and the First Amendment has its fullest and most urgent application to speech uttered during a campaign for political office. Those same First Amendment interests are not at stake here. Further, the defendant's comments go well beyond attempts to claim that he is innocent of the charges against him and make clear that he intends to use the press to deliberately manipulate outside influences to be biased in his favor. Brown, 218 F.3d at 424 N.9. Finally, to wiggle out from underneath the gag order that he demanded from this court and consented to be bound by, the defendant now claims that the First Amendment permits him to continue to engage in communications that may prejudice these proceedings as long as the potential jurors are subject to voir dire and he is prevented from speaking directly to witnesses. DEF reply at 13. But the Supreme Court has made clear that courts must take remedial measures that will prevent the prejudice at its inception, not wait until such prejudice may have already materialized at the time of voir dire. Shepard, 384 U.S. at 363, see also United States v. Cutler, 58 F.3d 825, 836, 2 D. Sir 1995, stating that comments may still be improper attempts to prejudice proceedings even if they do not in fact taint the jury pool. In light of the defendant's history of obstruction, this court has an obligation to protect the fairness of this proceeding, including protecting the right of the public to have this trial end in a just judgment. Wade v. Hunter, 336 U.S. 684, 689, 1949. The First Amendment offers no protection for the defendant's intentional efforts to interfere. For the conditions proposed by the defendant fail to ensure the safety of the community or the defendant's appearance in court. For all the reasons stated herein, there are no conditions sufficient to reasonably ensure the safety of the community or the defendant's appearance in court. but to the point about which the court inquired of the government at the November 22, 2024 hearing, see November 22, 2024 TR at 8. The government additionally writes to make clear that the package proposed by the defendant is insufficient in numerous respects. Without any meaningful specifics, the defendant argues that through private security he can turn an apartment in the Upper East Side of Manhattan into a more restrictive environment than the MDC and meet the requirements of the Bail Reform Act. The proposal relies on a private security company to monitor family visits, ensure zero non-lawyer phone or internet usage, and restrict visitation to a pre-approved list. Such a proposal in essence elaborately replicate as the detention facility without the confidence of security such a facility instills. United States v. Gotti, 776 F sub 666, 672, EDNY 1991. But as courts have 5. The defendant also appears to claim that Trump stands for the proposition that a criminal defendant has a greater constitutional claim than other trial participants to criticize and speak out against the prosecution in the criminal trial process that seek to take away his liberty. Def. Reply at 13, quoting Trump, 88F.4th at 1008. But, this overstates the court's holding. Although the court noted in dicta that criminal defendants may very well have a greater constitutional claim than other trial participants to criticize and speak out, it did not decide the issue. Trump, 88F.4th at 1008. Case 1:24 CR 00542 as document 86 filed November 25, 24 page 11 of 13. Page 12. Observed. Security guards are not trained to act as jailer or detectives, and a home is not a secure facility. United States v. Agnello, 101 F sub 2D 108, 114-16, EDNY 2000. More to the point, in this case, private security employed and paid for by the defendant cannot be trusted. Throughout the charged racketeering conspiracy, the defendant has used private security to stash weapons, purchase narcotics, pay commercial sex workers, and tamper with witnesses, among other things. The defendant did so through the racketeering enterprise that he led and controlled, and through which he wields his immense power and influence to cause others to act on his behalf. Private security paid for by the defendant cannot ensure that the defendant will not access contraband communication devices or tamper with witnesses because the defendant has done just that while incarcerated. Further, under the proposed conditions, the defendant would still have access to individuals, such as family members, who could act as his intermediaries, as they do now, smuggle in contraband devices to him, or even bring him drugs. It is simply unreasonable to portend that the defendant would not use whomever he has access to family, security, even legal staff to accomplish his aims. No amount of private monitoring can effectively mitigate this risk. See Agnello, 101 F sub 2D at 114-15, finding 24/7 monitoring by private security to be insufficient where the defendant's activities inside the house will not be observed, nor is it reasonable to believe that the defendant could not evade monitoring by obtaining access to communication devices and employing other methods to carry on criminal activity and to endeavor to obstruct justice. Point 6. The proposed conditions also fall short of sufficiently protecting against future violence and obstruction. Defense counsel claims there is a 0% chance that the defendant would be violent toward someone while out on bail under the proposed conditions. November 22, 2024 TR 25-26. This gross overstatement ignores the realities of the defendant's history, including acts of violence he carried out himself and through those working on his behalf. Unless private security can staunch the defendant's malignant influence over everyone around him, a pattern that has resulted in numerous individuals being physically harmed and threatened for decades, the court cannot have any confidence that the community will be safe with the defendant out on bail, regardless of the presence of a private security company. Likewise, private security will be ineffectual at preventing the defendant from violating his conditions. The defendant has decades of practice at covering up his crimes and shows no signs of stopping. See Supra at 6, discussing apparent falsification of legal pad evidence. This is in addition to all the other rules set by the BOP, the court, and even his own counsel that the defendant has broken and ignored since the recent inception of his criminal case. A promise now that he will abide by the conditions of release is insufficient. See United States v. Lynch, number 20 CR 202, Lab, 2020 WL 214-5363, at *3, SDNY May 5, 2020. He defendant's consistent failure to comply with the most basic condition of supervision ceasing criminal activity shows. 6. The government notes in this regard that following the defendant's identification of Sage Intelligence Group, through its director Herman Weisberg, as a viable private security company for bail at the hearing before Judge Carter, see September 18, 2024 TR at 34, the government learned that Weisberg was already working as a private investigator for the defendant and was contacting witnesses, a fact that was not disclosed by the defense to the court or to the government prior to or at the hearing. Case 1:24 CR 00542 as Document 86 filed November 25, 24 page 12 of 13. Page 13. That he cannot be trusted to abide by conditions of pretrial release no matter how strict. Cf. United States v. Manafort, 897 F.3d 340, 348, D.C. Sir 2018. Affirming district court decision to revoke bail based on its judgment about whether the defendant can be trusted to comply with the court's directives when defendant contributed to an op-ed while under a gag order and repeatedly communicated with potential witnesses, personally and through an intermediary. Finally, the defendant's lawyers and family members do not provide meaningful guardrails to the defendant's conduct. See United States v. Dono, 275 F. Appex 35. 37-38, 2D Sir 2008, finding that assurances by defendant's father to take personal responsibility for the defendant was insufficient to ensure the safety of the community and that pretrial detention was the means chosen by Congress in the Bail Reform Act to protect the community from dangerous defendants. Far from assuring that the defendant will abide by conditions, these parties have enabled the defendant to flout rules while at the MDC. Moreover, defense counsel's blasé attitude toward breaking these rules while simultaneously asking this court to release their client does not give the government any confidence that counsel will be able to police the defendant's conduct with any rigor. Indeed, contrary to representations by counsel just days ago, the defendant has continued to engage in unauthorized communications with family members from the MDC by using another inmate's Contact Me ASAP account as recently as yesterday. The conclusion. For the reasons stated above, and in the government's prior briefing, the defendant's renewed request for bail should be denied. Respectfully submitted. Damian Williams, United States Attorney.
Ooh. That's 86. They are very upset. With the daddy, huh? With daddy. Before I start on the next one, let me see. I can still do this. I think I could. All right, let me see if I can hear this. Okay, that did not work. All right, I'll read this one. So this pretty much says this is from his attorney, Puff Daddy's attorney. It says we respectfully submit this letter on behalf of defendant Sean Combs in response to the government's letter submitted today, which was the one that was just read. So the government's 13-page letter rehashes old arguments, add new arguments, and seeks to supplement the factual record, even though the parties have already provided full briefing, and the court held a lengthy bail hearing on Friday, November 22nd, 2024. The court asked the parties for short letters on very specific legal issue. Mr. Combs' letter responded to the court's request and addressed only that issue. Mr. Combs objects to the government's submission on the extent that it goes beyond responding to the court's specific question and requests that the court not consider any new or repetitive information in the government's letter. In other words, they want the judge to disregard that letter. Now, and because these are letter motions, they can object to the filing of something, but nothing precludes the other side for saying something in a letter that wasn't acts of the court. It just pretty much demonstrates that one side didn't follow the instructions, right? So that's that. I can read this as well. This is also from Agnifilo, Puppy's attorney. It says, Dear Judge Subramanian, whatever his name is, this short letter is in response to the government's letter of yesterday and updates the court on one issue discussed at Friday's conference. Following Friday's conference, the defense located, and it's redacted, it says, this is an important safety measure that better ensures the safety of Mr. Combs, the security detail, and others. We have attached several photographs taken on November 25th of the building. And some redaction. That must be as a photo of the pit, the building. So the security professional is coming to the location on the morning of November 26th to assess the location, including the placing of cameras and other security measures. We have also spoken with pretrial services, which indicated that in the event Mr. Combs is granted release on conditions, it would want to inspect the location prior to Mr. Combs residing there. In regard to the concerns raised by the government, the stringent measures laid out in our bail proposal include, as the court will recall, that Mr. Combs will not have access to a cell phone. Rather, the cell phone will be in the exclusive possession of the security detail, which will keep a written log of all incoming and outgoing calls, text messages, etc. Accordingly, all such communications will be maintained both in a written log and within the phone itself. Without getting into the merits of the government's various allegations, these conditions address them all, while also ensuring that Mr. Combs has full access to his counsel to prepare for trial and to defend the over 30 lawsuits in which he is a defendant. We thank the court for the time and attention is Wait a minute. Attention is has devoted to our application. Well, must be he has devoted to our application, right? Remember, I told you on one of those lives when I was discussing this that I was surprised that they did not go ahead and forward a like a blueprint of the apartment, the building, and all of that, right? To just say, hey, this is gonna be real secure. So now they are addressing the building, right? Just to make sure that the judge feels comfortable with his decision. Of course, again, these filings are meant to be persuasive, okay? And that's what they're trying to do. Um, so, and the next one is the government pretty much saying the government respectfully submit this letter in further response to the court's inquiry during the November 22nd, 2024 bail hearings regarding the applicability of United States versus Bostani um, to the defendant's proposed conditions of release. After reviewing the transcript, the government recognizes that it may have misunderstood the court's initial questions. To clarify, as set forth in the government's opposition briefing and at the hearing, the government is seeking the defendant's detention based on his danger to the community, including the serious risk of obstruction of justice he poses, as well as the defendant's risk of flight. Because the government does not seek detention based only on risk of flight, relying primarily on the defendant's personal wealth. Bostani's holding applies here. The defendant is not permitted to avoid detention by relying on his own financial resources to pay for private jail. The government relies on many other bases besides the defendant's wealth. Conversely, the holding of United States versus Saba, Sab, what is that? Oh, Sabonai, okay, is applicable. The Second Circuit of Bostani clarified Savani applies only in limited circumstances where the defendant is deemed to be a flight risk primarily because of his wealth. The conditions proposed by the defendant are therefore barred under Bostani, as they amount to a two-tiered system, which is precluded under the Bail Reform Act. And that was something that I wanted to do. Look at the conditions under the Bail Reform Act. I don't remember that shit. The government sincerely apologizes for any inadvertent miscommunication to the court in response to your honor's questions at the hearing regarding this issue. So, that's the back and forth. That is the saga of Sean P. Diddy Combs. Give me 1 second, please.
a third bid for bail by P. Diddy and his team, and we'll know the ruling early this week. Will the disgraced rapper be set free from the Brooklyn jail he's recently called home? If that's the case, what would bail for the mega-rich superstar even look like? And where would he go? We're unpacking it all with former prosecutor Melba Pearson, who says Diddy's release could actually happen. And soon. I'm Sierra Gillespie, and this is Law and Crime News. For more than 2 months, 55-year-old Sean Diddy Combs has called Brooklyn's Metropolitan Detention Center home. Since his arrest on September 16th, Diddy's been held without bail on federal charges of racketeering conspiracy, sex trafficking by force, fraud, or coercion, and transportation to engage in prostitution. But it's not for trying on the defense's part. Diddy pleaded not guilty to the federal charges weeks ago, maintaining his innocence and calling for his release. Just last week, Diddy's team formally put in his third bid at this release, asking federal judge Arun Subramanian if their client could be placed on house arrest. All this went down in the Southern District of New York's courthouse in Lower Manhattan, where our very own Elizabeth Milner was in the courtroom. As she reported, the defense originally wanted Diddy to be held on house arrest at his Star Island mansion in Miami, Florida. But Judge Subramanian shot that down quickly, and it was decided if Diddy was granted bail, he'd be staying in New York, specifically on the Upper East Side in a 3-bedroom apartment. If he's granted this bail, it would be to the tune of $50 million, plus some major restrictions on his house arrest. Inside the apartment, there would be 2 live-in guards and another guard downstairs. Diddy wouldn't be allowed any access to phones or the internet unless it was to contact his legal team. On top of all of that, there would be a vetted list of people approved to visit Diddy, including his legal counsel and his family. Diddy's attorney, Mark Agnifilo, said there was a 0% chance that Diddy would be violent if released, and even called this bail package a very, very rigorous set of conditions, more strict even than at MDC jail. This marks Diddy's third attempt at release since his arrest, but the other requests have been denied by other judges. First, Magistrate Judge Robin Tarnowski denied Diddy bail, highlighting his apparent anger issues and history of substance abuse. She also voiced concern about a danger to the community or witness tampering should Diddy be released. After that, Judge Andrew L. Carter denied Diddy's release too, arguing the proposed bail package was insufficient to guarantee the safety of the community or to maintain the integrity of the case. Throughout all of this, the prosecution has opposed Diddy's release, most recently saying he simply cannot be trusted. There's more to this too. Federal prosecutors alleging Diddy has been working to taint the jury pool from inside of jail. In recent filings, they mentioned Diddy's apparent use of other inmates' phone accounts to both conduct calls with people that were not on his approved list of contacts and to avoid being recorded. Prosecutors say Diddy's working to subvert the jury process using social media too, like a recent birthday post he apparently coordinated from behind bars. Judge Subramanian ruled both sides must submit specific Bureau of Prison forms showing what communication forms Diddy is allowed to use. That paperwork was to be submitted by early Monday afternoon. Judge Subramanian's rulings didn't end there, though, also calling for the prosecution to throw out documents collected during a sweep of Diddy's jail cell. The defense says 19 pages worth of notes with legal materials were collected during this search. Prosecutors argued this sweep was already planned even prior to Diddy's arrest and that no privileged information was collected. That was a win for Diddy's team, but will they score another win this week too with his release? Okay, all of you out there multitasking, listen up. If you're out running errands, this one is for you. I have to tell you about this new app, Upside, that gets you cash back on daily essentials. I use it every time I pump gas because it's so easy and it's free. Here's what you do. Download the Upside app and claim an offer for whatever you're buying. Pay as usual, and then just follow the steps on the app to get paid. To find out how much you could earn, click the link in the description to download Upside, or scan the QR code on your screen and use our promo code LCNews to get an extra 25 cents back on every gallon on your first tank of gas. So for some much needed insight, we're turning to former prosecutor Melba Pearson. Melba, it's always great to have you on with us.
Always great to be with you.
All right, so this is Diddy's third try for release for bail. What do you think? Is it going to happen?
I'm a little worried that it might actually happen this go round. Reason being that the judge seemed to be asking more questions about where he's going to be held, what kind of house arrest. There was a discussion about him living during this time period at his mansion in Miami Beach. The judge had an issue with that because there was a dock, so he felt that that could be a way for him to flee and not come back to court. And so now there's more of a discussion of, well, maybe he can stay in his 3-bedroom apartment in New York City. So the fact that they're getting that into the details tells me that the judge is considering it. And so if you're considering it and not dismissing it out of hand like the previous judges did, that tells me that there might be some hope for Diddy's team.
I think you're right in that it seems that the past couple of rulings happened almost instantaneously. We knew that he'd still be back at MDC, but now it's like, oh, the judge is going to think it over for a couple days. So I guess we'll see. But going back to your point about him hoping to live in Miami, in Florida, while he was on house arrest, that was interesting to me that they offered that up as the first choice rather than New York, so close to the courthouse. What do you think the reasoning behind that would have been?
I think a couple things. Number one, it's just a bigger house. So obviously he'd want to be someplace where he'd be comfortable and where it's very familiar to him, and also where he has that base of support. And I think he feels most comfortable in Miami. Of course, in terms of proximity, it would make more sense to be in New York, but also at the same token, that's where he's being tried, and it's not necessarily a happy place for him right now. So in all likelihood, it's a matter of comfort and just having that space, because again, he's going to be on house arrest, meaning he cannot leave the house, period, end of story. The only times you get to leave the house if you're on house arrest is if, let's say, you have to go to work, or you have a doctor's appointment, or if you go to church, and like legit, not that, oh, suddenly I found religion so that I can start going out now that I'm house arrest. You already clearly have been part of a church, home, synagogue, temple, whatever the case may be. You've already been worshiping there on a regular basis. So now they'll let you continue to do so. So of course, Diddy being Diddy, he obviously does not need to go to work like the average human being, and he's likely not going to church. So he's basically not going to be leaving the house at all. And with that being said, you'd likely want to be in a more comfortable surroundings if that is an option for you. And for him, it is an option.
One of the stipulations about this bail package would be, okay, he has to stay in New York on the Upper East Side, but there are also a couple of security guards too that would be live-in, actually up in this apartment with P. Diddy, and another one downstairs, I'm assuming somewhere in the lobby, kind of keeping tabs on the entrance and exit. What would all of that look like?
Well, I mean, this is all going to be basically at Diddy's expense, because it's not going to be New York City Department of Corrections putting corrections officers outside. The general rule when it comes to house arrest is that, basically you're checking in with a probation officer type situation on a regular basis. You may have an ankle monitor, which has GPS that can clearly see if you leave the house. Of course, people try to play with that. That's a separate issue, but generally the GPS is pretty accurate in indicating what your location is. And so this would be him having these guards for his own security and his own peace of mind, which is something he probably generally has anyway. If he was just there, let's say for 2 weeks, I'm sure he would have had a team of security that would be securing the exits and entrances as well as being in the apartment. So I don't see that as being something new just in terms of his house arrest.
The security guards kind of got me thinking, because right now at MDC, obviously there are guards there watching what Diddy's doing. They can kind of monitor him and see what he's up to. In this case, it would be, as you said, the security guards that he hired. Let's say something happens potentially nefarious while Diddy is on this house arrest. Could the prosecution then reach out to these security guards, put them on the stand, and have them testify about what happened?
They absolutely could if they feel the security guards were actually witnesses to something, whether it be witness tampering or something more nefarious. The question is, will the security guards testify? And what would they say? I mean, would they kind of do the code of no snitching and, say, oh, I didn't hear anything, or I must have been in a different room, or whatever the case may be? Or are they going to be forthright and honest with whatever they may have seen? So there's that aspect. But then the other aspect to consider is in terms of the witness tampering, which is where my greatest fear lies, because of the fact that we've already seen his behavior while in custody, where he's doing three-way calls to be able to circumvent the list of people he's not supposed to contact, and being able to basically orchestrate a social media campaign with the goal of tainting the jury, or at least influencing the jury pool, things like that. So with him now out of custody, I would think that behavior would escalate to a higher degree. And so in order for the prosecutors to be able to build a case with regards to witness tampering, the witnesses have to come forward and say, Diddy contacted me, or somebody from Diddy's camp contacted me. Will they? That's a different question. So that's what makes it a little bit more difficult, especially, again, if he's not using his phone, if he's having third parties make these calls, then now it's harder to track those, calls back to him, whether pulling his cell phone records or anything like that. So there's the danger that the court has to balance and consider.
You touched on something really important. This is what the prosecution was talking about all last Friday in their hearing, that they're alleging that Diddy is trying to, from behind bars, taint the jury pool. Again, you mentioned the three-way calls, potentially influencing a social media campaign. Okay, so he's outside of jail. Let's say that he is granted bond. Again, to your point, wouldn't it then be way easier to go about continuing this alleged attempt to taint the jury pool? I mean, how would we make sure that that wasn't happening?
That's the rub, right? That's the rub, because the reality is his family is going to be able to have access to him. And so he can sit down with his family, much like he was doing from behind bars, and tell them, this is the schedule of what you need to post. This is how you need to, act. And you talk about, we miss our dad and all of these things, which it'll be different if they decided on their own to do that. If they were like, as a family, you know what, we want to support our loved one, and this is how we're going to do it. That's completely permissible. When you're behind the scenes trying to orchestrate like a puppet master, that's where we have a problem. And so I think it would be much easier for him to continue what he's doing and even escalate that behavior. So that's something the court really needs to weigh, because we could be in a situation where we're losing federal witnesses or actual survivors because they've been contacted, they've been intimidated, they've been offered money, whatever the case may be. And the Department of Justice may not be aware of what is going on until it's too late and they're trying to call them in to testify as we get closer to trial next year.
I think it does make things even more tricky, because one of the stipulations is he's not allowed to have the phone or be on the internet except to talk to specific people, obviously his defense team, his family, some vetted people that were approved by the judge. So how is the judge going to go through and determine, okay, yes, this is safe. I think that Diddy should be released on bail. How can we 100% be sure he isn't using someone's phone or going online?
We can't. We absolutely can't. So that's the tough decision that judges have to make, is looking at the totality of the circumstances, looking at the person's criminal history, looking at the severity of the crime and who was involved. Is this something, for instance, like a domestic violence type offense, where that there's a relationship between the two people and there's a higher likelihood of tampering, maybe not even by the defendant directly, but by other family members or other people they have in common. So that becomes the huge decision that judges have to make, and they're taking a chance any which way, because you could have the most, innocuous seeming person who has no criminal history, the case is okay against them, and then they get released and either reoffend or do something that helped, would be along the lines of witness tampering or something like that. So a judge basically doesn't have a crystal ball. They can't predict what's going to happen. They're only going to make the best decision they can based on the information they have at the time. And then if new information comes to light in terms of Department of Justice is able to come back and say, okay, so-and-so was contacted on this date, here's a recording of the call or something along those lines, here's the email, here's a letter that I can trace back in some way, shape, or form to Diddy, then absent that, there's not going to be a lot that the court can do.
So if we're looking back at the past 2 times that he was denied bail, one of the judges actually mentioned Diddy's history. Obviously, there are allegations that are pretty severe when we're talking sexual assault, but there's also the Cassie video that shows he could potentially be harmful physically as well. So he could be a danger to himself or others. But then the other judge also mentioned the integrity of the case. So if Diddy was released on bail, this judge ruled that it could compromise the integrity of this case. So what do you think this new judge is going to think, considering all of these things and kind of putting them together?
Yeah, I mean, I'm not quite sure. I'm trying to extrapolate based on the reports and sort of the snippets that have come out of the courtroom in terms of the discussion. But you know, I know that there has been a lot of folks that feel that this was too severe, that, you know, people like, Harvey Weinstein was able to, you know, with these types of severe charges be out of custody. Bill Cosby, severe charges, was out of custody, that he's not a flight risk because of the fact that his face and likeness are so well recognized globally. And so, you know, all of those arguments kind of come into play. But at the same token, we still have to balance harm to the case and harm to the survivors and witnesses. And again, he is somebody who, based on what we've heard about his behavior while incarcerated, as well as his behavior allegedly before he was even caught, that he is well versed in witness tampering and making people keep their mouth shut and finding that pressure point to ensure that they don't tell any dirty secrets that he has. So I would only anticipate he would continue in that vein, because it's not like he learned his lesson in the last couple of weeks, right? This is a lifetime, you know, again, allegedly, but this is a lifetime of him out here manipulating and harming and assaulting and everything else, and just degrading and all of these things. So I don't see that somehow he's suddenly going to have a come to Jesus moment and now not engage in witness tampering. I just don't see it.
You know, something else interesting to me during the hearing on Friday is that Diddy's attorney, Mark Agnifilo, actually said that these are a very, very rigorous set of conditions, and said that this house arrest would be worse than where Diddy is at right now at MDC, which is kind of an infamous jail in Brooklyn for a lot of bad happenings. What do you make of that statement?
Yeah, that's a bridge too far. That's a bridge too far. You're going to tell me that a 3-bedroom, probably penthouse overlooking Manhattan is somehow going to be worse than being in custody in a jail that is noisy, that doesn't smell very great, that the food is awful? Somehow that's better. Now, granted, I will give this aspect. If he is on suicide watch and he is in isolation, that is definitely tough, because you're by yourself in a very small room and that's it, right? And we have seen that that can really affect your mental health. So I will give him on that one point alone. But everything else, he's going to be sleeping in basically his own bed, having his best gourmet meals, and being able to see his family unfettered. He'd be able to hug them, touch them, as opposed to having to see them through glass. So yeah, that argument doesn't hold water for me. Not at all.
It's going to be interesting to see which way the judge does rule. Obviously, all eyes are on the Southern District of New York. Melba, thank you ahead of all of this for breaking it down and giving us some insight into what could happen.
My pleasure.
We can expect to see Judge Submaranian's ruling on Diddy's potential release sometime early this week. For Law and Crime, I'm Sierra Gillespie.
Folks, I am listening to, I was in and out of these,
They want to see a certain amount. Then y'all will have to reel it over and we'll display it in the courtroom. So we can't keep them for a while. No. Mm-mm. No. I mean, they might deliberate for a month and a half. We might need to use, I'm going to be using this courtroom for the other defendants.
Well, let me
on
put this
indictment.
on here because I was in and out. Oh, I don't know what that is. I don't know who that person is leaving me a message. I just heard them say that there was a an indictment, a revised indictment. I want to know what that revision was. So I'm sorry, I caught that. Um, what else I want to tell y'all? Now, whose lawyer is Joe Lieberman? He's sitting next to Shannon. So, um, yeah, I guess I answered my own question, but Joe Lieberman ain't said shit since I've been watching him. Now I don't know if he said something prior to me watching this case like this, but he ain't said nothing since I've seen him. Okay, if y'all don't know who Joe Lieberman is, I don't know. I don't know. He's in politics. He was. I don't even know if he still is, but he always remind me of Joe Lieberman. Now, did the and depending on, let me see what we're doing with this poll I have up. Okay, maybe I'll do Drake next and I'll be able to finish with the poll. 'Cause I really want to know if you think the defense with the YSL case will, did they hurt themselves by not putting on a defense? That's maybe if I go out tomorrow, I don't know. I'm deciding whether I'm gonna listen, have Thanksgiving at the house, mean do nothing, or am I going to hit the road? I don't feel like hitting no road. I really don't. To be honest, I really don't. Nope, I don't feel like doing that. Um, but I want to know, do you think that they will, did they hurt themselves? Well, I have a couple questions. Let me write it down. So just give it out. I'm probably going to do a poll on that at some point. Because I saw a lot of that in the chats that I was browsing around. Oh yeah. Okay. Then the other question is, do you think Diddy will get the bail now, seeing that it seems like it's off the timeline than the judge had indicated that he would make a decision because he said, I think when I was doing the Twitter updates, it was saying like, yeah, he'll try to have a decision or something like that. Before something before Thanksgiving or something like that, right? Well, tomorrow's Wednesday, and if it was going to be a holiday thing for Diddy, I mean, just in my opinion, it seemed as if they would have, um, he would have made a decision by, at least by today. So they will be able to get the security and all that stuff in place at the man's house, right? That doesn't mean that he won't be released. Okay. I'm just saying, a lot of people was thinking, oh, he asked some questions. Oh, is he gonna get out? He gonna get out? He gonna get out? He gonna get a bed? He gonna get out? One fool said, "Oh yeah, I know he's gonna get out Friday. He's gonna be given a bail Friday." That didn't happen. Just oh, I can't stand all that. Mm-mm. Speak on the record as if you know it's for certain, and try to certify it as if you know it for certain. And damn well you don't know, because that would require that you somehow know somebody, know the judge. But I may clown that shit at a later date, but I don't know. It just depends. Somebody fuck with me. Stop. Okay? Because that were the case, the judge would have done what you said and would have gave him the bail Friday. Oh, wow. Oh. Lord, free. Oh, no, I can't say that. Because I don't know what that response would be like. So, um, but let me see if I can figure out something real quick. So hold on for a minute. Okay. Let's see what we have with this.
So no.
Your Honor, Ms. Chrisfield, these are, I separated these. This is investigator Dennis's stuff that was taken out.
Okay.
Jimmy Winfrey, plea that was taken out.
Okay.
And a transcript for Mr. Sledge.
All right.
So these are all different things that were either removed methods, whatever it is.
Can you make sure that 444Y and 1AS are not going back? They were, I think maybe Ryan, I don't know, something to do with, no, I don't know what they were. I just have a note to myself that those are continuing witness.
Your Honor, I've looked at the revised indictment that was received, and it's acceptable.
Thank you.
There you go.
That may have been Mr. Sledge's pleas or something like that.
Yeah, it works. See it? Right there. Good. You got it.
444.
Okay, so there must be another part to this video. Okay, so let's read because she read the she really read the let's see. Hold on. Does anybody know if they got a special verdict form? Does anybody know? I have to find out myself. Okay, here we go. So it took her an hour to put it on the record. So I can entertain that for an hour. We can put that on the record. Hold on. Okay. What else did I see? I'm gonna make these questions. For tomorrow, if they don't have a verdict back. Um, so, and although the defendants have majority of it played out, left these two guilty face. Why I've always said was, had the guilty. We're not some other gang. Um, left those guys back. I had seen also saw some. They was arguing back in the chat today about it was like it wasn't fair that Thug Nim had money. Oh, that was on Twitter. I'm sorry. Like it's saying like Thug was able to go home scot free. They had a picture of two guys up that had to go to jail, prison. They showed their prison photos and stuff, and saying like it ain't fair because he had money and Thug had money and stuff, and they were saying that the charges wasn't as serious as the other two guys. Remember, I don't know the names of all these guys. I just really know Shannon's name. You know why I know Shannon's name. And whatever this guy in guilty face, what his name is, I don't know his name. What's his name? Doug Weinstein's client, guilty face. So, what I was saying is they were saying that the other two guys that they showed on Twitter, the charges are different than Thug's on, right? So I don't know all them defendants. Some of those cases were severed. I can't begin to tell you who's who, what's what, and people taking pleas and all. I can't. And I think the YFN case is going to be even worse. And while I'm sitting back and hopefully they've uploaded the new indictment so that I can get it, or I can pay attention to what she's saying and see if I can figure it out based on the jury charge, which I'm not gonna be able to, because it has over 100 something acts, and they have what 50 something charges. Now I ain't gonna be able to do that. But just like some of the back and forth they had going on in the chats and stuff. One the other one was about the evidence. So although Thug and all those people are gone, it doesn't stop the prosecution from using using evidence that has already been gathered, right? Doesn't stop them from using that evidence. Doesn't stop them from mentioning Thug's name. Doesn't stop any of that. What the defense can do, those last two defense attorneys, that what they can do is motion for the judge to only to have a limiting instruction for the jury only to consider evidence, not to consider that evidence against their client, if they have the legal argument to do so, and if the rules support their legal argument, okay? Other than that, they can consider the evidence, okay? Remember, this is a RICO. I think all of them are charged with RICO, I believe. I don't know. Well, let me take that back. I don't know. Whoever is charged with count one, and this is if I'm not mistaken, a conspiratorial RICO, which is harder to defend because the elements for conspiratorial RICO is very, very, very basic. Okay, so it's hard to defend. It's like you knew about it, I think it's either before or after the fact or something, like something is basic like that. Like if you know something, you in it, that type of shit. So that's why it's harder to defend versus the RICO that R. Kelly was charged with, which is a substantive RICO, which means that the prosecutors had to prove that he actually participated in it. Okay, it's harder to prove that somebody participated in something. Okay, it's a little easier to prove that somebody knew about it. Okay, so yeah, so and I think some people was getting on edge about, because they have a lot of supporters in these chats, right? In these news chats and things, right? And they were like, I think a lot of people was getting kind of, you know, um, nervous over the prosecution's performance. You know how they were able to play all that evidence during closing and all of that, whatever, make all of those allegations, every if they were true and all of that. It pretty much did the same thing during the trial, and you can do it during your closing, right? And the fact that the defense did not put on a a case, a defense, I'm sorry, doesn't mean that the defense threw in the towel. I've seen all kinds of shit, right? It doesn't mean that they threw in the towel. No, it's a strategy. One, it's a strategy, or it could be they really have no defense for that evidence. And defending that evidence can open the door to something else. Okay? It is a strategy because remember, the defense don't have to prove nothing. Okay? The burden of proof is on the prosecutors. And sometimes the strategy is make them stand on it. All right, let their case work for them. Don't put on a defense and then start opening doors to other shit. And don't put on a defense when you don't have witnesses or anything that can defend what the state has put on. Kind of that situation with R. Kelly. For some reason, I just don't understand what is wrong with these people. But you still, this is 2024, and you still talking about, oh, why you ain't take the stand to defend R. Kelly? Why he ain't had nothing? Why all this right? That is because one, just because you know some good things about R. Kelly does not qualify you as a character witness. There are certain rules to be a character witness. Common sense thing. If it was as easy as just you going in there and sitting the ball of your ass on the stand, don't you think the damn courthouse has been wrapped around the corner with people? Now I hear one more motherfucker say that There's a lot of times I be wanting to say that, but that kind of comes out because certain things just bother me and dumbness does, and not you not getting it. And even though I know I done said 100, and you gotta take it from me, but go ask another attorney or one that you believe is an attorney. They'll tell you, or do yourself a favor. I think it's rule maybe 404 or something like that. Look up character witness. No. Hold on. What is character witness? Look that up. Shit, and stop saying stupid shit. Yeah. What's the rule? Rule 405. What's rule 404? Yeah, relevance of always. Um, reputation of opinion, but even that comes with some limitation. specific instances that comes with some limitations. Oh, yes, rule 404 and 405. Okay. I know I went crazy. It ain't been that damn long. But, I mean, been that long since I had to remember rules like that. But, like, just say crazy shit. I have no idea why. And y'all have no problem about saying incorrect shit on the. That bothers me. But I have to listen. I have to know where I am. Okay? Nothing bothers you motherfuckers. But, so, like, everybody can get up there and testify. And again, for as they expect your mama to, just so your mom can't get up and all that. Like, just don't worry about it. Just don't worry about it, okay? Just stop saying stupid shit, because that really gets on my nerves too. But the reverse is somebody eating and putting drink in your mouth. I just hate a bunch of shit, right? So, um, so it's either gonna be because it's a strategy why they ain't put on a defense, or they could not defend that evidence. It's one or the other. If it's an attorney talking to an attorney, and if they are asked why you put on put on a defense or whatever, they're gonna explain either or. Oh yeah, strategy. Especially if you think that you got a good chance for the jury being on your side. You have you have a belief that the prosecutor's case is weak. Okay, you don't put on. Yeah, I mean that's just and that's a strategy. I mean that's really. I mean it's not no matlock moment or nothing like that, but you just have to. But in a case like, and see, it's not a matlock moment for a simple case, right? In a case like this, that is a real a real I mean that's something that you had to do some real a real deep dive into what you have. And both, you notice both attorneys didn't put on a case. So right there, it's probably more of strategy. Could be a combination of the both. More is strategy, one. Two, you can't defend what the prosecutors have. So why sit up there try to? Why open the door, risk opening the door, prosecutor go get some other evidence and all this here. You don't know what the Judge Whitaker has, like, I want to call it pending evidence, meaning that, when you say, well, we'll see as the trial goes. Remember that maybe there has been, she excluded or precluded the evidence, but she's going to wait to see how the trial goes, meaning if somebody opens the door or something like that, or somebody opens the door that can usher in one of those rules that can make that evidence relevant. Now here comes some bullshit from the prosecutors. You don't want to risk all of that. So you make an executive decision to say, okay, okay. And also, and what they did was pretty smart. They seemed as if they kind of presented their defense during cross-examination as well as during the closing, right? Because they played that video of the girl, the car driving down and the girl, somebody getting shot later on, minutes later. I don't know. I mean, and I don't know too much. I didn't even know some girl got killed. I didn't know nothing about all of that. I don't be keeping up with all of that like that. So then there's that, right? So it's either one or two of those things. If you think you got a good shot, you leave well enough alone. Okay. And again, now that I think about it, it was two of them, either attorney put on a defense. That was a strategy. Strategy. That'd be my first guess, and backing it up would be you don't have nothing to put on, no evidence to nothing to counter that. Because remember, right? You put on a defense, just about everything that the prosecutors put up, you got to have some piece of evidence to suggest that either it didn't happen or somebody else did it. And I mean, when I say it didn't happen, meaning your defendant, your client didn't do it, or somebody else did it. You see, during the closing, they were putting everything on Woody or whomever, anybody but their client. They was pointing somewhere else. Remember, I said that long time before R. Kelly's trial got started, right? I said, they're going to have to either show evidence of, like, he's on trial. I mean, he's on tour. He couldn't possibly did this, that, and the third, or somebody else did it. Or another one, it didn't happen. Now, it didn't happen like that. That's tricky. Because when you put on it didn't happen like that kind of defense, you are relying on the jury to say, oh, okay, well, the prosecutors, they don't have their facts right. Or the prosecutors, they lying. Let's find them not guilty. And I hate to say it like that. You are betting on, betting on the ignorance of the jury, or the naivete of the jury, right? That's what you're doing. You might not want to make that, do that, put that, because here's the thing. Right now, if you can put it together, like, okay, it didn't happen like that. Based on the evidence we have, it didn't happen like that, and the way it happened, it's more likely that Woody did it, because it didn't happen on Tuesday, right? We have a coroner's report saying that the rigor mortis didn't set in till more than 24 hours later. So it didn't happen on Tuesday, it happened Wednesday. Tuesday, my client was in the hospital all day, seeing a sick relative, and he stayed there all night, and everybody saw him. See what I mean? It's all about strategy, baby. It's all about can you answer the questions, and if you can't, what you do? Am I in trouble? You know, so yeah. What else I saw? Money. That's about it. They be real serious in them chats, baby. Why is that got some real hardcore fans, honey? I swear I ain't know nothing about all this. And I only knew about why. Now I knew about YFN before I knew about YSL, only because I followed the reality stuff, because YFN, the dude was dating Lil Wayne's daughter, and I followed Toya and Reginae, because they be doing having little reality shows, and they friends with Candy and all of that. You know what I'm talking about? And remember, and the Candy thing, and the Tamar thing, and the Toya thing, and the Toya and K Michelle was like, remember all that stuff, and then Candy and Tamar had Candy had an issue. Candy and Tiny had an issue with T.S. Madison coming to the show, and Tamar said it was okay, and that was one of their falling outs and stuff like that. And a lot of stuff that was going on, offline. That's when I was one of the calling girls over there with T.S. and them, whatever, Yes, honey, yes. So it was a lot going on. That's how I know about YFN. But I followed Toya and Reginae. The reason why I know about them. And, I ain't know nothing about no Young Thug until he showed up with Chris Brown. My baby, daddy baby. But anyway, let's get Paige on this record with these jury instructions. Let me see if I can hear something that may stand out to me. See, and then listening to the jury instructions, remember, that's the way that you can tell whether or not the prosecutor proved this case. If you want to jump ahead of the jury making a decision, listen to what the jury has to prove and see if the prosecutors prove their case, right? That's not me, it's her.
51, participation in criminal street gang activity pursuant to subsection B of that statute. 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during your deliberations. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, the instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is the doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is the doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If after considering the evidence, you believe beyond a reasonable doubt that a defendant is guilty of an offense alleged in the indictment, you would be authorized to convict the defendant of that offense. If the state fails to prove the defendant's guilt of an offense beyond a reasonable doubt, it would be your duty to acquit the defendant of that offense. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses, the exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, and these 4 stipulations are marked as joint exhibits. Where parties stipulate facts, that is in the nature of evidence, you must take that fact or those facts as a given without the necessity of any further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Direct evidence is is that which can be seen or heard or otherwise directly sensed. It may be brought into court in the form of exhibits or the testimony of a person who asserts that he or she has actual knowledge of a fact by personally observing or otherwise witnessing that fact. It is evidence that points immediately to the issue in question. When direct evidence points by inference to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly observed or otherwise sensed, that's said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that tends to prove or disprove another fact by inference, that is, with consistency with such a fact or elimination of other facts, or that only tends to establish a conclusion in question by its consistency with such conclusion or its elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence alone, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or a greater degree of certainty on the part of you, the jury, to return a verdict based on circumstantial evidence than upon direct evidence. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. And whether it's dependent upon direct or circumstantial evidence or both, the true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility, and this may include evidence of a character for untruthfulness, bias toward a party, or felony criminal convictions. In determining the credibility of any witness whose credibility has been attacked or challenged, as I've described above, and any testimony given by him or her in court, you may consider, where it's applicable, evidence offered to support the credibility or believability of such a witness. The credibility of a witness may also be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony that the same witness gave before the trial started. It's for you to decide whether there's a reasonable explanation for any inconsistency in a witness's pretrial statements or testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if that is shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of all of the witnesses. The testimony of a single witness, if believed, is generally sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. An exception to this rule is made where the witness is an accomplice. The testimony of an accomplice on its own is not sufficient to warrant a conviction. An accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It's not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does in fact support the testimony of another accomplice is a matter for you to decide. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose or against some parties and not others, or for some counts and not others. I have previously instructed you as to how to consider particular evidence that was limited over the course of this trial. Such evidence may be considered by you only for the sole issue or purpose, or against only the party, or only for the counts for which that evidence was limited, and not for any other purpose or against any other defendant or for any other counts. You have received evidence of certain prior convictions of these defendants as well as certain other witnesses in this case. You may consider the conviction of Mr. Kendrick only against Mr. Kendrick and only as to count 1 and as to the required element of being a convicted felon in count 63. You may consider the convictions of Mr. Stillwell only against Mr. Stillwell and only as to count 1 and as to the required element of being a convicted felon in counts 52 and 64. You may consider the convictions of any witnesses only insofar as they may relate to attacking the credibility of that witness and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out-of-court or any out-of-court identification. It's for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict on those counts. If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor. You are not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of a crime, unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer, Influence, and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy. For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be expressed, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you, because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of codeine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act, as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity. For malice murder, the state must prove that a defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation, and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes any handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony, of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon when you get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols or THC. The state must prove that the defendant possessed the marijuana and or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending upon which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant knowingly possessed the marijuana or the firearm. And I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that, for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person's property from the immediate presence of the other person by using an offensive weapon and with the intent to commit theft. An offensive weapon is an object that's either likely to cause or actually does cause death or serious bodily injury if it's used against someone. Conspiracy to commit murder. A person commits conspiracy to commit murder when that person conspires with one or more others to commit the crime of murder. Murder has been previously defined. Criminal attempt. A person commits criminal attempt to commit a crime when, with the intent to commit that crime, the person performs any act that constitutes a substantial step towards the commission of the crime. Criminal gang activity has been previously defined. Criminal use, a person of an article with an altered identification mark. A person commits the offense of criminal use of an article with an altered identification mark when he possesses a firearm from which he knows that the manufacturer's serial number or any other distinguishing number or identification mark has been removed for the purpose of concealing or destroying the identity of that article. Possession of a firearm by a convicted felon has been previously defined, but in addition, with regard to that offense, possession of MDMA with intent to distribute, possession of cocaine, and robbery are felonies. Possession of a firearm by a first offender probationer. For possession of a firearm by a first offender probationer, add that word, probationer. The state must prove that the alleged perpetrator possessed a firearm while on probation for a felony as a first offender. Robbery and criminal damage to property are felonies. Possession of a firearm during the commission of a felony has been previously defined, but in addition, for these overt acts, possession of codeine with intent to distribute and possession of cocaine are felonies. Possession of a machine gun. The state must prove that the alleged perpetrator possessed a machine gun during the commission of any of the following offenses: participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. A machine gun means any weapon which shoots or is designed to shoot automatically more than 6 shots without manual reloading by a single function of the trigger. Possession of controlled substances. For possession of cocaine or oxycodone, the state must prove that the alleged perpetrator possessed any amount of cocaine or oxycodone, both of which are controlled substances. Possession with intent to distribute. For possession with intent to distribute codeine, hydrocodone, marijuana, MDMA, or methamphetamine, the state must prove that the alleged perpetrator possessed any amount of marijuana or any amount of codeine, hydrocodone, MDMA, or methamphetamine, which are controlled substances, with intent to distribute. And intent to distribute means intent to unlawfully deliver or sell. Sale of marijuana. For sale of marijuana, the state must prove that the alleged perpetrator sold any amount of marijuana, and sell here means to transfer marijuana in exchange for money or anything else of value. Possession of a weapon by an inmate. For possession of a weapon by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized weapon. For possession of a telecommunication device by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized cell phone. Conspiracy to possess a telecommunication device by an inmate. A person commits conspiracy to possess an unauthorized telecommunication device by an inmate when that person conspires with one or more others to commit the crime of possession of a telecommunication device by an inmate. For terroristic threats, the state must prove that the alleged perpetrator threatened to commit a crime of violence and that the threat was made. Theft by receiving stolen property. A person commits theft by receiving stolen property when that person receives or keeps stolen property and the person knows or should have known was stolen, unless the property was kept or received with the intent to restore it to the owner. Knowledge on the part of the alleged perpetrator that the property was stolen, or evidence sufficient to show beyond a reasonable doubt that the alleged perpetrator had reason to know the property was stolen, is an essential element of this offense. Knowledge that the property was stolen may be shown by circumstances that would excite suspicion in the mind of an ordinary person. The burden is on the state to prove beyond a reasonable doubt that the alleged perpetrator had knowledge, or under all the circumstances should have had knowledge, that the property in question was stolen and was in the alleged perpetrator's possession. All right, that's it for the overt act crimes. All right, the law provides that criminal action shall be indicted and tried in the county in which the crime was committed. In a prosecution in any case in which it can't be determined that what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt it might have been committed. We don't have that here, do we? So essentially just the state must prove that the criminal actions alleged as counts in this case, that they have to be tried and indicted and tried in the county in which the crime was committed. So venue, that is that the crime was committed in a particular county, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue may be proven by direct or circumstantial evidence or both. To prove venue for the RICO count, the crime is considered to have been committed in any county in which an incident of racketeering occurred or in which an interest or control of an enterprise or personal property was acquired or maintained. The defendants are each charged with certain offenses that are set forth in various counts of the indictment. Each count is a separate and distinct offense, and you must independently evaluate the evidence against each defendant and as to each offense. The fact that you reach a conclusion with respect to one offense or with respect to one defendant does not necessarily mean that the same conclusion will apply to any other charged offense or to another defendant. Each count of the indictment before you is separate and distinct. You must evaluate evidence as to one count independently from evidence of each other count. You must evaluate the evidence as to each defendant independently, and you must render a verdict as to each count and as to each defendant individually. If, after considering the testimony and the evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt the defendant in Fulton County, Georgia, committed an offense as alleged in the indictment, you would be authorized to define the defendant guilty of that offense. In that event, the form of your verdict for that offense would be to find the defendant guilty. If you do not believe the defendant is guilty of an offense as alleged in the indictment, or if you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense. In that event, the form of your verdict for that offense would be to find the defendant not guilty. You are to make a separate determination of guilty or not guilty as to each offense and as to each defendant. Your verdict as to each count must be unanimous. That means that you must be unanimous in your determination that the state has proven every element of that count as defined and listed above beyond a reasonable doubt. And you'll have a copy of these instructions out with you so that you can see what each of the elements of each of the offenses is. Again, the elements are listed above where the crimes are defined, and you must be unanimous that each element has been proven. Let me explain what that means for a few of the elements for count one a bit more specifically. And that's the conspiracy to violate the RICO Act. You must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. But because count one is charged as a conspiracy to violate the RICO Act, it's not required that the state prove that any conspirator actually committed an act of racketeering activity. And on the overt act element, you must be unanimous that a conspirator committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. And you would note on your verdict form that and any of other overt act committed in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against any party. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it's wrong. However, you should never give up an honest opinion simply to be congenial or to reach a verdict solely because of the opinion of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. And these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. During your deliberations, any communications from you to the court must be in writing, signed and dated by the foreperson, and given to a bailiff. And let me add that given that the evidence is closed, my ability to respond to questions may be limited. Evidence that was admitted by audio or video recording can only be played here in the courtroom, so any request to review or listen to that evidence again must be made in writing by you to the court, and then it'll be replayed in the courtroom. And that is the end of my instructions. I'm going to excuse you all to the jury room now to elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, and 508 to hang back with me. And the rest of you can return to the jury room to elect your foreperson.
All rise for the jury.
All right, y'all are the alternates in the case. considering the length of this trial, it was critical that we had alternate jurors in case we lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take. And so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty. You're not going to be deliberating right now. But you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at any kind of social media or any other kind of accounts of this trial or anybody involved in the trial. Essentially, you're still on jury duty. I am going to, for the next hour or so, keep y'all around here. And Sergeant, maybe, I don't know, I'm sure there's probably another jury room that they can retire to. While y'all are on jury duty and the jury is deliberating, I want y'all to stay within an hour or so of this courthouse. If we're ever on a break, you know, we've got Thanksgiving break coming up. Obviously, y'all can go and do whatever your Thanksgiving break plans were because the jury's not going to be in session, court's not going to be in session, we're not going to be deliberating. But even when you're on those breaks and any others that might occur during the deliberation process, you still can't talk to anybody about the case or allow anybody else to talk to you about the case or look for any information in any way about the case. So essentially you remain on the same instructions, just when we're on break, you're on break too. When the jury is deliberating, I need y'all to be where, if we need you, we can get you within an hour, down here within an hour or so, okay? So for right now, y'all can go and grab your things. You can say goodbye, it's been great. I may see you again to your fellow jurors. And then we'll have you in one of the other jury rooms for a little while at least. And if I'm going to release y'all for the day, I'll let y'all know that. But again, just kind of stay within an hour or so of the courtroom. And just like you've sort of kept your cell phones in a way that we can communicate with you, continue to do that in case we need to. Thank you very much. Are there objections to the chart?
Just a few things that you guys are on.
Okay.
On page 2, Your Honor.
On page 2? Okay.
When reading participation in criminal street gang activity for count 50, you said subsection 1 and not A. So I just wanted to
Hang on a second. Let me get there. Page. Where are you talking about?
So count 50, where it's participation in criminal street gang,
Yes.
you said section 1 and not A.
Okay. Do you want me to call them all back in and say I meant to say A, or they'll have copies of this out there and it'll be on the verdict form correctly?
Yes, Your Honor.
All right.
That's fine. I didn't know if I had something different than what you had, and so I wanted to make sure that what I have in front of me was correct.
Okay.
Only as to page number 9, when you last paragraph, any out of court statement.
Hang on. Yes.
As we were reading it, the thought came that maybe we should add any out of court statement made to law enforcement, or made to the police, made by one of the defendants on trial in this case after the alleged criminal act.
We probably should have.
So just,
I gave y'all this, I don't know how many different times to look at and ask you. I don't know how many different times for any kind of comments or corrections. So what do you want me to do?
can we add it, and then when you send it back?
Sure.
That's all, Your Honor. I'm just going back.
Made by one of the defendants made to law enforcement by one of the defendants on trial?
Yes, Your Honor.
Okay, we can do that.
And as of right now, those are the only ones that I see.
All right, appreciate it. Thank you. Anybody else?
I have no objections to your reading of the jury charges, Your Honor. I just need to renew my request and objection to exclusion of jury charge 3.01.10, which is the justification, as I requested justification for my client's possession of a firearm by a convicted felon. I requested that charge, so I'm just renewing my objection to the exclusion of that charge, as well as the separate and distinct charge that overt acts need to be proved. An overt act needs to be agreed upon unanimously by all the jurors. I know Your Honor stance that you referenced the need for unanimity, being unanimous. I always struggle with that word.
Okay.
Within the jury charges, and I understand that, but I'm just going to renew my objection.
Okay.
Thank you.
All right. Then we will, y'all have agreed as to what evidence goes out?
Yes, Your Honor, there is we're including a flash drive with a list of the exhibits, the Stillwell exhibits.
Okay.
And I thought it would be appropriate, and if it's not appropriate, please object. It's just a list of the exhibit numbers, because the flash drive is little, so we can't list them all. So we're printing on a piece of paper.
Okay.
And we're just going to attach the flash drive to the piece of paper.
Okay. And those don't go out. You're just saying you're listing them.
My understanding, well, they can't play them. My understanding is that all the media was going to go in the back room. They can't play it, but then they could ask if they wanted us.
Just so they'll have a list of what it is?
I'm not even proposing a list of what it is, as in what each exhibit is, but just that these are the exhibits that are on this flash drive. I'm not suggesting.
We don't normally send the actual media out with them.
Okay, I mean,
they can, it's certainly in evidence and they certainly can consider it. They just would need to say, hey, I'd like to watch the FedEx tape again.
Okay, my understanding, I had spoken to some members of the state about this. The understanding I had was that the media was going to go out, but of course they have no way to play it, but then they could request.
Okay, are they going to even, if it all, for instance, goes out in a bin, are they going to even know what it is? Like, are they all labeled? Yes? I mean, it's fine with me if that's the way y'all want to do it.
The only other thing we were going to ask to do, I believe the defense counsel has an objection. We were going to send a legend out with the letters and what letter is associated with what act, so that they would know. We organized them.
I don't know what you mean by that.
So every act that we presented, so for example, VV was the Shamel Drinks homicide, so that they can know when they pick up a letter, what that was in reference to.
I'm going to object to that, to the state's kind of direction of compartmentalizing the evidence. And quite honestly, some of the evidence that was admitted under certain letters applies to certain other cases. I mean, these aren't distinct. I know that they're charged as distinct overt acts, but Walter Murphy testifies, for instance, and he has things they admitted to Walter Murphy might have a WW, just for instance, but what he testified to involved different acts.
I mean, I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53 WW, then they can find that, or if it's media, they can ask to re-listen or replay it. I don't think that it's really appropriate to say, here's kind of the state schematic of the evidence. Okay. So have y'all otherwise agreed on what evidence goes out with them and what evidence doesn't?
So I've been presented some case law this morning and we've discussed it. I don't have any problem with the GBI reports going back. I know that was one bone of contention.
Mhm.
I don't have any problem with the ME reports going back. We've been going back and forth about two issues, the CAD reports and the
Okay.
demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay. You wanna?
I join in.
Okay.
Mr. Sharp.
All right. Does the state feel that the CAD reports or the demonstratives should go out?
Yes, Your Honor, we have case law regarding demonstrative evidence.
Okay.
That demonstrative evidence does go back to the jury, and it's not a violation of the continuing witness rule.
Would you like to share that with the court?
Yes, Your Honor.
Okay.
This state will cite Ruffin v. State, which is 333 Georgia Appeal 793, which is a 2015 case.
Mm-hmm. Okay. And then how about the CAD reports? Is the objection, what's the objection to the CAD reports?
Continue.
Okay. And does the state have a position on that?
Your Honor, the state does not believe that the CAD reports are a violation of the continuing witness rule, and we are looking, I thought we had the case on point, but we are looking for that case. Yes.
Okay.
I have a case, Your Honor. It's a March 2021 case. I'm going to spell it PATTAROZZI, state 385 Georgia Appeal 675. It stands for basically what the continuing witness rule applies to, and a CAD report would not be something that is listed as something that wouldn't go back because it would be a continuing witness because it's an original evidentiary document and it's non-testimonial in its nature.
Does it cover CAD reports at all, or is it just kind of here's what continuing witness means?
It's just kind of just here's what continuing witness means. I couldn't find a case specific or on point as it relates just to
It's hard to believe, honestly.
which leads me to the conclusion they go back.
Yeah. So does the defense have any case law on CAD reports? So I'm looking at a case, Muse, from the Supreme Court from last year, 316 Georgia 639, and it also doesn't cover CAD reports specifically, but it's talking about surveillance videos, and it says, here the surveillance videos were not the reduction to writing of an oral statement, nor a written statement provided in lieu of testimony. And a CAD report, I mean, it contains the reduction to writing of an oral statement, doesn't it? So it may be that it can go out redacted. What does CAD stand for? Computer aided
Dispatch.
Mm-hmm.
I wanted to share this in case it helps. My thinking is with the arguments we've had on CAD reports and 911 calls
Mm-hmm.
In our many days of going through upcoming exhibits, the court made determinations on testimonial versus non-testimonial with how we walk through and redacted. And so my understanding with the continuing witness rule is if a document is non-testimonial in nature, then it's not a reduction or substitute for the person's oral statement or testimony. In terms of that non-testimonial analysis is part of the genesis of the continuing witness rule. And that was why I wanted to share that. And this is coming from, I believe it's the same case that Mr. Abadi cited, the PATTA. Yeah. But I just wanted to share that because it just hit me that that pre-analysis, of course, with the CAD and 911 specifically, we have argued and the court has ruled on that part. That was all I wanted to share, Your Honor.
There's another case that's pretty new. Davis v. State, which is 371, Georgia Appeals 469, 2024 case.
I mean, in the Paparazzi or whatever it is case, the continuing witness rule is inapplicable where the documented issue is original documentary evidence or where it's non-testimonial because it's not a reduction of or substitute for oral statements or testimony. It's certainly not a substitute for oral statements or testimony. And it is original documentary evidence. And I think we already redacted out of every CAD report, at least since I've been involved, any hearsay, right?
Your Honor, it is true. It is what Mr. Atkins said, to my recollection, is completely accurate. As we did have a series when we went through these CAD reports, a series of hearsay objections and confrontation clause objections.
Right.
And some were redacted.
Yeah. All right, so then I think it would be my conclusion that it is all right for them to go out as long as they're all redacted to cover the evidentiary rulings that I made previously, or that the predecessor court made previously. All right, did y'all, I hadn't had a chance to look at the demonstrative law yet. Yes. All right, my rating of reference is that demonstratives can go out with the jury. Y'all, if y'all got something contrary to that.
Can we just be clear what demonstratives we're talking about?
I believe there's some physical evidence that Ms. Weaver may have in her.
She's got guns and drugs.
So the drugs kind of.
Neither of those is going out to the jury.
Okay.
If you have pictures of them, those can go out. Or you suggest, is there anything besides guns and drugs that she has?
So we're going to look at the evidence list.
Y'all aren't suggesting that either of those go out with the jury, are you?
No, we're talking, we have the jewelry upstairs.
Okay.
Some of that may or may not.
Not sure we want that to go out with the jury either, considering the allegations in this case by one of the attorneys. Unless we've got an armed guard in there.
We're going to go over the exhibit list trying to see what else Ms. Weaver may have.
Y'all got pictures of the jewelry and pictures of the guns and the drugs, right?
Yes.
Okay. And those are those in evidence?
Some of the picture of the jewelry.
Okay.
While that's being done,
Mhm.
I have permission to just step out for a moment.
Sure, absolutely. Yep.
Thank you.
There seems to be pretty
Excuse me, Your Honor.
yes.
Regarding Ruffin v. State, having looked at the demonstratives the state plan would like to send back to the jury, these are demonstratives that were, if not all, at least for the most part, I think all, produced by the state for use with their witnesses.
Okay.
Whereas in Ruffin, that was an anatomical chart apparently used. Well, actually, I can't tell if that was, it looks like it was used by a medical examiner in the parenthetical.
So I'm looking at, it's a fairly old case from the late 90s, but it says items of demonstrative evidence. It's Gabbard versus State. Hang on. Let me find that part.
Oh, Gabbard v. State,
Yeah.
Your Honor.
Mm-hmm.
233 Georgia App 122.
Yes.
Let me pull that up.
These were also anatomical drawings to illustrate victims' testimony.
There's a more recent case, more v. State, Georgia Supreme Court case 311, Georgia 506. It addresses demonstratives as well as the cell phone presentation and things of that nature going back.
Sorry, was that Moore v. State?
Yes.
Thank you.
311, Georgia 506.
Thank you, Mr. Abate. This case, Your Honor,
Mm-hmm.
I think it seems to imply that the lead detective is the one that prepared the PowerPoint summary that went out to the jury, not a demonstrative prepared by the state. Unless I'm reading it quickly, but it appears to be a distinction there.
Okay, so I'm looking at a case, McKenzie versus State, 300 Georgia App 469. It says the continuing witness rule does not apply to demonstrative evidence designed to illustrate testimony given by witnesses. Here, the documents complained of were designed by an investigator of it was the DeKalb County DA's office based on other admitted exhibits, including cell phone records, dates and times that checks were cashed. The documents were admitted at trial and served only to summarize the other admissible evidence. There was no violation of the continuing witness rule. I mean, that was more like a summary document, but I guess that was demonstrative and summary. And it was prepared not by the witness, but by one of the parties, and it was not subject continuing witness. Seems okay to me.
I'm going to have more of a challenge distinguishing that one, Your Honor.
All right.
Yeah, I don't know.
So I think unless y'all come up with something else, that I'm going to overrule the objection to both the CAD reports as described, redacted, and demonstratives going out. Other.
So there are some pieces of physical evidence, Your Honor, hats,
Okay.
other clothing items that
Yeah.
we're having someone go to retrieve to bring them down.
Okay.
And I think by the time we retrieve that, gather everything, we'll be ready to
All right.
collect everything and have it sent back.
One other matter. There are two demonstratives that were admitted by Mr. Steele.
Okay.
These were admitted at some point during the trial.
So I'm
in January.
Yeah. Those are just blow-ups of
Yeah.
the language of certain
Yes, Your Honor.
overt acts.
It was admitted when Trontavia Stevens was on the stand. I don't particularly have a strong feeling one way or another about them going back. I'm not sure.
I'm thinking those aren't needed because they're going to have the indictment itself out, and that's really just a magnification of certain of those items on the indictment. So we won't send those out. And if y'all want to look through whatever other demonstratives there are, that might be a good idea. I feel like I asked y'all to do this several times, several weeks ago.
They just went through it, I
Hmm.
believe, Mr. Atkins.
All right. Okay. Well, good. Thank you. So I keep. Hmm? Can you do that? Yes. Hmm.
The state has demonstratives which were the result of their writing during testimony.
Right.
I don't believe that those are covered under the case law that we're talking about. This is just literally writing in trial. I don't think that makes it a demonstrative. Essentially, they were writing to encourage the jurors to write. Is kind of the way I saw it. Sending a message, write this down because it's important. But I don't believe it's appropriate for these to go back.
Thoughts? I mean, it didn't seem like that was being used to help the witness illustrate their testimony. It was more to help the jury kind of. Okay, so those will not go out.
So I'm going to put these right here with the, not those.
Okay. All right, y'all can continue to do this. Let's take a quick recess though. And y'all do that during the recess, and then maybe we'll come back and once it's settled, okay?
Your Honor, is there a ballpark for this reset?
I honestly think it'd be our recess /lunch if you want it to be. So if you want to come back at 1:30.
Okay, let me see where we are. Where we are. Where we are. Okay, now I'm gonna put up some stuff that I just got from some reliable resource, right? Over off that Twitter. Show you what I found. Now, when did this occur? Ain't nobody told me nothing. So apparently, there have been some issues with some of these jurors, and that's why I said, okay, didn't know, whatever, right? First one says, it says, the one, I guess this juror 56, about a year and a half ago, said, I just, no, it says, I just like to keep things in a timely manner. That's just how I am. I value time extremely serious. And it says, left my ass up. The state should have seen this coming. Not guilty off of pure spite. It says, for those not familiar with this same juror that just a couple weeks ago emailed the judge that they will be biased against the state no matter what because they're taking so long. What? What this is what I'm talking about. We're gonna have to get some more people on this information bureau. All right, because everybody, I don't know what we doing. Then it says the juror in the YSL case emailed the judge that they will be biased against the state no matter what because they're taking so long. Okay. Then there's this juror number 387 whose coworker reached out to her after Thug took his plea, is one of the alternates and won't be part of the deliberations. If one of the main jurors somehow drop out at this point, she will be the one to replace them. A juror's co-worker were reaching out asking if the trial was over after Thug took the plea, and she replied, "Everyone and their mama is saying that." The judge questions her to find out what information people gave her and if she can continue to follow directions. She stays on. Huh? And know this. If they are found to be not guilty, there's nothing that can be done. Okay? If there is evidence of jury tampering, the only thing they can do is try whomever for them for jury tampering. That's it. Nothing else. Unless they find some other way to um, come up with some other charges. That's it. Then you have this where the Weinstein, apparently there's a description of what he said, and apparently Hilton said targeting only people of color for their music is and lyrics is wrong, Weinstein said towards the end of his closing argument. Says Deputy DA Simone Hilton started out saying that they are not targeting people of color, but gang members, and that most of the prosecution team are people of color. Doug Weinstein, I guess, wanted to clarify what he said. He says, "This is what I said. I said not. I did not say that the state is targeting black folk. I said that they are only targeting them for their music." Huh? Like, this is crazy. Another thing, right? I was back here trying to get some information on this TD Jakes thing. Only thing I saw, I didn't know what the hell was going on with him. Only thing I saw was him getting all stiff on look like a little bench holding the microphone. And of course, they gave that media training as excuse as they give public figures and celebrities that um there is the person is suffering from dehydration. What? Like, oh man, this is crazy, right? This is like, what is going on with all of this filing and all of this? I don't know. I don't know. What else am I trying to find? So, but yeah. So we got the jury charge on the record, so y'all can again make a decision whether or not did they um did they did the state meet its burden, right? That's why we pay attention to the jury charge. Listen, y'all, I'm still mad at New Black, right? No, no, I'm not. Yes, I am. Hold on, let me let him. Give me a minute, y'all. One second. Okay. Now, let me see. So, got Diddy out the way. Got YSL out the way. Where you want to go? Let me see who got the longest piece of paperwork. Let's see. Drake got 14 pages. TDJ has 25. Let's go to Drake. I just want to know why. Oh, let me see if I can do slide the PDF. Let me see if I can do it this way. See if I can hit. If I can hit this way, baby. Oh, baby. What my white reader named Sarah? Oh, she might read it all motherfucking day. Let me see. Okay. Let's see. Let's see now. Oh, damn. But I ain't no reader. Yeah. Hold on. Well, I'm gonna have to go with lazy. Cut. That's what I'm going with.
File 125-2028-4:21 p.m. Gloria A. Martner Bor Cooney Disc Clerk Recepted by Brenda Caro Bor County 3260 Did Court 2024 C126782 Cosino.20 m_______ INRE in the District Court Aubrey Drake Graham, H. Petitioner, H. Judicial District requesting depositions of iHeartMedia Incorporated and HUMG Recordings Incorporated H. Behar County, Texas. Aubrey Drake Graham's verified petition for Rule 202 depositions. Petitioner Aubrey Drake Graham, petitioner or Drake, requests an order authorized under Texas Rule of Civil Procedure 202 to take pre-suit depositions of the corporate representatives of iHeartMedia, INE, iHeartMedia, and UMG Recordings Incorporated, UMG, which includes Interscope Records, Interscope, a wholly owned division of UMG, for which petitioner respectfully shows as follows. I pursuant to Texas R. Civ P 190.4, petitioner requests that discovery be conducted under a Level 3 discovery control plan. Factual background 2. Respondent UMG is one of a handful of companies that dominate the multi-billion-dollar music industry. When it comes to the release of new music by its most prominent artists, UMG is meticulous in TS planning and execution of the music it releases, promotes, and backs with TS considerable financial resources. That is true not just because of the amount of money on the line for UMG and its shareholders, but also because UMG's executives are eligible to receive incentive bonuses based on the revenue generated by the respective divisions. Cause no. 2024-_______________________________________________________________________________________________________________ In Aubrey Drake Graham, petitioner, requesting depositions of iHeartMedia Incorporated and UMG Recordings Incorporated. In the District Court. _______________________________________________________________________________________________________________ Behar County, Texas. Aubrey Drake Graham's verified petition for Rule 202 depositions. Petitioner Aubrey Drake Graham, petitioner or Drake, requests an order authorized under Texas Rule of Civil Procedure 202 to take pre-suit depositions of the corporate representatives of iHeartMedia, Incorporated, iHeartMedia, and UMG Recordings Incorporated, UMG, which includes Interscope Records, Interscope, a wholly owned division of UMG, for which petitioner respectfully shows as follows. 1. Pursuant to Texas R. Civ P. 190.4, petitioner requests that discovery be conducted under a Level 3 Discovery Control Plan. Factual background 2. Respondent UMG is one of a handful of companies that dominate the multi-billion-dollar music industry. When it comes to the release of new music by its most prominent artists, UMG is meticulous in its planning and execution of the music it releases, promotes, and backs with its considerable financial resources. That is true not just because of the amount of money on the line for UMG and its shareholders, but also because UMG's executives are eligible to receive incentive bonuses based on the revenue generated by their respective divisions. Filed November 25, 2024, 4:21 p.m. Gloria A. Martinez, Behar County District Clerk, accepted by Brenda Carrillo, Behar County, 225th District Court, 2024 CI 26782. 3. Earlier this year, one of the artists that UMG has under contract presented UMG with a new song called Not Like Us. Before it approved the release of the song, UMG knew that the song itself, as well as its accompanying album art and music video, attacked the character of another one of UMG's most prominent artists, Drake, by falsely accusing him of being a sex offender, engaging in pedophilic acts, harboring sex offenders, and committing other criminal sexual acts. Specifically, the song calls Drake a certified pedophile, a predator, and someone whose name should be registered and placed on Neighborhood Watch. 4. Pursuant to its rights under various contracts, UMG has exclusive control over the licensing of Not Like Us and could have refused to release or distribute the song or required the offending material to be edited and / or removed. But UMG chose to do the opposite. UMG designed, financed, and then executed a plan to turn Not Like Us into a viral mega hit with the intent of using the spectacle of harm to Drake and his businesses to drive consumer hysteria and, of course, massive revenues. That plan succeeded, likely beyond UMG's wildest expectations. 5. UMG released the song Not Like Us on May 4, 2024, and its music video on July 4204. UMG relied on its exclusive licensing rights and, in coordination with known and unknown third parties, utilized every tool in its arsenal to spread Not Like Us. 6. UMG made Not Like Us available for radio play, including to iHeartMedia, a mass media corporation headquartered in San Antonio, Texas. iHeartMedia boasts that it is the #1 audio media company in the U.S. based on consumer reach. iHeartMedia claims that it reaches 9 out of 10 Americans every month and has more reach than any other media company in the U.S. iHeartMedia owns iHeartRadio, a freemium broadcast, podcast, radio. iHeartMedia's Incorporated Annual Report, Form 10-K, February 29, 2024. We are Ethereum Media, Mirk Media, Hips, SSO Ekarmadicon Hits /Mev Archive.org UE 20241 119003308 Hips, Hiri Mediacon last visited November 20th, 2024. 2. 3. Earlier this year, one of the artists that UMG has under contract presented UMG with a new song called Not Like Us. Before it approved the release of the song, UMG knew that the song itself, as well as its accompanying album art and music video, attacked the character of another one of UMG's most prominent artists, Drake, by falsely accusing him of being a sex offender, engaging in pedophilic acts, harboring sex offenders, and committing other criminal sexual acts. Specifically, the song calls Drake a certified pedophile, a predator, and someone whose name should be registered and placed on Neighborhood Watch. 4. Pursuant to its rights under various contracts, UMG has exclusive control over the licensing of Not Like Us and could have refused to release or distribute the song or required the offending material to be edited and slashed or removed. But UMG chose to do the opposite. UMG designed, financed, and then executed a plan to turn Not Like Us into a viral mega hit with the intent of using the spectacle of harm to Drake and his businesses to drive consumer hysteria and, of course, massive revenues. That plan succeeded, likely beyond UMG's wildest expectations. 5 UMG released the song Not Like Us on May 4, 2024, and its music video on July 4, 2024. UMG relied on its exclusive licensing rights and, in coordination with known and unknown third parties, utilized every tool in its arsenal to spread Not Like Us. 6 UMG made Not Like Us available for radio play, including to iHeartMedia, a mass media corporation headquartered in San Antonio, Texas. iHeartMedia boasts that it is the #1 audio media company in the U.S. based on consumer reach. iHeartMedia claims that it reaches 9 out of 10 Americans every month and has more reach than any other media company in the U.S. 2 iHeartMedia owns iHeartRadio, a freemium broadcast, podcast, radio. 1 iHeartMedia, Inc., Annual Report, Form 10-K, February 29, 2024. 2 We are iHeartMedia, https://www.iheartmedia.com https://web.archive.org/web/2024111900330/https://www.iheartmedia.com/ Last visited November 20th, 2024. Streaming and music streaming platform. Radio stations all over the country, including stations owned by iHeartMedia, have played Not Like Us. 7 UMG and iHeartMedia have a long-standing, symbiotic business relationship whereby iHeartMedia pays UMG to license and collect royalties for UMG artists' songs over radio airplay and streaming services. As demonstrated by iHeartMedia's bankruptcy filings in 2018, the amount of money exchanged between iHeartMedia and UMG is substantial. In the last quarter of 2023, UMG, through its recorded music and music publishing divisions, had an ownership interest in more than 60% of the 100 songs listed on the Billboard Hot 100 radio charts. Plus, without TS business deals with UMG, iHeartMedia would lose access to a majority of its top radio hits. 8 On the first week of its release, Not Like Us ranked first on Billboard's Hot 100 with S million radio airplay audience impressions. In the week that the Not Like Us music video was released, Not Like Us played on the radio an additional 40 million times. 4 months later, the iHeartRadio leaderboard reported that Not Like Us was among the top 2 songs with the most plays on iHeartRadio stations and explained in a newsletter that it had been. Press release. Iliad Media revolutionizes live radio and introduces on-demand with new services Ilcart Radio Plus registered and Heart Radio All Access. iHeartMedia, September 23, 2016. HSV HeartMedia.com Preciart Midden revolutionizes LV Iridacandi introduces demand new serve IGCPN Radio Plus N, UPS, Perm CEO PZZKCGI. Glenn Peoples, UMG's TikTok standoff affects over 60% off massed popular songs. Billboard, March 1, 2024. TPSWS Billboard Comprof Universal Music Piafteps Majority Most Popular Songs https://perma-cc2wmnbnji** Gary Trust, Kendrick Lamar's Not Like Us blasts in at #1 on Billboard Hot 100. Bill Assard, May 13, 2024. It was a Billboard. Com's Kendrick Lamar Not Like Us Hot 10 November 1 debut NTI Govno 1/https://perma-cc-mrigwbls. Gary Trust, Kendrick Lamar's Not Like Us * returns 0 no. On Billboard Hot 100, Billboard, July 15, 2024. 7 I Hear Radio leaderboard songs with the most plays on iHeartRadio Syrians, Heart Radio, September 27, 2024. TPS Perm. 6 UUXMSOD, iHeartRadio leaderboard songs with the most plays on iHeartRadio stations. 3. Streaming and music streaming platform. Radio stations all over the country, including stations owned by iHeartMedia, have played Not Like Us. 7. UMG and iHeartMedia have a long-standing, symbiotic business relationship whereby iHeartMedia pays UMG to license and collect royalties for UMG artists' songs over radio airplay and streaming services. Point 3 As demonstrated by iHeartMedia's bankruptcy filings in 2018, the amount of money exchanged between iHeartMedia and UMG is substantial. In the last quarter of 2023, UMG, through its recorded music and music publishing divisions, had an ownership interest in more than 60% of the 100 songs listed on the Billboard Hot 100 radio charts. Point 4 Without its business deals with UMG, iHeartMedia would lose access to a majority of its top radio hits. 8 On the first week of its release, Not Like Us ranked first on Billboard's Hot 100. With 5 million radio airplay audience impressions 5 in the week that the Not Like Us music video was released, Not Like Us played on the radio an additional 40 million times. 4 months later, the iHeartRadio leaderboard reported that Not Like Us was among the top 2 songs with the most plays on iHeartRadio stations. 7 And explained in a newsletter that it had been. 3 Press release. iHeartMedia revolutionizes live radio and introduces on-demand with new services iHeartRadio Plus and iHeartRadio All Access. iHeartMedia, September 23, 2016. https://www.iheartmedia.com/press/iHeartMedia revolutionizes live radio and introduces demand new services iHeartRadio Plus and https://perma.cc/9pzz-kcgj. 4 Glenn Peoples, UMG's TikTok standoff affects over 60% of the most popular songs. Billboard, March 1, 2024. https://www.billboard.com/pro/universal-music-fight-majority-most-popular-songs https://perma.cc/2wmn-bnjj. 5 Gary Trust, Kendrick Lamar's Not Like Us blasts in at number 1 on Billboard Hot 100. Billboard, May 13, 2024. https://www.billboard.com/lists/Kendrick-Lamar-not-like-us-not-like-us-no-like-us-no-1 https://perma.cc/mr9g-wbl5. 6 Gary Trust, Kendrick Lamar's Not Like Us returns to number 1 on Billboard Hot 100. Billboard, July 15, 2024.
Please don't do no hyphen.
https://www.billboard.com/lists/Sorry,
y'all.
Not Like Us number 1 second week Hot 100 https://www.billboard.com/lists/Kendrick Lamar Not Like Us number 1 second week Hot 100 https://perma.cc/74fn6exn https://perma.cc/74fn6exn. 7 iHeartRadio leaderboard. Songs with the most plays on iHeartRadio stations. iHeartRadio, September 27, 2024. https://perma.cc/6ux-m59d. iHeartRadio leaderboard. Songs with the most plays on iHeartRadio stations. Heard more than 25 million times across iHeartRadio's platforms alone. As of the date of this filing, the iHeartRadio leaderboard still reports Not Like Us as among the most widely played songs on iHeartRadio stations. Billboard reported that, as of October 7, 2024, Not Like Us reached 45.4 million in total audience impressions on radio with 15 non-consecutive weeks in charge of the R&B/hip-hop airplay list. 9. Radio was only one of the mediums on which UMG relied to spread Not Like Us. Within a week of its initial release, Not Like Us broke the record for the most streamed song in a 7-day period, with 96 million streams. On October 7, 2024, Not Like Us broke the record for the most weeks 21 at number 1 on Billboard's Hot Rap Songs based on streaming, sales and radio airplay. Since its initial release, Not Like Us has been seen and heard billions of times. 10. The record-shattering spread of Not Like Us on streaming, sales, and radio play was deliberate, and appears to have relied upon irregular and inappropriate business practices. iTerk Radio, November 20th, 2024, hips/Beast White Cart. Count playlist here radio leaderboard 3120647502 ALBUSD IGA YSKGTENWNE HTTPS/mebarchive.org way 20241 120182335 TPS Hart Konipla Ishiart Radio leaderboard 3120647502 Alriest 7 Sigal YSKGTE Naan iHeartRadio leaderboard songs with the most plays on It Theory Radio Satins, ICA Radio, November 20th, 2024, hipsmedarchive.org way 20241 101823335 hips, BW Heartcom Pla Ishiart Radio leaderboard 3120647502 ALBUSDI Gal YSKGTENWNE. Asterisk Trevor Anderson. Kendrick Lamar's Not Like Us * breaks record for most weeks in No. On Hot Rap Songs chart, Billboard, October 7, 2024, hits, Billboard.com/music heartbeat Kendrick Lamar Not Like Us #1 record AP Songs Heart 123-579-4635 HPS/Perma CC 4XBBSUQG. Copyright Cedric Thornton, Kendrick Lamar's Not Like Us breaks streaming record. Passes Cardi band Taylor Swift Black Enterprise, May 16, 2024, Hups/VW Black Enterprise Come Kendrick Lamar Not Like Us Steaming Record 1 Anderson, Supernote. 44. Heard more than 25 million times across iHeartRadio's platforms alone. As of the date of this filing, the iHeartRadio leaderboard still reports Not Like Us as among the most widely played songs on iHeartRadio stations. 8. Billboard reported that, as of October 7, 2024, Not Like Us reached 45.4 million in total audience impressions on radio with 15 non-consecutive weeks in charge of the R&B/hip-hop airplay list. 9. Radio was only one of the mediums on which UMG relied to spread Not Like Us. Within a week of its initial release, Not Like Us broke the record for the most streamed song in a 7-day period, with 96 million streams. 10 On October 7, 2024, Not Like Us broke the record for the most weeks 21 at number 1 on Billboard's Hot Rap Songs based on streaming, sales and radio airplay. 11 Since its initial release, Not Like Us has been seen and heard billions of times. 10 The record-shattering spread of Not Like Us on streaming, sales, and radio play was deliberate, and appears to have relied upon irregular and inappropriate business practices. iHeartRadio, November 20th, 2024, https://www.iheart.com/playlist/iHeartRadio leaderboard 3120647502AL825D7GQUY5KGDCNWM/. 8 iHeartRadio leaderboard, songs with the most plays on iHeartRadio stations. iHeartRadio, November 20th, 2024. https://www.iheart.com/playlist/iHeartRadio
I'm sorry, y'all. I mean,
leaderboard 3120647502AL825D7GQUY5KGDCNWM/https://www.iheart.com/playlist/iHeartRadio leaderboard 3120647502AL825D7GQUY5KGDCNWM/https://web.archive.org/web/20241120 121203355/https/www.iheart.com/playlist/iHeartRadio leaderboard 3120647502AL8 do 5D7GQUY5KGDCNWM/9 Trevor Anderson, Kendrick Lamar's Not Like Us breaks record for most weeks at #1 on Hot Rap Songs chart, Billboard, October 7, 2024. https://www.billboard.com/music/chart-beat/kendrick-lamar-not-us-number-1-record rap songs chart 123579463/https://perma.cc/4xbb-cqg 10 Cedric Thornton, Kendrick Lamar's Not Like Us breaks streaming record, passes Cardi B and Taylor Swift. Black Enterprise, May 16, 2024. https://www.blackenterprise.com/kendrick-lamar-not-like-us-streaming-record https://perma.cc/wg7g2wbm https://perma.cc/wg7g2wbm 11 Anderson, Supernote 9. 11 According to one inside source known to petitioner, UMG made covered payments to a number of platforms, including radio stations, to play and promote Not Like Us without disclosing those payments to listeners. This practice, known as payola, is prohibited by the Communications Act of 1934, C 47 U.S.C. 317, 508, and has been the subject of regulatory scrutiny. In 2006, UMG agreed to pay $12 million in a settlement with the New York Attorney General following an investigation involving accusations that UMG executives had used a broad array of pay-for-play tactics to secure radio airplay for music. Separately, in 2005, UMG was sued by 2 radio promotion companies alleging fraudulent pay-to-play practices. 12 petitioner has named of at least one UMG employee making payments to an independent radio promoter, who had agreed to transfer those payments to certain radio stations and/or radio station employees. These radio stations subsequently played Not Like Us and to petitioner's knowledge, did so without disclosing to their listeners that they had been paid by UMG to do so. 13 Petitioner has been unable to confirm whether any iHeartRadio stations were among the stations paid as part of UMG's pay-to-play scheme or whether there were any direct payments from UMG to iHeartRadio to promote Not Like Us. Given iHeartMedia's status as equals preventing payola in the music industry has been a priori for the federal government. For example, in January 2020, TH Federal Communications Commission sent to 3 music companies, including Universal Music Group, seeking prompt information regarding catch companies' practices. Letter rom-coms of Fedcom and Sony Music NT, Warner Music GRP and Universal Music GRP GAN 16, 2020, ipso facto. gov.public/8admins.3619988 Jeff Leeds, Universal Music XLS Big Payola Case, NY Times, May 12, 2006, TPS NewYorkTimes.com May 12, 2006 Using C2 Payols Him Smith equals URL share. https://mebarchive.org Way 200,2401,310,04539 TPS www.newyorktimes.com 20060051 Business Payols Who 1 UMG sued for fraud, Polestar, April 28, 2005, 2:20 a.m., Hips, Polyer.com 2005/0428 said for fraud. PS Perma CE6QHTRK. SC5. 11 According to one inside source known to petitioner, UMG made covered payments to a number of platforms, including radio stations, to play and promote Not Like Us without disclosing those payments to listeners. This practice, known as payola, is prohibited by the Communications Act of 1934, C 47 U.S.C. 317, 508, and has been the subject of regulatory scrutiny. 12 In 2006, UMG agreed to pay $12 million in a settlement with the New York Attorney General following an investigation involving accusations that UMG executives had used a broad array of pay-for-play tactics to secure radio airplay for music. 13 Separately, in 2005, UMG was sued by 2 radio promotion companies alleging fraudulent pay-to-play practices. 1412. Petitioner has learned of at least one UMG employee making payments to an independent radio promoter, who had agreed to transfer those payments to certain radio stations and/or radio station employees. These radio stations subsequently played Not Like Us, and to petitioner's knowledge, did so without disclosing to their listeners that they had been paid by UMG to do so. 13 Petitioner has been unable to confirm whether any iHeartRadio stations were among the stations paid as part of UMG's pay-to-play scheme or whether there were any direct payments from UMG to iHeartRadio to promote Not Like Us. Given iHeartMedia's status as 12, preventing payola in the music industry has been a top priority for the federal government. For example, in January 2020, the Federal Communications Commission sent a letter to 3 music companies, including Universal Music Group, seeking prompt information regarding each company's practices. Letter from ComR of Fed. COMM to Sony Music and Warner Music GRP and Universal Music GRP, January 16, 2020. https://docs.fcc.gov/public/attachments/doc-3619988a1.pdf. 13 Jeff Leeds, Universal Music settles big payola case, NY Times, May 12, 2006. https://www.newyorktimes.com/2025/12/business/12payola.html. 14 UMG sued for fraud. Polestar, April 28, 2005, 2:20 a.m. https://news.polestar.com/2005/04/28/UMG suit for fraud https://news.polestar.com/2005/04/28/UMG suit for https://perma.cc/6qh7-t8k2. The #1 audio company in the country, petitioner believes that UMG engaged in similar tactics to drive radio play of Not Like Us on iHeartMedia stations. 14 UMG also directed its digital marketing team to use discretionary funds provided or reimbursed by UMG to pay unknown third parties to share the Not Like Us song and video in the days after they were released. The purpose of UMG's payments to third parties was to inflate artificially the metrics reported relating to Not Like Us to encourage media and music critic commentary, and, ultimately, to make it go viral. 15 One whistleblower whose identity is unknown revealed publicly that someone from management paid him thousands of dollars on May 6, 2024 to use bots to achieve 30 million streams of Not Like Us on Spotify in the days immediately after its release to turn Not Like Us into a crazy hit. Bots appear to be real social media accounts, but are in fact software programs designed to mimic human behavior. 16 Petitioner has received information that UMG also paid certain third-party influencers to promote Not Like Us. In order to create incentives for high-visibility influencers to spread Not Like Us in what appears to be a radical departure from long-standing anti-emo policy at UMG, UMG removed copyright restrictions on Not Like Us on YouTube and Twitch, thereby whitelisting the song. 17. Petitioner brings this action for a discrete and specific purpose: to understand whether, and how, UMG funneled payments to iHeartRadio and its radio stations as part of a pay-to-play scheme. Petitioner has amassed sufficient facts to pursue certain tortious claims against Jambisco Don, at Lambisco Don, Kendrick Lamar exposed by DJ Academics and Hacker Epic for bot Syrians, YouTube, June 18, 2024. It's /of youtube.com /si pojal type of peak nv equals res w2 we wafir youtube https/perma ccsqqb atgov 66. The #1 audio company in the country, petitioner believes that UMG engaged in similar tactics to drive radio play of Not Like Us on iHeartMedia stations. 14 UMG also directed its digital marketing team to use discretionary funds provided or reimbursed by UMG to pay unknown third parties to share the Not Like Us song and video in the days after they were released. The purpose of UMG's payments to third parties was to inflate artificially the metrics reported relating to Not Like Us to encourage media and music critic commentary, and, ultimately, to make it go viral. 15 One whistleblower whose identity is unknown revealed publicly that someone from management paid him thousands of dollars on May 6, 2024 to use bots to achieve 30 million streams of Not Like Us on Spotify in the days immediately after its release to turn Not Like Us into a crazy hit. 15 bots appear to be real social media accounts, but are in fact software programs designed to mimic human behavior. 16 Petitioner has received information that UMG also paid certain third-party influencers to promote Not Like Us. In order to create incentives for high-visibility influencers to spread Not Like Us, in what appears to be a radical departure from long-standing internal policy at UMG, UMG removed copyright restrictions on Not Like Us on YouTube and Twitch, thereby whitelisting the song. 17 Petitioner brings this action for a discrete and specific purpose, to understand whether, and how, UMG funneled payments to iHeartRadio and its radio stations as part of a pay-to-play scheme. Petitioner has amassed sufficient facts to pursue certain tortious claims against 15 Jambisco Don, at Jambisco Don, Kendrick Lamar exposed by DJ Academics and Hacker Epic for bot streams, YouTube, June 18, 2024. https://www.youtube.com/watch?mark si=POAZLQIBP=v=sign RCSW2W20C&feature youtube.bhttps://perma.cc/8QKB-MX9B. UMG, including, but not limited to, a claim for defamation, but currently lacks factual support necessary to determine whether he may bring claims of civil fraud and racketeering against UMG and its many, as of yet, unidentified co-conspirators who violated payola laws and accepted illicit payments, and other things of value, from UMG without disclosure parties and deponents. 18. Drake is an individual domiciled and residing in Washington County, Texas. 19 iHeartMedia is an audio media company incorporated in Delaware and with a primary place of business in San Antonio, Texas. iHeartMedia's principal executive officers are located in San Antonio, Texas. iHeartMedia, through TS Radio division iHeartRadio, operates more than 60 radio stations in Texas, including 9 in San Antonio, 8 in Dallas, and 7 in Houston. iHeartMedia may be served via its registered agent, CT Corporation System, at 1999 Ryan Street Suite 900 Dallas, Texas, 78258. 20 UMG is a wholly owned subsidiary of Universal Music Group NV, a publicly owned limited liability company incorporated under the laws of the Netherlands. Interscope is a division of UMG. UMG regularly conducts business in Texas, including through contracts and agreements with iHeartMedia and other music-related corporations in the state. UMG may be served through the Texas Secretary of State. Pipes plus White Card Middies Constitutions. Market equals Houston TXHPS/perm SCWGTG2WBM, N7. UMG, including, but not limited to, a claim for defamation, but currently lacks factual support necessary to determine whether he may bring claims of civil fraud and racketeering against UMG and its many, as of yet, unidentified co-conspirators who violated payola laws and accepted illicit payments, and other things of value, from UMG without disclosure. Parties and deponents. 18. Drake is an individual domiciled and residing in Washington County, Texas. 19 iHeartMedia is an audio media company incorporated in Delaware and with a primary place of business in San Antonio, Texas. iHeartMedia's principal executive officers are located in San Antonio, Texas. iHeartMedia, through its radio division iHeartRadio, operates more than 60 radio stations in Texas, including 9 in San Antonio, 8 in Dallas, and 7 in Houston. 16 iHeartMedia may be served via its registered agent, CT Corporation System, at 1999 Bryan Street Suite 900 Dallas, Texas, 78258. 20 UMG is a wholly owned subsidiary of Universal Music Group NV, a publicly owned limited liability company incorporated under the laws of the Netherlands. Interscope is a division of UMG. UMG regularly conducts business in Texas, including through contracts and agreements with iHeartMedia and other music-related corporations in the state. UMG may be served through the Texas Secretary of State. 16 listening platform, our stations, Houston stations, iHeartMedia, November 20th, 2024. https://www.iheartmedia.com/stations market Houston -tx https://perma.cc/wg7g-2wbm. Jurisdiction and venue 21. This court has personal jurisdiction over iHeartMedia because it maintains its principal place of business in San Antonio, Texas. 22. This court has personal jurisdiction over UMG. This petition arises out of UMG's continuous and extensive business activities in the state of Texas, including doing business and entering into contracts with Texas-based iHeartMedia for the specific purpose of misleading the residents of Texas about how radio stations are choosing what songs to play and the song's popularity. UMG also avails itself of Texas by directing distribution, marketing, licensing, and other business activities to Texas residents, such that Texas residents may purchase, download, and stream music, including Not Like Us in the state, and selling, promoting, and paying third parties, some of whom are believed to be in the state, to play songs, including Not Like Us, for radio airplay. UMG seeks out and derives substantial benefits and profits from these activities in the state and in San Antonio. Accordingly, UMG is subject to personal jurisdiction under the provisions of the Texas Long-Arm Statute, Texas Civ Prug, and REM Code 17.041 F-Sec. It would be reasonable for this court to exercise jurisdiction consistent with principles underlying the U.S. Constitution, and the exercise of jurisdiction by this court would not offend traditional notions of fair play and substantial justice. 23. This court has jurisdiction over this matter because a substantial part of the events giving rise to the claims that petitioner seeks to investigate occurred in Behar County, and these potential claims are within the jurisdictional limits of this court. 24. Venue is proper in Behar County pursuant to Texas Civil Practice and Remedies Code 15.002, 1, and 3. And Texas Rule of Civil Procedure 202.2 because a substantial part of the underlying events that would give rise to the claims being investigated occurred in Behar County, and iHeartMedia resides in Behar County. -58. Jurisdiction and venue 21. This court has personal jurisdiction over iHeartMedia because it maintains its principal place of business in San Antonio, Texas. 22. This court has personal jurisdiction over UMG. This petition arises out of UMG's continuous and extensive business activities in the state of Texas, including doing business and entering into contracts with Texas-based iHeartMedia for the specific purpose of misleading the residents of Texas about how radio stations are choosing what songs to play and the song's popularity. UMG also avails itself of Texas by directing distribution, marketing, licensing, and other business activities to Texas residents, such that Texas residents may purchase, download, and stream music, including Not Like Us in the state, and selling, promoting, and paying third parties, some of whom are believed to be in the state, to play songs, including Not Like Us, for radio airplay. UMG seeks out and derives substantial benefits and profits from these activities in the state and in San Antonio. Accordingly, UMG is subject to personal jurisdiction under the provisions of the Texas Long-Arm Statute, Texas Civ Prug, and REM Code 17.041 ET-Sec. It would be reasonable for this court to exercise jurisdiction consistent with principles underlying the U.S. Constitution, and the exercise of jurisdiction by this court would not offend traditional notions of fair play and substantial justice. 23. This court has jurisdiction over this matter because a substantial part of the events giving rise to the claims that petitioner seeks to investigate occurred in Behar County, and these potential claims are within the jurisdictional limits of this court. 24. Venue is proper in Behar County pursuant to Texas Civil Practice and Remedies Code 15.002, 1, and 3, and Texas Rule of Civil Procedure 202.2 because a substantial part of the underlying events that would give rise to the claims being investigated occurred in Behar County, and iHeartMedia resides in Behar County. Request to depose 25. Rule 202 permits a party to investigate potential claims via pre-suit depositions. Rule 202 functions in aid of a suit which is anticipated and ancillary to the anticipated suit. J. Henry Wolf, 341 S.W.3D 932, 933, Texas 2011, per curiam. Depositions under Rule 202 are governed by the rules applicable to depositions of non-parties in a pending suit, Rule 199.2, b. 5, and the scope of discovery in depositions authorized by this rule is the same as if the anticipated suit or potential claim had been filed. Texas R. Civ. P. 202.5. 26. Here, the limited Rule 202 depositions petitioner proposes are the most efficient method for him to understand the role of iHeartMedia in UMG's scheme to unlawfully promote Not Like Us. Based on the minimal information already available to petitioner, the testimony sought is necessary for petitioner to understand and evaluate his potential claims. 27. Because petitioner only seeks this limited testimony, the benefit of allowing petitioner to take the requested depositions outweighs any associated burden or expense to iHeartMedia and UMG. Moreover, the interest of justice is served by allowing petitioner to investigate potential claims before filing these depositions are necessary, as part of the requirements of Texas Rule of Civil Procedure 13, for petitioner to make an informed decision about any future legal action. 28. Petitioner seeks an oral deposition of iHeartMedia by a corporate representative, S, to investigate evidence of UMG's provision of financial benefits to iHeartMedia in exchange for obtaining airplay of Not Like Us to spread the song to billions of listeners, and to lean the identities and practices of any direct participants in a pay-to-play scheme, including any intermediaries who may have been involved. -9. 9. Request to depose 25. Rule 202 permits a party to investigate potential claims via pre-suit depositions. Rule 202 functions in aid of a suit which is anticipated and ancillary to the anticipated suit. In Re Wolf, 341 S.W.3D 932, 933, Texas 2011, per curiam. Depositions under Rule 202 are governed by the rules applicable to depositions of non-parties in a pending suit, Rule 199.2, b. 5, and the scope of discovery in depositions authorized by this rule is the same as if the anticipated suit or potential claim had been filed. Texas R. Civ. P. 202.5. 26. Here, the limited Rule 202 depositions petitioner proposes are the most efficient method for him to understand the role of iHeartMedia in UMG's scheme to unlawfully promote Not Like Us. Based on the minimal information already available to petitioner, the testimony sought is necessary for petitioner to understand and evaluate his potential claims. 27. Because petitioner only seeks this limited testimony, the benefit of allowing petitioner to take the requested depositions outweighs any associated burden or expense to iHeartMedia and UMG. Moreover, the interest of justice is served by allowing petitioner to investigate potential claims before filing these depositions are necessary, as part of the requirements of Texas Rule of Civil Procedure 13, for petitioner to make an informed decision about any future legal action. 28. Petitioner seeks an oral deposition of iHeartMedia via corporate representative, S, to investigate evidence of UMG's provision of financial benefits to iHeartMedia in exchange for obtaining airplay of Not Like Us to spread the song to billions of listeners, and to learn the identities and practices of any direct participants in a pay-to-play scheme, including any intermediaries who may have been involved. iHeartMedia, Inc. 20880, Stone Oak Parkway, San Antonio, Texas, 78258210822. 822-282829. Petitioner seeks an oral deposition of UMG via corporate representative, S, to investigate evidence of UMG's conspiracy to increase radio play for Not Like Us by providing iHeartMedia with financial benefits and to lean the identities and practices of any direct participants in a pay-to-play scheme, including any intermediaries who may have been involved. BUMG Recordings Incorporated, 2220, Colorado Avenue, Santa Monica, California, 90404814389, 6366130. Critical evidence relevant to petitioner's potential claims, including the identities of potential defendants, is not available to him. The benefit of allowing the requested deposition outweighs the burden or expense of the procedure. 31. Texas R. Civ. P. 202 enables a person to petition the court for an order authorizing the taking of a deposition to investigate a potential claim or suit. Texas R. Civ. P. 202.1 b. A. Court must order a deposition requested if it finds that the likely benefit of allowing the petitioner to take the requested deposition to investigate a potential claim outweighs the burden or expense of the procedure. Texas R. Civ. P. 202.4 a. 2. 32 Critical evidence relevant to petitioner's potential claims, including, but not limited to, the identities of unknown defendants, is not available to him and, without the requested deposition, he may be unable to pursue such claims. 33 For the reasons set forth above, petitioner avers that the likely benefit of allowing petitioner to take the requested deposition to investigate potential claims outweighs the burden or expense of the procedure. 1010. iHeartMedia, Inc. 20880, Stone Oak Parkway, South San Antonio, Texas, 78258210822, 282829. Petitioner seeks an oral deposition of UMG via corporate representative, S, to investigate evidence of UMG's conspiracy to increase radio play for Not Like Us by providing iHeartMedia with financial benefits and to learn the identities and practices of any direct participants in a pay-to-play scheme, including any intermediaries who may have been involved. BUMG Recordings Incorporated. 2220, Colorado Avenue, South Santa Monica, California, 90404814389, 6366130. Critical evidence relevant to petitioner's potential claims, including the identities of potential defendants, is not available to him. The benefit of allowing the requested deposition outweighs the burden or expense of the procedure. 31 Texas R. Civ. P. 202 enables a person to petition the court for an order authorizing the taking of a deposition to investigate a potential claim or suit. Texas R. Civ. P. 202.L. B. A. Court must order a deposition requested if it finds that the likely benefit of allowing the petitioner to take the requested deposition to investigate a potential claim outweighs the burden or expense of the procedure. Texas R. Civ. P. 202.4 a. 2. 32 Critical evidence relevant to petitioner's potential claims, including, but not limited to, the identities of unknown defendants, is not available to him and, without the requested deposition, he may be unable to pursue such claims. 33 For the reasons set forth above, petitioner avers that the likely benefit of allowing petitioner to take the requested deposition to investigate potential claims outweighs the burden or expense of the procedure. Authority for depositions. 34. Texas R. Civ. P. 202 enables a person to petition the court for an order authorizing the taking of a deposition to investigate a potential claim or suit. Texas R. Civ. P. 2021, b. A court must order a deposition requested if it finds that the likely benefit of allowing the petitioner to take the requested deposition to investigate a potential claim outweighs the burden or expense of the procedure. Texas R. Civ. P. 202.4, a. 2. Other interested persons. 35. Petitioner is unaware of other interested persons at this time. Prayer for Relief 36. Petitioner respectfully requests that the court issue an order setting a date for hearing on this petition with at least 15 days notice, and after that hearing, issue an order, A, requiring iHeartMedia's corporate representative, S, to testify by oral deposition related to the matters described herein, B, requiring UMG's corporate representatives to testify by oral deposition related to the matters described herein, and C, for all other relief, aid, law, or inequity, to which petitioner may be shown to be justly entitled. November 21, 2024 respectfully submitted, Ahmed, Zavitsanos, and Mensing PLLC. /S/John Zavitsanos, Texas, bar number 22,251,650 JRAVIT Sanos at azala.com. Daryl Moore, Texas, bar number 14,324,720 D. Moore at azala.com. Monica Eden. N11. Authority for Depositions 34. Texas R. Civ. P. 202 enables a person to petition the court for an order authorizing the taking of a deposition to investigate a potential claim or suit. Texas R. Civ. P. 202.L. B. A court must order a deposition requested if it finds that the likely benefit of allowing the petitioner to take the requested deposition to investigate a potential claim outweighs the burden or expense of the procedure. Texas R. Civ. P. 202.4, A. 2. Other interested persons 35. Petitioner is unaware of other interested persons at this time. Prayer for Relief 36. Petitioner respectfully requests that the court issue an order setting a date for hearing on this petition with at least 15 days notice, and after that hearing, issue an order, A, requiring iHeartMedia's corporate representative, S, to testify by oral deposition related to the matters described herein, B, requiring UMG's corporate representative, S, to testify by oral deposition related to the matters described herein, and C, for all other relief at law or inequity, to which petitioner may be shown to be justly entitled. November 21, 2024 respectfully submitted, Ahmed, Zavitsanos, and Mensing PLLC. /S/John Zavitsanos, Texas, bar number 22,251,650 JZAVIT Sanos at azala.com. Daryl Moore, Texas, bar number 14,324,720 D. Moore at azala.com. Monica Eden. State bar number 24,075,195 Muddin at azala.com. Michael Killingsworth. State bar number 24,110,089 M. Illingsworth at azala.com. 1221 McKinney Street, Suite 2500. Houston, Texas 77010. Telephone 713-655-1101. Facsimile.
Okay, that's it. Ooh, I am sorry. Oh boy. Well, like, I don't know what's the problem with Drake and his foolishness. I may not do TD Jakes because I'm really tired. I had to make up my mind whether or not I want to hit this road or not. Really don't want to, but I don't know. I'm so nosy about this TD Jake shit, right? This is crazy. Oh, they talking about Mike Dicker in hospice. God damn. Boy, I'll be glad when this year is over with. But this is crazy. Hold on. TD Jakes got a whole bunch of them wwws and all that shit on there, and I ain't got time for that tonight because I can't go through that. So let me modify my title. I ain't do it last night. I ain't got to do that. I remember that I didn't do what I said I was gonna do tonight. But check this out, right, honey. That's all, folks. I listen. All I saw was TD Jakes on my damn timeline. Still, I'm like, well, what is happening? What's wrong with TD Jakes? It's been some shit. Like, what? What the hell is happening? Right, baby. TD Jakes on my timeline. Still, with the microphone. I'm like, what? Let me see. What they if Mr. Combs got any good news or any news before I get up off here. It's crazy. They locking them up. Mm-mm. Yeah, I don't have nothing new. Nothing new, guys. Let me see. I believe that Dwayne guy is a legend. You think TD Jakes did that to him? Girl, I just hate putting shit like that on people. But now, hold on. Let me ask you this. Did this Dwayne guy sue TD Jakes? See, we got to get some more people on the Information Bureau. Because as you see, they ass sleep or getting ready for Thanksgiving. Oh, it is a lawsuit. Well, let me see if I can find this Dwayne Youngblood lawsuit. Let me see if I can find that. Let me see if it's in Fed. I hope it ain't in Texas, because that's gonna be too goddamn. I don't know where they are in Texas, and I would have to look. Let me see. Hopefully it's federal. Hopefully it's federal. And then Red Bunny, are you going to keep up with YFN? Because you know this YFN case is tied to YSL. But now we gonna be able to jump ahead of it because I was lost with the YSL because you know I done jumped in and in the middle of the shit and people had took deals and all that and whatever and the cases were severed and I ain't know. I just come in the middle of it. Right? I didn't even know that the case you know, oh, girl, I don't know. So, but we gonna have to keep up because if the people are snitching and stuff, taking deals, we got to know about that. No, I cannot pull up. Paste. I'm kind of brother. Get away from. Let me see. Oh wait, I think I already. Mm-mm. It's 25 pages. Damn. So it wasn't federal. Child, let me get off here and try to find this lawsuit. What? Correct. So maybe that's why his ass stroked up on the microphone. But here's the thing, right? When you are trying to sue for defamation and a person ain't got shit, I'm gonna put this on the wall. You are wasting your time. You're gonna be out of money and you are wasting your goddamn time. So I don't know. Mm-mm. I don't know, girl. It was on Larry Reed. I've heard that name before. Larry Reed. Let me see if I can take a look at his face and see who he is. Oh, let me see. Larry Reed. I ain't never seen this man before. I ain't never seen this man face before. I don't know him. Let me subscribe so I can follow this because I don't know nothing about this. Girl, you doing better than the damn so-called people on the Information Bureau because they asked somewhere else. Even the one that talking about, girl, girl, go, go live. Her ass is somewhere asleep. And the other one, her time is somewhere from across the world. Like, when the other two information specialists, I mean, I can understand what was going, like they terrible. We are hiring. 'Cause this is ridiculous. I didn't know what happened. All I saw was Diddy Jake stroked out. I'm like, wait a minute. I'm like, Diddy is the jank, girl. Diddy is the damn jank. He is the jank. You know what that mean, Red Bunny? The jank. He is the jank child. Hey, when with Diddy, your ass gonna go to jail or worse, but nothing can come good. He got everybody name in paperwork. My baby, see, breezy. People just from the industry was like, go did at the party, at the white party, like, go did it, go did. Now they like, that's silence. Hey, I don't know what's going on, girl. Girl, I don't know what the hell is going on. It is the damn jank. Is that Armand Williams? Oh no, I need I can't see. I be faking like I can see. But this is on the closer computer. And this dude, I'm looking at Larry Reed's little, where you show the different lives with his latest, popular, and oldest. And this is a dude on here with a suit on, look like Armand Wiggins from over here. But hell, well, what Larry black pastors that voted for Trump? Is he one of them? Oh, girl, I ain't gonna be able to do. Let me unsub, baby. I got a call. That's what I might put on in this and be done with it. I'll do that. I'll put that in my. Oh my gosh. I'll do that and then I'll ride out on that. I don't know what had happened with your boy. Yeah, I don't know him. Yeah, but talking about pastors who voted for Trump. I don't know nothing about all that. Yeah, I might have to unsub from him. But I might have to sub right now because apparently he got the information, right? Brother told me. Why they got Pastor Keon on here? He done something. It's this channel, and it's not. I know it's Larry Reid, dude. I don't think so. But it's this channel that be keeping up with what these pastors be doing and stuff like that. I don't think it's Larry Reid, but like when these pastors be killing folk, be cheating on their spouses, and we be on the down low and all that shit. hmm But yes, y'all. I'm gonna play this and I'm gonna be out. We still mad about the election. That's all I want to illustrate. We still talking shit. We still mad. People he put on the cabinet is racist.
Where the rapist decided to step down. What was his name? Wentz or something like that. Having sex with young girls and all that.
Matt Gaetz.
Yeah, Gaetz, yeah.
Oh, from Florida. Okay.
Yeah, he stepped down. Put Pam Bondi on there. I think Marco Rubio. And for some reason, all other immigrants got to get out of here for Cubans in the state. I don't get that. And who else he put on there? Oh, that was racist ass dude talking about he's going to be over like the immigration and all that. He already talking about sending them up out of here. The vice president, look at here. The vice president is a rapist. I mean, a racist. And so, man, it's just, yeah, man, I'm not even going. Like that day, every time I see him on the news, I turn the TV. I don't want to see him.
Right.
I just, because I ain't seen Vice President Harris come out and say nothing. And I know that lady probably cried that night because these motherfuckers didn't vote for him. Man, I did.
Yeah.
Stupid ass niggas who voted for Trump.
Yeah, I've been on a warpath. I'm letting you know we got a problem. I'm throwing hands, huh? What'd you say?
Friends voted for Trump. You can't be friends no more.
I know that's right. You stand for something. I know this some bullshit. This is definitely.
If you're a white person, you know how racist he is. So do you think the same way? And if you're a black person who voted for Trump, what more did that cracker have to say about us? You know what I'm saying? For y'all to vote for him.
Just dumb as hell. Just dumb as hell.
Since I heard his name, ever heard of Donald Trump? He's been racist. I go back to the Central Park thing. He was talking about, he took out a whole ad in the newspaper, in the New York Times, talking about execute them brothers. And knowing they had done what they were, man, but he always, when he was the president the first time, when he won the first time, he told all them NFL, he told them to get them sons and bitches back on the field and all that, man. Come on, man. Yep. You around here living in a ragged ass trailer and all that, cold as hell in your house, cold as fuck in your house. And you got a big ass Trump flag and he don't care nothing about you.
Right.
He just say stuff y'all thinking y'all hard, but y'all too scared to say. But now they coming out of the woodworks and saying it. Like that shirt that said, don't let your president get your ass kicked.
It's a shirt that say that.
Yeah, it's a shirt, but you know what? Silver Whips, when he won the first time, Silver Whips, when she was on Tom Jordan, she said, all right, don't let your president get your ass kicked. And now somebody that made that shirt.
Oh, wow. I know that's right. I know that's right. It's just, you know, I mean, I don't care. I don't know.
And, you know,
I
my
miss
cousin
it.
girlfriend, she voted for him.
Mm-hmm.
My cousin girlfriend, she voted for him. She voted for him. You talking about Trump gonna put money in your pocket, talking about the economy was good with Trump. It sure was when he first got in there, because Obama left him a good economy.
Yeah.
It sure as hell was. Obama told him about COVID. Trump telling people drink bleach.
Yeah.
Okay.
His crazy ass.
Yeah, man. I do not call him president and put his name in the back of it. I do not do it. He's the most unpresidential president I can remember in my lifetime.
Yeah. Just dumb shit.
Shit. I mean, his wife, I'm going to tell you how stupid he is. He was making a speech somewhere and said, Michelle Obama, people love her. And, you know, white people boo in and shit. Said, well, people love her. And she made a speech, and it was a great speech. Everybody loved it. He said, my wife, Melania, did the same speech, and nobody liked it. That just shows how stupid he is. She did the same speech whatever First Lady did. And you know what I'm saying? He can't understand why nobody liked the speech. Because she did somebody else's speech.
Yeah.
You know, but so all you niggas that sat on your ass and didn't go out and vote, I don't want to hear nothing.
Not a goddamn, because like a no vote was a vote for him. Then the people that voted for him, and I don't know where all them Latinos or whatever come from, but that's fine. But the black women, we unavailable. We don't want to march. We don't care about no black lives. We don't care about none of that. I don't care. Okay, whatever. They shoot you in the streets. Okay, what you want us to do?
Yeah, exactly. Because he told me giving the police 100% immunity. So they can come out and shoot up 50 people for no reason. They ain't got no problem with me. The Trump will say. You know, so yeah, you know, y'all gonna see. This gonna be the first 4 years of your damn life.
Listen, I might just go back to work and when you call me about some shit, what you want me to do about it? They done shot you. What you want me to do about it? I hang up. Shit. Fuck you. Fuck you. Like, what the hell? That don't make no damn sense. That don't make no sense, boy.
I remember last time me and you talked, you said you were going somewhere, and somebody in your family had a Trump thing when they come. You know what I'm saying?
Yeah, at the funeral. And my baby was like, wait a minute, who got that Trump at the funeral? My baby said, who got that Trump sign? Because they were some kid up. I'm like, Chad, that's your cousin. Well, I knew he was gonna vote for Trump, because you know, he ain't been black since he was born, to be honest. So that don't mean that, but I'm just saying. So I already knew that. He's black, but he ain't been black.
This man could say anything about he want to say about the black community. And the people in Michigan voted for his ass, and he said they're turning Detroit into Detroit. I said, how stupid is that? You know what I'm saying? So okay. Yeah, all you Latinos, all y'all voted for him. Y'all will be the first one.
On that boat. Don't call us. We don't have nothing for no Latino lives matter.
My black brothers, help us. We are brothers. Man, fuck you.
Okay. Everybody got time for this. This is ridiculous.
I hope he sent it back.
Yeah.
They deserve to go back, but it's going to flip this economy up big time to go back.
Yeah. Go ass out of here.
The illegal immigrants are taking all the black jobs, so what is a black job?
Thank you. Just say anything. It's crazy, boy. I'm learning when I tell you, I was like, oh my God. I was having 2016 all over again. I couldn't move.
Me too. I was mad. I was sad the next morning when I got to work, man.
Yeah.
I was sad.
Because you were a good one.
What more does this sister have to do? She was way more qualified. What?
Exactly. Exactly. But the thing about it is America, they're not ready to elect a woman yet. We still have.
And especially a black woman.
Exactly. Exactly. So you know we elect a white one. You know damn well. Yeah. You want to elect the black. Come on now. You know, they're not ready.
This woman went across the aisle. She said, when I'm president, I'm not just going to look at Democrat people to be on my cabinet.
Yeah.
You know what I'm saying? So she's trying to cross the aisle and all that. And you know what? When Tim started buying dollar ass at, they campaign for a big time. They didn't put their ass on the cabinet no damn well.
He got that Elon Musk. See, the thing about it is with him, favoritism and stuff like that. You scratch my back, I scratch yours. See, that's dangerous for this world. That's dangerous. Like I can't. I be trying, but I just don't say, woo, go Trump. That's gonna get you cussed out. If we cool, that's gonna get you red. Just don't even get on the topic with me.
Yeah, I do that type of stuff. Hey, let me leave, man. Brother, put your ass like Trump.
I'm gonna drink my water. Yeah, let me whip your ass. I'm just saying this is gonna be a good ticket to whip your ass. I'm not, but Tim, see, you already know me. I'm not going nowhere where I think politics gonna be a topic, because it's going to go the wrong way. Because I be in them blended situations, okay, where some of them people might be Trumpers. I'm just trying to say, don't say shit, because it's gonna get your ass beat today, okay? I'm gonna have a flashback. I'm gonna recall the spirit of Martin Luther King and Malcolm X and all of them. I'm gonna get your ass out of here.
I just really want, white people, what I'm saying? Okay, y'all do what y'all do. Y'all know that woman was way more qualified. She's not gonna vote for a woman. They're not gonna vote for a black woman, especially white women. They ain't gonna vote for a woman. They like being told what to do.
Uh-huh.
You know what I'm saying? Like for a man to be in charge. You know what I mean? Fox, this dude was on Fox. They were so racist to the lady when they were talking about the general's gonna have their way with her when she's in the conference room by herself. I said, what the fuck?
Yeah.
Nobody was fighting for that. You know what I'm saying? Nobody was fighting for that. You know, so man, and then our own people let her down. She's not really black. She went to Howard. You don't get no blacker than that.
Yeah, and my thing is, what does that even matter?
Exactly.
Like, what does that even matter? I mean, everything is off. It seems like Thanksgiving is gonna be late. It was late. You know what I'm saying? It's everything seems off. It's everything.
January 20th gonna get around here so fast. Oh, it's gonna get that fast.
And I'm thinking deep. I said we should have a insurrection.
I mean, they get it.
Right. I'm thinking deep. I'm like, Lord have mercy, no. Yeah, I'm like. Exactly. Well, we've been gone. But yeah, we get out of there. Yeah, but that's crazy though. I couldn't believe it. I was expecting it, but I was like, well, okay.
You know what, I wasn't expecting it until they kept talking about how close it was. I said, well, how can this be so close? You know what I'm saying? I mean, you look at the Republican convention. That looks nothing like America. All you see is white people out there. You look at that Democratic convention, that looks like America. Black, brown, white, all.
Yeah, everybody, representing all races and all, everybody. And Oh, boring ass shit.
Whoever goes into this house or this city, you better not go in there fucking with Jasmine Crockett, because she gonna let y'all know what time it is. You know what I'm saying?
Oh yeah, she is real funny.
Man, I love Jasmine Crockett. That's a sister you want on your team.
Yeah, she's real funny. We just, you know, I mean, us, you and I, whatever, we just ain't used to people and it's so fucked up. Like, what is going wrong? It's going down the wrong path. I'm like, I got another picture of you too. I got to find it. It's my.
Hold on for a minute. Hold on.
All right. But we stay in sync. I'm getting triggered. I can't talk about problems. Getting triggered. Woo woo. Seems like we need to address these people, mama and daddy, because they did a poor job with you motherfuckers. Poor job. That's me still on the call. That's not me talking right now. That's me still on the call.
Okay,
Yeah. Yeah, these people crazy. I mean,
I don't understand it. Young people that didn't get off there. Man, this man talking about cutting Medicare, Medicaid. Just older people. You know what I'm saying? Or people that can't work no more because of pre-existing medical problems.
Right.
Well, you talking about cutting the Department of Education.
Yeah, okay.
We already so far behind the rest of the world when it comes to our kids' education. Now you're going to cut that. I mean, Head Start and all that shit going.
Yeah.
Now, who does that affect?
Right. Yeah.
You talking about, this woman was talking about giving these sorry-ass women an extra $6,000 to help pay for daycare. Because what you call it, what it made, J.D. Vance said, well, get the grandparents to watch out, watch the kids or whatever like that, and aunts and uncles. But grandparents are still working, and aunts and uncles are still working. You know what I'm saying? So, you make a daycare is too expensive. These people don't want to get off their ass and vote. They don't see.
You know, and you just said something that is an example that happens all the time when it comes to politics and when it comes to passing these bills, right? They will pass a bill, right? Like to shut down the Department of Education. But what it does is there's an undertone there, right? It casts who it affects. You understand what I'm saying? So they know exactly what they're doing. They know who it's going to affect. Like, you know, like when they be all with that vote and shit, who can vote, what you need to bring, whatever. They knows who it affects.
Yep.
Okay? So it don't
shit. If I had a friend that had one felony, he can't vote, but a motherfucker that got 34 felonies, he can be president.
Yeah. Come on now. It don't make a bit of sense. Yeah. But baby, I hope Trump put something on them motherfuckers. I hope they can't even afford to buy bubble gum. I'll be like, I'll be pointing.
She was putting in a plan for people to help with first-time home ownership. You know what I'm saying? No, they don't want to. No, they don't want to go for it. No, see, it was just so much that lady was trying to do. You know what I'm saying? But he was totally the opposite against it. And these dumbass people think that because he signed his name on the stimulus checks that they came from him. They did not come from him. They came from the Democratic-led House of Representatives doing it when he was the commander-in-chief. He fought that. So he finally passed it and signed the damn checks.
And the reason why he doesn't have a plan to pay for programs and all that type of stuff and stuff that help America, because he don't plan to help America. That's why he don't have no plan when you ask him. He always says it's going to be beautiful. It's going to be good. We're going to rebuild. Yeah. How? What you going to do specifically? Tell me what you going to do.
And when I hear Make America Great Again, when is it being great for black people?
Shit.
When is it being great for us?
You know, yeah, make it, but no, that's dog whistle. That's dog whistle when Obama was. That was right after Obama. When he come up with that bull skate. You know what that means? He gonna, get America back and all this bullshit. Yeah. All that bullshit. But no, but baby, I'm telling you, Tim, I'm telling you, I cannot be outside right now. Because a motherfucker say somebody, you know me. You 100%. I fight when it comes to black and white, when it comes to bullshit. 100, I don't give a damn about none of that. What I'm putting on the line, I don't give a damn about none of that. Because I stand for something. I'm going to punch in your face. I'm telling you. Okay? That's what's going to happen. I'm going to beat your ass. I got to find me one of them shirts. Don't let that person get your ass beat. Like that.
You got TikTok? I think that's what I see today.
Oh, okay. Well, what you doing on there, baby? I couldn't get you on Facebook or nothing, but you on the TikTok.
You know what? I just watch videos. I don't comment or post nothing like that.
Baby,
videos like that. And I like looking at them Zulu women. Oh my goodness.
What Zulu women?
What are the Zulu women from the Zulu tribe? What is so beautiful? They always have on those shirts.
He's so ignorant.
Yeah, man. I just look at funny videos and stuff like that. They will make you smile at somebody. And I listen to like Nephew Tommy, Uncut, Frank phone calls. I bought some cologne off there. It smells real good.
No, for real. Have you ever worn Clive Christian? Oh, okay.
Your mother some Christmas?
Huh?
My mama say, if you say, oh, you
baby, listen, I've been trying to find a discount, baby. I'm going to figure something out. Some of that, boy, let me tell you, they got a bottle in there for $800. All right. So, I've seen it at the, you know how they have them, those perfume emporiums with, they be real legit. Don't you know your mama checks that shit out, and I found where they got like 40% off from that. But that's crazy, yeah. But they got different. Let me tell you something. The bottles have gold and crystals and diamonds and shit. I'm like, oh shit. Real gold and diamonds and shit.
By Fabergé and Old Spice.
Boy, you don't wear that shit.
And I mix it all together. Old Spice, fruit, and English leather. I call it Old Spice with the leather.
Boy, shut up. Your ass don't wear that.
Going up to the Marquee Lounge.
No, baby, you have a sister in some places, baby. I'm good. Y'all be going in some places, honey.
I ain't been nowhere in a while. Larry came by Saturday. And you're like, man, let's go to the Marquee Lounge. I said, I ain't.
Oh, God.
They had that bottle of Douce around there, some Modelo's. Shit, yeah, I got kind of tips. I said, I'm good, bro. I'm going to go play with this bed by 8:30. Shit. Yeah, I don't be going nowhere.
Are you walking around with like I think it's a style thing or something. But everybody's walking around with the Don Julio drinking it out the bottle.
I know. The last tequila I brought was Casamigos, George Clooney's tequila.
Oh yeah, they like Casamigos too. But I be keeping up. I don't drink. But I be keeping up though. But yeah, I think it's a style thing. They just walking around with the Don Julio, draining it out the little cute bottle. I'm like, well, why is y'all doing that? And I was like, oh, that's what it is. Huh?
Some young people in it.
No. Not. They like 40-something, 50-something. No, style thing.
Huh?
Style thing. Trend.
Style,
It's a
what?
trend. Style thing. It's a trend.
Yeah, I don't need no trend like that.
You stick with what you drink now?
I drink Douce, liquor, and I drink every now and then I get tequila to take some shots.
So Douce is a what?
Cognac.
Oh, that yak.
And I go to Sam's, and it's a lot cheaper than the Remy at Sam's. It's a lot smooth. It's a lot smoother. I know Shannon Sharp has his own, man, but I'm not paying $113 for a bottle of liquor.
That's cheap, but ain't cheap. That's mid range.
For a fifth. No, that Douce has cost me about $42. It's real smooth.
Wow, okay.
Yeah, but she cut these already. He doing this damn construction up here. They ain't let this man go yet.
Parking lot pimping.
I don't. I drank me a cold Modelo. Do say I may have me a little sip tonight when I get home. 2 more days of work.
I know that's right. My family got another picture of your ass. I'm like,
yeah?
Some shit, yeah. I'm like,
where was I at on that picture?
I don't know. They got it.
I ain't have glasses or nothing.
I was like, where y'all get? I'm gonna look this snapping. Yeah, they another picture of your ass.
You already had that picture?
My family gave it to me. My family gave it to me when I went to my cousin's funeral. We was going through pictures, and I was like, wait a minute, y'all got a picture?
How you got a picture of me?
Well, because you was with me to something we was doing, something we was having. Yeah, and I was like, they got pictures of all, a lot of people in my non-traditional, I call y'all my non-traditional family, more than friends, but not blood.
Non-traditional, I talked to short dog the other day for about an hour.
For real, what are you talking about?
Yeah, we were just talking, about a whole bunch of stuff. We were talking, and it was about an hour sitting out there in my driveway on the phone talking to short dog. I hadn't talked to him that long in a while.
Oh wow, I ain't talked to him.
Somebody's daughter is in college now.
Yeah.
So we just talked a whole bunch.
Yeah, I saw it. I have a graduation picture.
My Gina K. Cook.
Oh yeah.
She don't know how to iron. She don't know how to iron. I said, Tony, she just telling you that she did. She just put her clothes in the cleaners.
Yeah. But you know what? No, I got her graduation pictures and stuff. She looked just like Short Dog. Yeah, she looked just like Short Dog. I was like, Lord have mercy. There were band pictures, a lot of little pictures and stuff. Yeah, he's talking about Jenny can't cook and iron.
Yeah, that's what he said, yeah. That's what he was doing for Thanksgiving.
Probably, hey, cooking crabs. That boy loves some damn crab. He loves them. He swear his crab water is with boy. He swear his crab water is the bomb. I don't think he cooked no crab when we was partying like that. I don't think he cooked no crab. But yeah.
I used to remember this dude named Tony. He acted like a little female. I used to call him Tony with an eye. That's how. She moved me and I. That joke would cook crab like a female though, man.
For real?
This crab, but he like to eat them every week. I said, fuck, you got a little suspect. You don't eat crabs like that.
Boy, you crazy.
You could throw me some snow or some Dungeness or some king crab, and I made matter of fact, and I can't eat them this weekend. I'm gonna eat all that leftover Thanksgiving food.
Okay. Yeah, I'm supposed to.
Every year, Sean say, I ain't cooking that much. Now you already see all that shit in the butter.
For real, I don't know. I may go to my cousins. I may not. I just because it's gonna be real mixed down there. And I be wanting I really be wanting just nigga food, and sometimes they don't have the nigga.
So like my brother Dwayne, what? He went to a Chinese buffet and told my super question. They got a bunch of Chinese food in this buffet, but they got a lot of nigga food too. I like,
you know, because it's like I am when I cook, or when I have the turkey and the ham. And some people just want to give you the turkey, and then I have a unit on my face. Where's the ham? Because I love ham more than I love turkey, unless you're doing something special to it, unless you're doing the Cajun turkey, frying it, all that extra shit they be doing. If you ain't doing that, then I'm gonna need that ham. I want a little slice of turkey, but I want a bigger piece of ham.
Yeah, she's not even doing turkey. She's doing turkey wings. Doing turkey wings.
Okay.
I'm going to pick up 2 boneless turkey breasts today from Walmart. I'm gonna smoke them.
Oh, okay.
They're real small, so I'm supposed to pick them up between 6 and 7 tonight. And I'm gonna do that. Smoke them.
And see, they don't be messing with them collard greens and us, and I have a problem with that. Huh?
I'm tired of collard greens. We doing.
Look.
Turnips.
Who?
Mustards and turnips. I love mustard greens.
I don't think I know how to do them right. Because I have never done them. So I don't think I'll be able to do them right. Because I don't know what goes. I have to go some old black person is.
Yeah.
Yeah, and they do the mustard and the turnips. Huh?
You eat chicken too?
Yeah.
We having chicken soup.
Who gonna cook them? Who gonna clean them?
Someone clean them. Yeah. She get the ones that's in the bags. They be semi-clean. Matter of fact, she cleaned all of them the other day.
Oh, wow.
She thawed them out and cleaned them. She seasoned them up. And she put them in that Italian dressing and seasoned them up and put them back in the freezer. All she got to do is take them out and cook them. Yeah.
Oh, wow. Oh, damn.
You know, I don't know anything. Now, them buckets, I see them do get some buckets at the store the other day. I can't.
Did you get some what?
Them buckets in the red buckets.
Yeah. You don't supposed to get them?
Well, yeah, they say you get more chickens, but they have a lot more shit because they're not clean.
Oh, okay.
Yeah, they say you get a lot of chickens, but it took me a while to eat chickens, man, because I used to smell them. I said, hell no, I ain't eat chickens.
Baby, what? I'm trying to tell you, them goddamn chitlins. Listen, I don't care what, but oh my God, my mama used to cook the hell out of it. I went in labor eating chitlins. I went in labor eating chitlins, honey. Listen, and my mom used to buy the ones that was already clean, but she still went over, and she tried to show me how to clean them. And I was like, look like the thing that you putting over to the side is the same thing. That is the same, look like the same. I could tell the difference. I said, I ain't gonna deal with this. And it's so hard now to find somebody in Jacksonville, in Jacksonville we ain't got shit going on here. Like, who is doing soul food now?
I know. You know what? And I'll be looking at this dude on TikTok, be going to all these different restaurants in Atlanta and eat. I said, man, we ain't got
shit. Nothing. That's why I be so tempted to. I want to relocate, and I said, hey, all y'all here, I can't do that. I'm just gonna have to be a pop in. I can't leave here. I can't do that. You know, I be tempted.
I wouldn't go to no soul food restaurant and get some chitlins. Like they say, you don't eat everybody chitlins.
Yeah, you don't eat everybody chitlins, but you know I know everybody. I knew the lady who was making the chitlins over there. I know somebody that know you. So hey, you know about me. I know that. If you don't know me, personally, you know about me. But I knew. I'm gonna tell you who it was. Whatever soul food place that was on Sutel. Now I don't know if it's still over there. On that little plaza, like cross from that shrimp place. Suntia, across from the shrimp place.
I remember Madeline's. He was.
Is it Madeline? Wait a minute, Madeline's was right on the front of the street, right? Like when you pass by. I'm talking about on that strip mall, on the strip part that was behind it.
Oh, I don't know.
Okay, yeah. You know, the girl who said she knew me, the teacher Virginia, her mama was cleaning them and working back there. So I knew who was back there cooking there. You understand what I'm saying? And then off of 20th Street Expressway, you know, where you used to be across the street from on Winn-Dixie, that funeral home or whatever, that there used to be a little soul food place.
20th Street Expressway?
Yeah. Okay, you know, when you go there off of 20th Street Expressway, where on the corner, like where Moncrief or Merle, you know, that little, like when you take that right on, like you finna go down either Merle or Moncrief off of 20.
Yeah.
Okay, then to the right, where that funeral home is, you know, right over there, right across the street was a soul food restaurant. I don't know if it's still there. I knew who was making them back there. And then off of Talleyrand. What was that place off Talleyrand? That's what me and yeah, on the east side.
I think they still there.
Oh, for real? They do chilies back there too, and they got the sweet potato pies. So you know, I've been knowing the.
First time I was able to come to Chili's, in Georgia, August some fries. So that was the first time I ate. So.
I ain't never had no fried chicken.
Yeah.
Baby.
My mama stopped cleaning the buckets and she started getting the little rolls from the 7th cigarette store, or like 7th and Pearl. So she started getting them out of there, but we set them up, and then they started shortchanging them. They started cleaning them good. They had these little bowls in them or whatever like that. So, hey, I don't want them no more, you know. So now we just go to the Aunt Bess's make the best one, but it's hard to find hers. So we got the other one, Sean Cream. She like I said, well,
I gotta find out how to clean them. I find out how to clean them. The game is over. The game is over.
When last time you cooked some pork lions?
Shut up, fool. Man, everybody clown me about that shit. That goddamn Wanda said, bitch, put on your glasses. They said, Fort Lord, 100 hours in that damn grocery store, passing out, screaming. Oh my gosh. The people don't know how goofy I am sometimes, how I need guidance. They think I got it all together. But no, I don't. I done went all over Jacksonville looking for some pork chops. And I'm like, I'm tired of that shit when they had that lion on that package. I'm on the phone, Rhonda. I'm laughing. I'm like, girl, I'm over here at Albertson here. I can't find nothing that says pork chop. It says pork lion. I don't want that. She said, bitch, come on, your glasses. I was all in that cooler. I picked it up and looked. I said, "Oh, you say, Lord, I hollered, honey, they were hunting, and Miss Fields on y'all screaming. You hear me, baby? They were like, that is crazy. I'm looking for. I don't want no more pork. Look at me. I don't want any more pork lion. I don't want no pork lion." Listen here, dude. I don't know about no parts of the goddamn what's the name? Shit. Yeah, it ain't. You know, I ain't really was doing no grocery shopping like that. Yeah, what I'm supposed to know? It look without glasses. It look like it said pork lion. I don't want none of that. I know that the pork chop tastes different, and that was my mama was buying pork chop. Shit, all this here pork lion, right? That shit said pork loin. Boy, you remember everything. That shit was so damn funny. Oh my God, baby, I was in that damn grocery store screaming, laughing. Bitch, put on your glasses. Uh-huh. Okay, man. I know that's right. Shit, ain't nothing like a good old Popeye. And that chicken sandwich, baby. I don't know beat nobody ass about it, but that chicken sandwich is tight work. They were fighting over that chicken sandwich. I don't know about beating nobody's ass over no chicken sandwich, but I believe in cussing a bitch out about it. Yeah, that chicken sandwich was all right. I'm like, I'm talking about it was good and juicy and crunchy, baby. What? And they stole Chick-fil-A little idea, put them in them little packages and shit, and zipping it up. Yes, son. I'm like, Chick-fil-A, baby, you gonna have to do something different. Cause they coming for you. They came for you this time. Mm-hmm. Well, all right. All right, Ashley. I'm gonna lock this number down as the main number now, right? Yeah, just I don't know why y'all keep delete, and I keep trying to tell you this the number I done have for 20 years. Send me the other picture you got. Yes, sir. What? I didn't hear you. I know you said something ridiculous. I said you want to see me some titty pictures. See me some titty pictures. I'm not. I don't have. Shut up, fool. I'm always getting violated. I told that short dog, I'm like, even though short dog, I used to have my gown on around. Y'all used to be in the bed, all that type of stuff. I'm like, I ain't think nobody was looking. She told me, Andrew, what's wrong? What's wrong? You look. I'm like, y'all nasty, huh? Shut up. Trigger people out their ass. Here we go. I'm telling y'all use every motherfucking thing. My gullible ass. I ain't that damn naive no more. Trick me out my damn ass. Boy, I'm trying to tell you. I guess, after the 6 week waiting period, you got to find a way to treat me out my ass to get it going. So. Shut up, fool. All right, boy. Bye. Love you. All right, brother. That's my friend, not no romantic partner. We was talking about back in the day, all them damn, how the men be talking about, it's hot in here, take your clothes off and all that crazy shit. And we always talking about that type of stuff. But yeah. Oh my God. I told you, we still mad, baby. Listen, I think by Friday I will not be mad at New Black, and maybe by Friday I'll stop talking about the election. Okay, maybe. I don't know. I'm gonna try real hard. Okay, I'm gonna try. I'm human. Okay. Oh my God. I am gonna beat the ass eyes. I swear for God, I can't see. I swear that package used to say pork lion, but it was pork. Do y'all? Well, whoever listen to this, do y'all sell pork loin in y'all wherever y'all live, or do all y'all stores just sell pork chops? Or you go somewhere with pork chops? Shit, I don't know. Hell, I thought it was pork lion. Shit, I ain't know. Yeah, I had to look carefully at it. I'm like, oh, it does say loin. Hell to the no. I had that. I be trying to do right, right? They had and so they keep a track of my mistakes, okay? And they bring them up, all right? So we won't be having a bunch of mistakes all out there like that, but when I get one, it's usually a goofy one, honey. That pork motherfucking lion. Shit, they ain't gonna never let me forget that and that pink potato salad. And with that, baby, your mama is out of here, out of here, out of here. Let me go out with something. Let me see. I'm going out. Okay, child. Oh man, they always put me. You know what? Ain't nothing like good friends and family. Y'all know that. Y'all know that. Okay, ain't nothing like it. Ain't nothing like those who love you and who you love. Those who care about you and who you care about. You can't beat it. And I'm gonna beg you not to trade it. If you have good friends and good family and shit like that, I'm trying to tell you. You can do you do a lot of things with people like that. You have fun together, you make money together, you go through the good together, you go through the bad together, you work together, it's just so much. It is so beneficial. They're there in your time of need, you're there in their time of need. I mean, it is a beautiful, blissful thing. I absolutely enjoy it. But there's a family, and then there's probably like three people I really wanna um really the other one kinda ain't nothing really wrong with saying talk to that person in a minute. But the other three, two of them for sure I wanna get the band back together, what have you, touch base and see what's happening, what have you. But yeah, I gotta stop being so mean, and I gotta stop being, If I had gotten good though, well, not in my on the ground life. You do one, two things, baby, you are out of here, right? But I should have at least with a couple of them. I should have been more tolerable, right? Because now I find I can take a lot of shit and not even, you know, retaliate or anything like that. So I did change. I'm changing back, but I did change. I can take a lot now. I really can. I really have tough. I always had tough skin, but I have to think. I think about of the other people too. Because my retaliation ain't no joke, honey. Um, and then you have to think about it, and it's just like you know people that be suing and stuff like that. You gonna sue people? That's what I mean about suing motherfuckers, and they ain't got shit to take. Hold on. Hold on. I can play this while I'm typing this stuff. Jacksonville's on.
Who won't smoke me? Who won't smoke me? Who won't smoke me? Nigga, who won't smoke me? Who won't smoke me? Who won't smoke me? Who won't smoke me? Nigga, who won't smoke me? Who won't smoke me? I'm tryna fuck a nigga lungs up. They be like, no, don't put them damn guns up. Fuck that.
Hey.
Say big brother, bring them guns out. When it's smoke, we get the spinning while the sun out. I ain't never letting I pump gas with my gun out. Scream out what's happening to get the bus until it run out. All these niggas hiding like where they got it ain't no fun now. 762 big as hell to knock a nigga lungs out. 1, 2, 3, 4, kick your throat, get on the floor. 5, 6, 7, 8, don't make no noise, I'll eat your face. 9, 10, 11, we ain't gon' say that and won't fuck with Jake. I'ma kill 14 niggas if 13 bitch niggas play. I think my Draco might be gay. Why? Cause he blow niggas. I just got a brand new lolly. As a faux nigga. Call me an auto yes man. I don't know niggas. You can send your best man, you gon' lose your best hitter. What the fuck is that? What the fuck is that? That's how I step on niggas. I step on you bitch ass niggas.
They be on my page like Slav and Vaughn, I know they trolling me. Outside with y'all big homie be on, I keep the folks with me. Got it back in blood, y'all just don't know that's how it supposed to be. Called him for a feature just to kill him cause we know he's who the fuck is that? Bro, go check the door, look out the window, don't forget the strap. I be on they ass when I see ops, I do forget I rap. I be on this
It is the same version, but I like looks like the video version of it. It has more, maybe, I hear everything. I hear like the little sounds, the little beats, and the little, I don't know, that's in the song, not just the instruments that pronounce.
They be like, no, don't put them damn guns up. Fuck that. Say big brother, bring them guns out. When it's smoke, we get the spinning while the sun out. I ain't never letting I pump gas with my gun out. Scream out what's happening to get the bus until it run out. All these niggas hiding like where they got it ain't no fun now. 762 big as hell to knock a nigga lungs out. 1, 2, 3, 4, kick your throat, get on the floor. 5, 6, 7, 8, don't make no noise, I'll eat your face. 9, 10, 11, we ain't gon' say that and won't fuck with Jake. I'ma kill 14 niggas if 13 bitch niggas play. I think my Draco might be gay. Why? Cause he blow niggas. I just got a brand new lolly. As a faux nigga. Call me an auto yes man. I don't know niggas. You can send your best man, you gon' lose your best hitter. What the fuck is that? What the fuck is that? That's how I step on niggas. I step on you bitch ass.
They be on my page like Slav and Vaughn, I know they trolling me. Outside with y'all big homie be on, I keep the folks with me. Got it back in blood, y'all just don't know that's how it supposed to be. Called him for a feature just to kill him cause we know he's who the fuck is that? Bro, go check the door, look out the window, don't forget the strap. I be on they ass when I see ops, I do forget I rap. I be on this shit wherever I'm at, I learned that from the rap. He gon' drink whatever nigga sell him just to say hi. They be like he wasn't even with that shit whenever a nigga nigga die. Mercy won't always lie to y'all whenever a nigga die. Send a nigga stable as they check just to keep y'all quiet. Rollin' stop his ass. Better do what Nardo said, cause niggas die for pumping gas. Why you act like that shit so exclusive, bitch? That's public ass. Ain't no nigga we don't fuck with, come around, we stomp his ass. Nardo voice, creep up out that cut, we like shh. Nardo voice, catch before he run that gun on shh. Hey, who you kill? Steady talking like you did a drill. We gon' kill you sober, who done told you that I need a pill?
Real deal stepper, put my toe on that boy. Mickey Mouse, bitch, you ain't told on that boy. All my guns come with a switch, cause I'm fucking rich. I don't type no tweets or throw no fists. Get shot in your shit. Old nigga steady tryna diss. Fuck up out my dick. Caught him leaving bingo with his bitch. And we sent a blitz. Nardo tryna fight me by the stick. It's his turn to blitz. I can't even roll my Aussie shit. Pussies don't exist. 1, 2, 3, 4. Niggas mad I fuck they hoe. 5, 6, 7, 8. Pussies that got hit with this K. 9, 10, 11, fuck 12. Ain't got L's, we on the chase. 13, 14, 15, 16. Hollow tips, they hit his face.
What the fuck is that? What the fuck is that? Hit that little bitch front of back.
Pest control, who called about rats?
Hey.
Who won't smoke with us? 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 Nigga.
I be with real killers. I'm a rapping street niggas. Copy, paste, delete niggas. Can't wait till we see niggas. Who won't smoke is free. All the oppa sweet. Swish, hop out middle of the street. Hit him. Soon as he fall off his feet. Kill him. Been out all week. C3 RIP. Big my shooters all eat. You can tell that we rich. Pull up all and switch. Been on all the hits. Now I'm all legit. Shout not a wig. Bitch, 1, 2, 3, 4. Fuck the ops, them niggas hoes. 5, 6, 7, 8. Slamming race with GDK. 9, 10, 11, 12. No mask, still ain't go to jail. 100K checks in the mail. Put that away just for bail. All the crack we used to sell. Auntie house still got the smell. Fans be negative as hell. Fuck that shit, I just prevail. AR hold 100 shells. Aim that bitch, shoot everywhere. No limit, I never care. Spin a block, they never there. Plus, what the fuck is that? What the fuck is that? Cost a fucking check. Touch my fucking neck.
Slurping when my buddy get out, baby. Just bag up. I'm beating that hoe. And for all you fuck niggas, stay out the way. Oh God.
I'm in the Jeep with the doors off. She in my spot with the clothes off. Shot to the face, he dozed off. Spit that black and we rolled off. Oh, you wanna speak on CJ? I'ma come knock your bros off. Run around like you stepping on shit. Fuck, we just gonna cut his toes off. I don't even got no face, my face burnt. Empty your pockets, you buck on a robbery, you get your face burnt. I'm with them youngest, they love to spin, them little niggas stay turned. I ain't going back and forth with no bitch, so I'ma chase her. Pop up out that cut. Fuck it, drop your nuts. He was smoking. Okay, he got touched. Dry down on your man. Boy, you better not clutch. Every time that shit get spit, they blaming us. Where they hood at, twin? Let's go flame it up. Niggas lying about the score, they need to hang it up. You gon' get your block took trying to hang with us. I grew up on the east side where it's dangerous.
I'ma speak to my brother killer. They getting killed for another nigga. How you gonna ride for another nigga in a different city? Y'all homies switch. I can't talk, my voice bitter. Whatever you think, my boys did. YouTube record what niggas saying. He said he did, I know he didn't. I'm the man. I bring $1 million in cash around on robber shit. Wasn't a dollar miss. Ask any nigga in the trenches that's on business. I be saying the police round when I be out outside. They lying, just lying. Them baby threats gon' make them change their mind. Get in touch. The city gave up on me. I ain't give a fuck. I lost real members to them streets. I can't give them up. Not the clothes, but them op hoes. I got my dicky sell my Diddy out for 90, boom to 50. Fuck that Billy truck. Man, on the court like we gon' trigger on him. Bro, what you did to him? Losing back to back, that still ain't slide like that shit weird to him. County jail, he go on any deck, that shit get real for him. With no more papers, I'm going to visit Steve. Free my man and them. And they almost got his side. His his head. What they saying to him? Saying all them killers that you look up to, I'm the man to them. OTF, 4L, 21. I don't even be clicking and linking with niggas.
Pop up out that cut. 21. Fuck it, drop your nuts. 21. He was smoking. Okay, he got touched. 21. Dry down on your man. 21. Boy, you better not clutch. 21. Every time they shit get spit, they blaming us. 21. Where they hood at, twin? Let's go flame it up. 21. Niggas lying about the score, they need to hang it up. 21. You gon' get your block took trying to hang with us. 21. I grew up on the east side where it's dangerous. Yeah.
Man, what?
We turn bullets to ash. 21. Knocking nigga out like cash. 21. Cut on that switch and I blast. 21. Which one of y'all odds the fastest? 21. I ain't even go to my classes. Fuck, I look like giving out passes. 21. 200 on 9 my dashes. All my ops, we must stand ashes. 21. I don't wanna argue on the gram. I'm trying to paint him red. 21. I don't even feel like fucking right now, baby. Just give me some head. 21. Every dog gon' have his day, so stand on what you said. 21. I can't wait to shrug my shoulders when you pop up dead. 21. He on the phone, gang banging while he in the fed. 21. Came home and tried to hang. That shit had me scared. 21. This bitch got her outside clothes in my bed. 21. You got some nerve, little bitch. My covers cost her arm and leg. 21. Mouse bird with the slugs taking off his legs. Put that stick all in his face, knock out all his dreads. Send a blitz, I ain't talking, nigga, this ain't Ted. You feel some type of way, you pussy, cause you scared to say it, pussy. Pop up out that cut. 21. Fuck it, drop your nuts. 21. He was smoking. Okay, he got touched. 21. Dry down on your man. 21. Boy, you better not clutch. 21. Every time that shit get spent, they blaming us. 21. Where they hood at, twin? Let's go flame it up. 21. Niggas lying about the score, they need to hang it up. 21. You gon' get your block took trying to hang with us. 21. I grew up on the east side where it's dangerous. Facts.
Up-and-coming rap artist, Rap Outlet is the one-stop shop for everything hip-hop, as well as a
my niggas all eating. You know what? I wonder what is the status of Pooh Shiesty's case. Pooh Shiesty. Well, my boy is tight work, honey. Slurp. We all Cherry Production.
Yeah, I get this shit in blood, bitch, I got my own fight, don't need security in the club. All they wolfing on the nigga, I thought you was a thug. I ain't got nowhere to go, I shot up everywhere they was. Yeah, you know who took this shit from you, come get it back in blood. Bitch, come get it back in blood. We ain't mask up, no Dodger X, niggas know who it was. Story shit just like the 80s, want some back, get it in blood. Yeah, you know who took this shit from you, come get it back in blood. If a nigga killer ain't dead, you sure no RP show. We had 300 shots up in the car before we picked up dirt. Niggas who ain't got shit going, go grab a glizzy, get alert. Shots to G-Post RP and Breezy, he in the dirt. You gotta know I go too far. Got 2 O's up on this honey, one of them might stand for O-Block. 20 some shots left up in the K, 15 still in the Glock. Leave my door unlocked and stop, I like get on feet off the cop. Get no clothes, do them dirty, I ain't showing love. 11,000 all one, let my right pocket in the club. Girl faces up on me dirty, I went got it out the mud. If I took some, get it in blood, I don't give a fuck, but we will. Bitch, I got my own fight, don't need security in the club. All they wolfing on the nigga, I thought you was a thug. I ain't got nowhere to go, I shot up everywhere they was. Yeah, you know who took this shit from you, come get it back in blood. Bitch, come get it back in blood. We ain't mask up, no Dodger X, niggas know who it was. Story shit just like the 80s, want some back, get it in blood. Yeah, you know who took this shit from you, come get it back in blood.
Killed your man, you keep on talking, better get that shit in blood. Kill my shorty, them a dub, then they gon' walk inside the club. Hit his little ass with that switch, I got that switch up his nerve. Fuck the ops inside my city, little bro, put them in the mud. You can't come back to your hood, huh? No. He was dissing Snitching on my cousin, now his ass all in that wood. Book his ass, I wish he would come. Pussy. B-Boy pop up out that car with that new Glock, I wish he would run. His ass playing, bitch, I'm really icy. Really icy. You shicey, that's my dog. But boy, you know I'm really shicey. You told all them OT niggas that you really slide. Pussy. Tell the truth about your game, bitch, they really died.
Bitch, I got my own fight, don't need security in the club. All they wolfing on the net, nigga, I thought you was a thug. I ain't got nowhere to go, I shot up everywhere they would. Yeah, you know who took this shit from you, come get it back in blood. Bitch, come get it back in blood. We ain't mask up, no Dodger X, niggas know who it was. Story shit just like the 80s, want some back, get it in blood. Yeah, you know who took this shit from you, come get it back in blood, bitch.
Y'all remember the 80s?
Come get it back in blood.
I'm about to tell you, I done woke up now.
Big bird.
Chain Production.
You know what? I just can't do what that girl name is, that sexy red girl. I tried to find something. I was every little video. I just kept hitting no, not that one either. No, but I'm gonna get off new black at some point. But yeah, this motherfucker, I can't even connect to nothing ghetto. Like, are you serious? You know, stop it. Oh, child, I done tore his ass up, child. You have to be trying to break in between. What was fun? I'm gonna have to start typing. My mind be going so fast. I'm gonna have to start. When I think of the song I want to play, I'm gonna have to start typing it up right there, because baby, my mind be on to the next, on to the next, on to the next. Y'all, this is what I don't understand. Why is that spot? Why is surgery at? Why them spots? Because I guess they're doing the microscopic or whatever. Whatever. Why is it still, it itches? You can still feel like it's not healed or whatever. Like, what is that about? Like, I know they told me, gave me a long time off. Well, maybe that's why I don't get it. I don't get it. Because, I mean, I shouldn't be feeling like the sensation or not. I mean, I can push on it and it literally feels like it's just healed, like it just closed. That kind of feeling. Like, what? Like, was I supposed to do something else to it? That's weird to me. What was it? That boy said like the 80s, right? Because the 80s, man, it was terrible. Anybody remember the 80s? It was terrible. These people, they were, shit. It wasn't like it was, not like all this self-snitching, and that Bruce Rivers kills me with that shit. He said stop. He like trying to tell you stop snitching. God damn. Those people, I want to know if the YSFN, we got to keep track of that. If people cut deals and all of that, whatever, we have to watch that, because the people, it was YSL defendants all over the place. Some of the people were severed. Some people had People was coming in the court. I'm like, who the hell is that? Like, what? Oh, they agreed with him. I was like, oh, okay. Mm-mm. Mm-mm. And when the other guy, the key to the city man, that's his name. And we were talking about the guy who had a bounty on his head. He had a bounty on his head because of snitching. I wonder, are these people on YSL gonna be okay? You know, I want my Woody to be okay. Okay, I want to know, are these people gonna be okay? Right? Because that's that this is the stuff that took place. Right? It took place in the case. That's why we talk about it, because it took place in the case. Um, and I just want to know, is there gonna be some retaliation for that shit? Cause see, back in the '80s, that was retaliation for that shit. That was like it was some serious shit going on, but there wasn't no bullshit. It was some serious shit going on. Like people was really looking to do time, you know. And so if you told on them or whatever, you're gonna, hey, that's why because I knew, baby, I was the first one that told him that dude had a bounty on his head, and then he started hearing it, and then that's when he told me. Because see, this is when he first started hanging, letting him come to the house, and then after, because he was born here, then he left and was raised down south, and then he came back. So and that's why I was telling like the sheriff's son, like Glover. You look that up. Nathaniel Glover. You look up that big story, won a Oscar something or Emmy or something from HBO. I knew them, of course. I knew the sheriff and the son. He wasn't working there anymore because of what had happened. And I walked, child, I've been in all kinds of shit. But anyway, with the other guy with that turned state's evidence, the Kansas City guy, he didn't know. And I was the first one that told him. I told you, I walked in, I saw him over there shooting pool. I had my baby with me. I said, "Oh, hey, how you doing?" Blah, blah, blah. Because the dude used to hang with Mr. Walker. That dude used to come to my house. That was before, um, he had, turned state or whatever, right? No, it wasn't. It was after. Take that back. It was after. No, it wasn't. It was before. Never mind. It was before. We have the time periods wrong. It was before, right? And then soon after, because I remember that's when Mr. Walker had started hanging back. Remember, I told you he got out the streets, supposed to do right, go through the anti-program. Man, little by little, first he thought he would hang with my family, even though they my family. They at that point, and I'm like, okay, but this don't make it all right. Okay, but I was out the door with him anyway. So at that point, I really didn't give a fuck what he was doing, really, to be honest. And then he started hanging with, the people that he used to hang with. And one of them in that group was the dude that turned state. Now remember, I'm on one side and I'm on the other side, right? I'm not I'm in kind of like in the middle. I'm always in a bad spot. Hey, no matter how it works out, I'm in a bad fucking spot. Okay? With something. I was like, oh my gosh, right? So ain't no wonder I don't drink. So when when he started, Mr. Walker. Remember, he had two jobs, right? Then he just started just keeping the one. I'm like, oh, okay. Till he got well. I said, look here, um, and I told y'all about the damn counterfeit money. You gonna call my people? What? Now I don't know nothing about it. One thing I asked him, I said because it was when it started off, it was on a Friday, and that was his payday. And he give me his check, right? And I said, hey, this ain't that counterfeit money, is it? He's like, no. I was like, oh, okay. And so, I took it and just, paid like the cash bills or whatever. Right? It was crazy. It was a wild time. But anyway, and so, you know, like my cousin on that side of the family, like when I was playing with y'all and I was telling him, I said, yeah, these people out here messing with me. And he talking about, well, why don't you send your angels at them? I'm like, oh, that's a whole nother story. But they call them sending the angels. But anyway, but everybody, I'm pretty sure life is set up like this, and so I'm not, saying nothing foreign or whatever. So I'm gonna call the cops. I know everybody, know people that you ain't gonna unknow just because of y'all kind of, doing things different. But um, anyway, so that guy that had turned state, I had seen him one time where the people buy big jewelry at and stuff like that. I had taken my ring back there to get size. I had gotten it from there and I had taken it back there to get size. Lo and behold, he come in. He was at that point was walking around with security. I don't know. We got this thing here about walking around with security. I don't know why we do that. That is so stupid, you know. And so, um, um, I saw him come in. Baby, I was like, ooh, ooh. And like the jury, so we having all that glass, and this was downtown. So it's not in a mall or nothing like that. Anybody can come through there and do that goddamn young dog shit. You understand what I'm saying? It was like one of those type of things. One of the biggest jewelers that be servicing all them people that don't have a job. And so, man, I was like, oh Lord, Swapple God. I was like, oh Lord, please come on with my ring. And this was an older man, so he moving real slow. My nerves so goddamn bad. I'm like, how you doing? I moved on, went on, and I was so scared when I was walking out the door because of the glass front and everything, and it was on a corner. Boy, I was hurt, and parking down here, everything is fucked up here. It's nothing here. I'm telling you, my white man is going to somehow get me out of here. I don't know. I don't know if I think I ever leave because, um, you know, I just have to go and pop up in other places. But I don't think I ever leave. But I fell in love with that DMV area. Of course, I love Orlando. And look here, seem like the beaches of Florida, you probably don't want to be out there. Okay? But fell in love with those places. It would seem as though Georgia would be uh, uh, a home for me, but baby, people hate me in Georgia. Seems like so I'm gonna be food up with that. But anyway, so when I saw that goddamn boy in the key to the city man house. I had my baby with me. She wasn't a baby. She was grown. Well, no. She was maybe like 17, 8, something like that, right? I come in there because bounties don't expire. Even though people go to jail or whatever, bounties usually don't expire. I come in there, I'm like, oh, mm-hmm, he got a bounty on. I said, okay, well, he got a bounty on him. I'm gonna get ready to go. All right, then, all right, how you doing, whatever. And he over there telling me, that's my friend. You heard him on the phone talking about, he told me, that's my friend from church. I'm like, yeah, and your friend from church got a bounty on him. So ass out of here. Let me get the fuck out of here. Like, my nerves was bad. And you would think, baby, If I be, yeah. I'm like, And so I was the person that told him that, and then he started hearing that from people. He was like, you're right. I'm like, I know I'm right. I know I'm right. Hell no. Your friend from church. Yeah, your friend from church got down. Mm-mm. That's bad business there. And it stems from the 80s, right? They was like real strong like that and stuff like that, right? And that particular dude, what? Let me tell you the stats anyway. Um, that was a real serious move he did. And do you know that the dude that turned state didn't do one day, and he was the one of the like the how you have a tree and you like he was the one of the guys that was right up under the dude. Yeah, he didn't do not one day, not one. Mm-mm, mm. I couldn't believe he was just still. I don't know how he made it. I mean, shit. I'm probably Googling and see if he's still. You still here? Yeah, that was some crazy shit. Um, I guess he could have. I mean, I know he could have probably negotiated a a deal that didn't involve him but he probably was facing life too. And I mean, now the guy didn't get life, but it was a long time. It was crazy. And I realized today that Cat Williams referenced Jacksonville in that room. He got in an argument with Wanda Smith, and he said, "Yeah, I got X amount of money for a special I did in Jacksonville." Yeah, honey. hmm And I love it here, but there's nothing here. No, I told y'all we have no restaurants. We don't have shit. I mean, let me tell you, on my own, I'm going to familiar places or places where I know people, right? So with credit card man, he was taking me like different places I hadn't been, right, and stuff like that. So that was, if I shared that Nicole Murphy thing, right? That's somebody that was showing me stuff, and I was learning, different things, right? Um, key to the city man, he was taking me, different places, right up, you know. But with the policeman, we pretty much going to places that I already know. You know what I'm saying? Because he saw it as the plus one in that situation, right? Um, so, and it's always great to me. I'm always in a learning position, right? I'm in a learning mindset. I just want to learn. I learned a bunch of shit from y'all. Learn about Cash App, all kind of shit like that from y'all. I ain't being funny. I'm just saying I learned some I learned some shit out here on the east side of the street. I ain't talking some Twitter some up here, but still. So I love to learn. Learning, that's eternal. I can teach you some shit. The credit card man was always teaching some shit. Always. Always in charge, always the boss. And you be like, with this one, I get to lay back. I don't have to worry about it. Even though I got me, it's always good when somebody got you too, right? Mm-hmm. We want a leader, not a follower, not. And you know me, I can stand a bitch ass nigga. I'm telling you, I detest the motherfuckers because I don't understand what's wrong with you. There be so much in their bag when you call them bitch ass, when that bitch ass nigga, and weak is one of them. Weak. Oh my gosh, I ain't used to no shit like that, and then you ain't gonna make me get used to it. I can't stand that shit. That bitch ass nigga bill. I can't live there. Like, yeah, I don't even know like, how do you do that? And you have people that are bitch ass niggas when they have the options not to be. I have gotten into it with men on, like, on some shit. And one thing about it, through our getting into it, miss, I don't do no, bitch ass shit or say no bitch ass shit, right? It was like, I mean, they found other shit to do, but wasn't bitch ass, right? And so you can, you can respect that. Yeah, oh my God, me and Kansas City, man. Oh my God, we used to get into it. He ain't never do no bitch ass shit outside of clock block, and that wasn't bitch ass shit. But he ain't never do no bitch ass shit. And when I tell you we got into it, oh, we got into it. Our our daughters got into it. We got into it. Okay, our daughters got into it at the damn fair. I might ask my daughter if she remember that. We wasn't doing fuck shit to each other, right? That's just how it works. And if you stand on what's right, doing the right thing, right? Or you do nothing. If you don't do bitch ass shit, you know, I can stand. I'm like, oh, true or false? Bitch ass niggas don't even get invited to the parties, honey. They gotta have their own and invite people. They don't get invited. True or false, honey? They don't get invited. Something came in my head. It started all this Drake shit. This was something me and Craig got man right out to.
Yeah. Sticking to the code, all these hoes for the street. I put in her nose, it's gonna make up pussy weak. Pussy niggas told ain't gonna wake up at these sleep. You can hear that switch, but you can't hear them niggas scream. All my hoes do songs, nigga, all my hoes do coke. 20 carat ring, I put my fingers down her throat. If I lose a carrot, she might choke. I know she gon' swallow, she'll go. Big bad nigga, bring the rats in. Got the shooters in the corner like the pack-in. She think cause she's out of bitch, she attractive. That's that shit that get you put up at the station. Ain't the models still the same. Ball like I won a championship game. You know these hoes hungry, they gon' fuck for a name. I put her on the game, she get fucked for a chain. Got your girl in this bitch, she twirling on the dick. I got syrup in this bitch, turn up in this bitch. Everybody hurts in this bitch, get murked in this bitch. All these pointers on me, baby, you know it's game time. Bring a friend, bitch, we fuck them at the same time. I'm a different nigga, no, we not the same kind. You can have that look, bitch, you ain't mine. Young dope, dealer selling dope, is you like that? Kicking doors, kicking in doors, is you like that? Young dope, niggas selling lows, is you like that? All 24, you won't go, is you like that? Niggas from the bottom really like that. Stepping in balances if you like that. Pop another bottle if you like that.
These niggas talking out of their neck. Don't put no coughing out of your mouth. I'm way too paranoid for a threat. Hey, let's get it, bro. DOT, the money, power, respect. The last one is better. Say yes, a lot of goofies with a check. I mean, I hope them sentiments symbolic. My temperament bipolar, I choose violence. Okay, let's get it up. It's time for him to prove that he's a problem. Niggas clicking up, but cannot be legit. No 40 water, tell him. Yeah, get up with me. Fuck sneak this and first person shooter. I hope they came with 3 switches. I crash out like fuck rap. This Melly Mel if I had to. Got 2 T's with me. I'm snatching chains and burning tattoos. It's up. Lost too many soldiers not to play it safe. If he walk around with that stick, it ain't Andre 3K. Think I won't drop the location. I still got PTSD. Motherfuck the big 3. Nigga, it's just big me. Nigga, bum. I'm really like that. And your best work is a light pack. Nigga, Prince outlived Mike Jack. Nigga, bum. For all your dogs getting buried. That's a K with all these 9s. He gon' see Pet Cemetery. Nigga, bum.
Selling dope, is you like that? Kicking doors, kicking in doors, is you like that? Young throw, niggas selling laws, is you like that? All 24, you won't go, is you like that? Niggas from the bottom really like that. Stepping in balances if you like that. Pop another bottle if you like that. Young dope dealer selling dope, is you like that? Kicking doors, kicking in doors, is you like that? Young throw niggas selling lows, is you like that? All 24, you won't go, is you like that? Niggas from the bottom really like that. Stepping in balances if you like that. Pop another bottle if you like that.
strip club, make it rain for 3 hours. Locked in and now I got my film in my dropper. Perked out, took chances in my hood like Nevada.
Woody did another 21.
Hey Woody, you ain't got long to be here. You gotta hurry up. Time is money. You gotta be in Atlanta. You gotta go back to Charlotte. And you gotta go see your probation officer.
And you ain't got no weight in your head. But
What? We need to wrap this up.
Let's go. You gonna be waiting on this? I'm talking to Mike.
see,
So bag.
that's why I'm tired of doing these 25
No.
You be tripping, bro.
But you signed up for this.
Carolina, first 20 verse 1. 1 verse Woody. Who bought Woody here first?
Whoa, hold on, y'all. Wait a minute. Wait a minute.
White.
Hey, yo,
This is what I'm talking about.
This is why we here today.
This is what I'm talking about. You know I'm finna share this. Oh, thank you, Jesus, honey. Oh, Lord. I know I be putting my money on the right folks. Oh, I'm gonna share this. Oh my gosh. Woody seems like he is direct. You know how I get excited, I'll get all speak. He is directing this 20 and when this is what I'm talking about. Oh, we could have been doing some production, some kind of shit, right? Getting to the bag and having those residuals, baby. Listen, I don't leave no money on the fucking table. If I can fit it in, I'm gonna get it in. What? Keep me, baby. What? Oh my gosh. Let me tell you. You don't know how many times I've been tempted to call credit card man or somebody. But I'm so embarrassed though. But call credit card man or somebody to see if they can turn this shit into a production. Because we already got the videos. That's why I be trying to, look at zoos and I be playing about big in a way. But, the best way to get to the people is through security. But you just got to look, see how close they are aligned with each other. You know what I'm saying? Is it security in a boss, an employer working condition, or is it like friends working for each other and working with each other, that type of shit. What? Boy, you know how much money out here? Boy, bye. I'm serious. I be looking. I be like, okay, I can, all this stuff we done put on the record. Come on, production. Come on. You know, I'm just so embarrassed. Gonna be hard to me to explain, you know. Mm. I don't know how this could be really packaged up, you know. 'Cause I wouldn't mind. I don't give a fuck. I ain't gotta fuck with you. But make a bag with you. I don't fuck up the bag. I'm media trained. And I went to editing school twice. And, you know, my family literally raised me. Raised the hell out of us. But I'm talking about, like, you see how these people, like, they have all these subscribers and stuff, have that programming going on their channels and shit like that. Now, YouTube is paying them, and plus people done got sponsors and shit and all of that. That's making our time count. Mm, mm. But because of people's differences and stuff like that, they don't know how to put that to the side to get to the bag. Fuck all them differences. Do like the people on the baddies do. Fight and they shake hands and hug afterwards. That's what I'm used to. It's gonna be some shit if you try to come together. Man, what? You got a running boat around here, running R. Kelly name. Shit, well, we can't catch it somewhere in there. And so people be like, oh, what? I mean, anybody now, I don't give a damn. Get to the bag. Somebody out here have to know how to do production, all that type of stuff. Like, come on. How hard is it? But you know, I be thinking on a large scale. I mean, like, if I call such whatever, they can get us in the different doors, bigger doors, right? Like with their production, come or their management or their, you know, investment, or you know, I'm talking about distribution and whatever. I'm bored. I'm used to making money with people. I ain't used to all this kind of bullshit. It's crazy, craziness. Yeah. Boy, I am so proud of this boy. This is what I'm talking about. And this boy here ain't half educated as some of you are. Mm, 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 mm.
They black left them brought us here. We got Woody. We come 20 versus 1 Milf edition. Shout out to Columbia, South Carolina. Shout out to South Carolina Pillars. I told y'all, we love y'all. Woody love y'all.
L's up, man. You know what's going, man. Pastor Red Diamond. Love gang. Atlanta, Georgia.
I'm a judge.
Put your L's up. Put them up higher.
Y'all see this man telling me what to do?
Yeah.
I'm a judge.
I'm the pastor.
Okay,
You're the judge.
Who go first?
Pastor, of course.
Okay. Hold on, don't come.
Oh,
I'm a judge.
L's up.
I'm a judge. L's gonna be down if you call me crazy.
No gun. L's up.
Yeah, you gonna be down.
You gonna take me down?
Don't call me.
Yeah, I'm about to pray on this one.
Who is preaching?
Oh, Pastor Cristiano.
Cristiano.
Hold on. He's doing his acting thing. And this is crazy. We got an actor. I have a history. Like, what we doing? I can't, and especially while, you know, I'm old but I'm young. Boy, there's some dumb shit. And then we got enough content where some people can put it. Boy, fuck y'all, man. I don't like nobody fucking up my bag. Y'all fucking up my bag. I got a problem with y'all.
Judge.
I'm the pastor.
So
who am I? You I gotta be the pimp. The pimp is the pastor.
Wait to hold.
Judge, pastor, yeah.
You got some hope.
Well, that's why I'm up here for. I'm not a convict. I'm not a convict.
Nah, you're not.
No,
and I'm not a
You
judge.
delivered.
either. I'm not a judge. They think
With
I'm a
the
judge,
Lord.
but I'm not a judge.
Hey, now listen. Before I lock y'all up, I don't give a what you do. This is what we're gonna do. I got these meals. Some bad grown ladies, South Carolina baddies, you know. They grown, they milk, they got big old things.
What's up,
Can I answer the phone while I'm talking?
You just said.
Go ahead. Go ahead, answer the phone.
You said we get to that.
Catch a blade. Catch a blade.
Man, bro, what's up, bro? You need how many? Bro, I don't got no oil, bro.
Who we talking to? Who gonna call me when I'm talking to the judge? A Diddy for. So listen.
This is literally
This is what I
production.
do. I bring first girl out here. You done did the little thing with these young girls. Now I see what you about to do with these grown women. South Carolina.
Yeah.
Dirty.
What part of South Carolina?
Columbia.
Push up.
With the mother judge.
Okay, Judge.
All right then.
We know you're in the town.
All right, come on, let's do this again.
Push up.
All right, bring first girl out.
Let's get it.
So
It's not funny. It's not funny. Got some grown women back there. Put your grown man on. Don't play with him. All right?
For sure. I ain't gonna play.
What's going on?
What's Sam?
So my name's Kimchi.
My name Tony.
No. Kenneth Copeland.
How you know my name?
I know you.
For sure.
So I got a question to ask you. So if you would lie to the cops, you think you lie to me? I know you for lying to the cops, but would you lie to me though? And I want to see your feet.
You wanna see my feet?
Yeah.
Damn, you ask me too much. You know, you dish around why I keep you or get rid of you. And you come here with all these demands like you gonna tell me what to do.
Are you gonna let me go or what?
You ready to go? What they mean?
Are you gonna let me go or?
Damn, girl, you crazy, man. I don't know. I got a date on you.
You in the Carolinas?
What they mean?
We kind of crazy, kind of southern.
Let me give you another chance. I'm gonna keep you. You go to the right.
Thank you. Good job.
She crazy thing. I'm gonna let
why
that
you
go
kept
with
her?
her. She in prison. She crazy, but
She
I
pretty.
gotta handle that.
She crazy as hell. She like feet.
Yeah, she.
What's wrong with her?
My feet got the sunflower seed toe.
She might like them.
She don't have no trouble but like.
He
What that
said
young saying?
sunflower
Don't be
seed
slow.
She didn't say what kind of feet she like. She said she like feet, so she don't give a damn.
She had to roll these feet.
Next girl. Okay, she got a little whopper.
Where's Sam?
Hi, honey. Hi, Woody.
Do you know my name?
Yeah, of course.
That's your real hair?
Yeah, some of it, some of it.
How old are you?
But
You let me put it?
yeah, I will.
You stay.
I can say.
For sure.
Nigga, that was fast.
Yeah, she said I can pull her hair.
Is it real?
She went the wrong way.
Is it fucking real?
Yeah,
You gonna know till you pull it, ain't it?
she went the wrong way.
Okay, well, next girl, where the next girl at? You kept up fast. God damn. And she got the soft voice like, meow. Meow, I'm a kitty. You got a big old fat donkey.
Thank you.
You can stay.
Appreciate it.
Man, why you kept her away?
See, why when I not keep going?
Okay, clocking along. Click, clack. Next girl. In the courthouse.
Hey,
man.
Woody.
Where's Sam?
How you doing?
I'm all right. I like your smile.
Thank you.
You can stay. You don't want to stay?
Maybe. It all
Maybe.
depends. It depends.
Depending on what?
It depends on the answers you give me.
The answers I give you?
Yeah.
Oh, you could be a problem already. I said you can stay and you stayed instead of going to the right. You want to go to the
Like
left?
I said, it depends.
Depends on what. Because now I'm reconsidering.
I mean, like, what are your morals? Because, I mean, I kind of need something in my life.
I got what you need right here. No, but like,
But, I mean, you know, that ain't always all I need. I need a little bit more. So, what's your morals? What you got for me? That's it?
This ain't what you want?
I mean, it is what I want, but it's not what I need.
This is more definitely what you need. You ain't never had it, so you can't say what you need.
Is it?
Yeah.
Is it though?
Huh?
Are you sure?
For sure.
Positive.
No, guaranteed. You wanna go left? Send her at to the left. You gotta go. I said you can stay. We're gonna send you to the left. I know. I did you. We did each other.
It's tough. Don't get me wrong. It's tough.
We did each other a favor. We both gonna send each other to the left.
I guess. Whatever.
To the left, to the left. Everything you own in the box to the left.
She crazy anyway. Ain't got time to find her
she
old ass.
crazy.
I see her now.
She
Playing my
came
time.
here. This is
Right.
you the question to you. She
Right.
might be the FBI.
It's our first round, girl. This is up to me to keep you or get rid of you.
She might be working for Primo.
She working for somebody, ain't it? Probably
Gotta
Dollar
be
General.
working for Primo. What her name is?
And I mean, this is decent, but this ain't even funny. And we know we funny. I am pissed.
Y'all Carolina girls don't play fair. Good gracious.
Hello.
Where's him?
I'm Tay.
You who?
Tay.
Tay, T-A-Y?
Yes.
Every Tay I know shooters.
It's in the car.
For sure, you can stay.
Thank you.
What do you kept her because she a shooter?
Nah, because she got them titties out.
I wonder where I thought she was without them shoes on.
I should have seen, I'm catching on nigga around.
Take them shoes.
I got to see them toes on nigga around.
Got a little bit of height to that. Next girl, where she at?
This ain't even funny.
Oh, yeah, she ready to hunt some shit.
This is guns. Hey, where's Sam?
Welcome to the South.
Oh, she about to get
this for me?
Yeah.
You can stay. Give me a hug, girl. Ooh, you know how to get me. What? That's what you call a real woman.
A bride.
She trying to, that ain't no bride. These girls nowadays want you to take care of them.
You don't know her name.
She gave me the crib and the blood. No,
Man.
good and bad. Well, let me pick up both
Where
of
the
them.
next girl at?
I ain't there. You keep not safe.
I'm judging. I'm still nigga.
See, Barry White, they don't even show me that type of love.
What's up?
Don't you ever. How's that, man? Where's him? How you doing? We look like brothers and sisters. Yeah. What's up, T-Ray? Hey, okay.
And listen to the one he did with Charleston White.
Go to the
Hold
real.
on.
Right, I just playing.
Oh,
Right.
don't do that.
Oh, that other side for to come out. Now see how I feel to touch mine.
This ain't even funny. I mean, I love you, with it. This ain't funny. This ain't a funny one, boo-boo. Which one is Ryan with this? Which one is on? That shit hit 6.1 million, 2 million, 2 million. Let's see which one is the funny one. It's this one.
Question is for you, Mr. Def. You can hear?
I'm fool over here with you. Woody White. Woody, pull up, man. Goddamn, Woody White. Goddamn, Woody White. You just left the crib.
Yeah,
They got you with the trick or the gunner.
I don't even know which.
Boy, you right, boy. He been rolling the dice with that torpedo. Man, they say if you do this right here and get that earwax on your finger and stick it up, then she go jump. And that's when you know that's it.
I'm going to start trying it. And
Yeah. Well, you put a 20. I say, my bad. I seen that. Them hold on. I said, I wonder we stiff their ass to see if they clean down now too.
It'd be too late at that point.
You gonna start licking out. Well, I don't eat that. So that, just put that out there, and I don't tongue kid. Just straight to it. You a soldier boy.
See the difference? This one is funny.
You know what I'm saying? We thought Sexy Red was gonna be the last one, but we only doing bangers. You know what I'm saying? Brought out Charleston, brought out Woody, two of the biggest on the internet right now. You know what I'm saying?
Two America's Most Wanted. We the new Snoop and Tupac.
New Snoop and Tupac. You believe that?
Yeah, keep it on.
Me too.
What's that?
I can't carry no gun right now. I'm out on bond.
So look, how many views and how many likes we need on this?
We need a bunch of them, man. I got over 2 billion views on TikTok, so I need them views to come over here too, man. Let's push this motherfucker past the Cat Williams and Shannon Sharp interview.
Y'all heard it, man?
Yeah.
Y'all heard it here first. You know what I'm saying? It's your boy Ron with the Sauce. I brought you to the biggest house, so make sure you like the video right now. Comment if you haven't subscribed.
Literally, within months.
That's your real edge up.
Make it down. It's like, y'all suck. Oh, y'all suck.
Look, man, it's for the
Oh, I'm pissed. Oh, I'm about to cuss.
Nigga, I need a little Beijing.
Nah, you good. Your shit still full up there. I just get it for the look, for the video.
Okay, already. Okay.
You know what I'm saying?
It was looking too perfect.
But it's my shit. I ain't never had a haircut. Weed or weed? The one the girls got in there. Yeah, whatever. Alright, if you listen to the channel, smash the like button if you haven't. Comment if you haven't subscribed. Roll to 1 million.
Alright, so YouTube, look, man, y'all know how the first round go. First round, each lady gonna come up, introduce themselves. And either Woody or Charleston is gonna swipe left. Woody. There we go. You know what I'm saying? So let me get my first lady in here. It's spelled Woody. He must can't. I told you, man, it's spelled Woody.
Take the head off.
Nope.
Hi, how you doing?
Hey,
My name's Elsie. Nice to meet you.
Miss Elsie.
Hey. Okay. What y'all think?
2 million motherfucking persons. I ain't trying to be disrespectful. But I ain't never wanted to date an African woman. I like European women.
You keeping me, Woody?
I'm swiping left, or whatever they say swipe.
Okay, but look though, my lady, I don't know if I told you, if one of them swipe you right, you in the game for the rest of the rounds. So you're still here. Charleston swiped you left. Woody swiped you right.
I like matching panties and bras and matching toenails and fingernails. Yeah, that's absent.
No, I don't.
I said, oh yes, ma'am. I'm just saying.
I like your friends. Thanks for keeping me.
You up? You don't think his britches too tight?
Nah, I fuck with him. I fuck with your friends.
This nigga hate anyway.
Hi, how are you? My name is Stardom Shay.
Hey, Miss Stardom Shay.
Yes.
How you doing?
I'm good. How are you?
All right.
So based off appearance, Woody, Charleston, we swiping left, we swiping right.
I'm debating. I won't say swipe left because she got 1, 2, 3, 4, 5, 6, 7 persons. But boy, that motherfucking gap. Boy, she got a motherfucking gap like a man. I'm keeping them. I'm keeping them, baby. This kid. I'm keeping them with Jack.
Hold on. Woody, what we doing?
You heard me.
I bet, you know what I'm saying?
Thank you.
And she got scars on them knees. And she got she got scars on them knees, nigga. Keep up.
What does scars on the knees mean?
She don't mind getting on her knees cleaning. And shit, we won't keep up with it. Shit, we might get what we looking for with that one. Like that. Shit. Yeah. She can stay.
She ain't made it to the floor yet, Charleston.
She don't need me.
Oh, I'm pissed.
Can she introduce herself?
No.
Yeah, let her introduce herself.
I'm Martina.
Hey, how you doing, Miss Yellow Panties?
I'm good. How you doing?
All right. She can stay. She got on yellow panties. Yeah,
I'm
niggas
glad
see
you
them
seen
panties from way over there.
You want to see him later?
Yeah. And she in her toenails and fingers don't match. She can stay.
Okay, bet. You still here. You know what I'm saying? You stand.
What's up, y'all? Y'all already know who it is. Make sure y'all follow me at It's Only Vendetta. Hey. How you doing?
All right, how you doing?
Good.
How you backing up?
Shit, why she stepping up?
Oh, the line. My bad.
Let me see your toe.
Where you gonna see my toe? What you trying to do? You said you wanted me in the last video.
I sent you to the left.
No, you didn't send me to the left. You sent me to the right.
You should show me your toe.
Look, we got on matching colors. I feel like we would look cute together.
Honestly, she got hair on her legs. How we gonna rub legs?
I got hair on my legs.
You
got hair on your nuts?
No,
you got hair in between your ass?
No.
You shave it? You get it waxed?
It don't even grow.
There? It don't grow.
Hair don't grow out my ass.
Why it don't grow?
I don't know, God. They want me hair that.
No hair on your chest either. Just smooth.
I ain't got hair up under my arm.
Down.
I ain't got hair up under my arm. But you got hair on your leg. And how we gonna rub legs?
It's just something for you to cuddle up under, get you warm, you know.
Oh, you that girl from last time, man?
You already know who I am. That's why you asked to see my toes.
What's wrong with your toes?
There's nothing wrong with my toes. You said you wanted to suck them.
Yeah, you should live.
Hey, look, man, the video should be out.
She can stay to the right.
Yeah, I already knew
And
that.
they run
She
this
can
shit
stay.
on Patreon.
So
This
why
is
you can
making
stay?
money.
That's why you can stay.
It don't look clean.
It don't stink or nothing.
Look at that part right. Nigga, man, that ass don't look clean.
It don't stink or nothing. You ain't gonna break out. If anything, it's gonna rejuvenate you. You know what I'm saying?
I think I seen the
You gonna
ball.
start growing hair right there.
Nah, it's a ball right there. Look at that ball. Oh, no,
ball.
that's pussy meat.
What you talking about?
That's pussy meat.
Man, she stinks.
That's pussy meat. I'm saying.
You stink.
That's a fat pussy.
It's a
But I don't want it. It got hair on the leg.
She stink.
You don't even grow hair in the
Hold on, hey, look, though. If one of them swipe right, you still in the game.
Okay, period. I love you, Daddy.
Which one?
And you got some pretty teeth. Ain't they got some pretty teeth?
You got a gap in yours.
Yeah, but you got hair on your legs.
And you don't have no hair in your ass.
Smooth legs.
It's crazy. For the first couple times, yes.
Let her go.
You gotta be responsible.
I got
Let her go.
You already said right, anywho.
Yeah, he said right. You still in the game. You green. You good.
She got meatloaf back there.
I don't like ass. I like a pretty face. I'm not an ass-obsessed man. I grew up watching Popeye fight Bluto over Olive Oil. Olive Oil was tall and skinny. Yeah.
She freaky. She look like she gonna get this.
She kept talking about ass. Her on your ass. She gonna be trying to go to your ass, nigga.
She said that to you though.
What do you think she gonna try to go to yours though? That's a whole no. I didn't want her though. Man, hell no, man. Hairy leg woman ain't good for nothing, nigga.
Okay. Thank you. Hello. I'm Queen. What's up? You can put your hat back on.
Oh, step over to the left a little bit. Love, step over to the left. There you go. You can face him.
Why are you acting like that? What's wrong? It's not on my face? It's cute, right? I know you're not talking. Hi, Mr. Sir. How are you
Hey,
feeling?
how you doing, ma'am?
Mr. Who?
Mr. Sir.
You don't know his name?
I know his name, but I called him Mr. Charleston, sir.
You African?
No, I'm Jamaican.
You going to the room?
No, I'm not. Am I wearing black? No.
I don't know what you wearing.
Oh, I look good.
You do look good.
I know, thank you. So what we doing? I like your pants, not gonna lie. I like your pants. But the pink and the red on the shirt, it kind of throws it off. You could have did a pink dirt stick, but...
Thank you so much.
You're welcome.
But you know how I feel about girl blonde hair?
How do you feel?
They say a coochie.
Why does everybody keep saying that? This didn't go out of my head, though. So...
Have two more said.
Listen, it didn't grow out of my head,
What you gonna do with that?
Man, I don't like nothing about this girl. You man, hell no. I don't like nothing about her.
And I don't like nothing about you not having no hair on the top of your head.
Hair up on your arm?
I do.
You got on black socks?
I don't have on black socks. I have black feet. So
I'm suspended girl done come out here with black socks on, these flip-flop. Man, you done, man, hell.
there's no socks. I'm dark skinned.
That girl
We're
there.
not gonna do that. I'm dark skinned.
Hello. You know what I'm saying? We love our dark skin.
Yeah.
I ain't said nothing about dark skin.
But you talking about black socks, and I'm obviously
you
not
know I
wearing
got
socks.
vision problem. You know I'm visually impaired.
Okay, well, I'm dark.
I'm sorry, man. I'm visually. I thought maybe you had holes in the
I'm
socks.
from New York.
Oh, they make. Oh,
Yeah,
okay.
I'm from the
Okay.
town.
Okay.
I'm from Harlem.
All right.
I used to be in the Chicago 79th and Jeffrey. I know about.
Have you ever sold some pussy before?
I've never sold pussy before. Never did
How old
that.
are you?
I'm 25. My birthday was last week.
For real?
Thank you.
You
The
said
28th. Thank you.
Yeah,
See,
you-
y'all
I
getting
think
there now. Y'all getting there now. It makes sense now.
Listen, pelvic on pelvic go hurt if we fuck.
Huh?
Two skinny motherfuckers grind, that shit go hurt.
Who said we was gonna fuck? We
Oh,
can
she
get
got
money
to go.
together though.
She got to go. We got to go. Shit, now this about fucking.
That is not why we here. That's not why we here. We here to get to know each other.
Huh?
That's
Yes.
You know what part of knowing each other is, right?
What's better than
Who get to know each other to fuck? That don't exist nowhere.
That's what I just said. We're not here for that. We here to get to know each other.
I said swipe left. I said swipe left.
You want to swipe me left?
Find my food stamp card, so
You don't got your link card? All right, baby. I'm gonna go.
And you flat-footed too, ain't you?
I'm a little flat-footed. I am.
Why
Thank you. I got them done for you because I know you like to look at feet.
I like to look at feet.
Well, you was
I just
making-
like my girl to have pretty feet.
All right.
But she gotta have the other stuff to go with it too, though.
Wait.
You skinny, like you.
I'm a bad, skinny, dark-skinned baddie.
Give
Like,
your knees
that's
down
what's
now.
given.
Why your knees way down
Because
now?
I'm long-legged. Okay, Mr. Sir? I'm a real authentic model. This is what models usually look like.
What are you?
Me.
Them knees too far from the hips to be real. No, man, hell
To be
no.
real,
What are you?
you remember, you don't have an eye. So maybe you're not seeing right.
You don't got an eye?
You sure right? No, I don't.
He's not seeing right.
This one's visually impaired. You right. You sure right.
I
You sure
know.
right.
So we going right?
No,
I thought we was friends. What
I'm
happened?
keeping them.
He's keeping me.
I'm keeping this.
That's it. Now I'ma leave. Hey y'all.
Hey y'all. I mean, how you doing, man?
I'm good. How you doing, baby?
All right. You a school teacher?
No.
You got a professional job, don't you?
Yeah.
I can tell by the way you walk. All them toenails and fingernails, they pretty.
You said how what? No. I found out.
I'm fine out.
Okay.
I ain't fucking after you, no.
You don't want to fuck out of you, nigga. You
I like y'all outfits though. Y'all look
I say
nice.
you stay.
I like yours too. I like your
last thing
shoes.
that just left out of here. I ain't want to say it up, but you just see that.
Oh, be nice.
Yeah,
No.
don't do it. No.
Hey, I can't help it.
Say it then, nigga.
That thing is so ugly.
No.
There she go. No, you ain't, baby.
No.
Maybe
She
funny
beautiful.
looking, but you ain't ugly.
She should have come in here with some.
Man, I'm funny looking. Blondes have more fun. That's my woman. I ain't finna sit up here and let him talk about my woman like that in front of me. Nigga, I picked her for a reason, nigga. And she ain't got pretty ears as ass pretty does.
See?
Okay. All right. So look,
Yeah.
Woody gave you a swipe right.
Okay.
We both keeping you
Okay.
with that silky black skin.
Ooh.
Yeah,
Talk to me
glowing like a
nice.
pregnant hoe.
What's up, y'all?
How you doing,
He said
sister?
glowing like a pregnant
Step up to the
hoe.
line. Step up to that line.
What's up?
What's so funny?
Man, it's just you. You make me nervous.
I ain't did that.
I got a crush on you.
Oh my God.
Mm-hmm.
Every girl had a crush on me, been chasing me all week.
I ain't gonna chase you. I ain't gonna stalk you.
I'm gonna follow his lead.
But I'm in your DM.
What's your Instagram name?
Shade_the actress. You should go look at it.
Hey, y'all both got on pink too. You know what I'm saying? Coincidence.
Read my
Oh, you can stay. I ain't see that.
But you know where I got the shirt from, right? Jail Bay.
Oh.
Jail Bay. She out there. She coming. Oh, Jail Bay. The one with the blue pants on.
You know who Jill is?
You got looking at you. What you got? You got nothing to say about him?
I like we got on that blue, that chain fire.
You don't like the way this shit up here look?
Thank you, baby.
That shit fire.
Talking about my hair?
Yeah.
I ain't shame, nigga. I'm the new motherfucking George Jefferson. The fuck you talking about? I'm giving everybody walking around no motherfucking balls spot. Nigga, I ain't shame on motherfucking thing. Nigga, I had one out of
Slick. You got that shit on. You fresh. You got that shit
on.
on.
But you scare me.
I scare you.
Man, you come out here talking about.
I'm just saying, y'all here leave.
Boy, them tiny girls there hit you across your motherfucking head when she
No,
said
we
that.
don't.
Turn around, show us something. Do that again?
I like to fuck missionary, so that don't do me. I'm a missionary
You know
fucking
what?
nigga. I'm
that
just
part.
like, I'm like
That
Mister.
part.
Yeah, I'm like Mister.
Show him something. He already smashed the last take out here.
I like to fuck missionary. Your ass don't do nothing for me. No, that was a pretty ass. No, that was a pretty clean ass. But I'm a missionary.
What's your toes if you take so long to leave?
What? I want you to see my.
And you got them tattoos done in the hood.
You did that.
I did. I put the shirt on dress.
Oh, you're ugly though, but you.
My toes is not ugly.
Let me see the heel of them feet.
My feet ain't dirty.
Ooh.
It's a little dead skin back there. You ain't had a pedicure on this week. Yeah. You all right though, baby. I like everything about you except.
She just put that mouth on you.
I didn't like that part. You came out like that. So no, hell no. He want to keep you.
So Woody, you swiped it right.
Yeah, she staying.
What we doing, Charleston?
Yeah, she can stay.
She can stay?
All right.
Yeah, she can stay.
All right, y'all.
With that butt cheeks on
Yeah, she got it.
You know you don't hit a big girl.
I'm not in the
I know you hit a
ass.
big girl.
I have, but I'm not in the ass. She was a flat back big girl. She had a pretty face. She was a pretty fat mistress.
This nigga hit me before about SpongeBob.
Hey,
How you doing?
I'm good. How y'all doing?
Hey, Miss Joy.
Hi.
All right.
What's up?
All right. How many kids you got?
0.
How old are you?
28.
28.
You look nice in pink.
Thank you. You can stay.
What you say?
I'm sick of y'all looking at this ugly ass nigga. How this nigga look nice and pink? Fuck that pink. No, she can't
You
stay.
look good in pink.
No,
Don't
she can't stay. Man, fuck that pink. Man, no, she can't stay. Man, go on.
All right.
All right. But look though, if one swipe you right, you stay.
Yeah, you still get to stay. He keeping you. I just don't want
You gonna change your mind later on?
He's your kind of hoe, Woody.
No, they ain't.
These the hoes in special ed.
Hey, you remember I was telling you,
What?
I had something for you. There's that motherfucker been locked up boy to me.
What's up? Hit me out. What's up, y'all?
Your son when they came home.
What?
Damon came home.
No.
Your son ain't named?
I don't got no kids.
His mama out next Friday. Oh, shit. Say, what's your name, mama?
My name Brooklyn. They call me Jail Bay.
They call you what?
Jail Bay.
Tell me what? Jail
Because
Bay?
there ain't nothing for me to go back. That's why.
Jail back?
Jail Bay. I don't got no back.
You say you like a flat back. Yeah. One for you right there. No butt, but guts.
Shit.
You ain't no stud, is you?
Nah, I ain't no stud.
What? And he been shot. Man, don't make him mad. I mean, don't make him mad. Look at that arm. That mother been hit with a stick.
I'm trying to protect you.
What Gucci store you got them out of?
The Gucci store?
Send them back. Say, listen. You serious?
Look, like I'm serious.
Y'all dressing alike too.
You got the same colors on.
Hey.
You got the same.
Put that ass on.
Oh, whoa. You can pick that up? You can pick that up for me?
Hell no. What you got tissue in your pocket for? That nigga pick it up. Y'all dressing like.
Pick it up for me.
He got you. That's a rock. You been in jail.
You pick it up for me.
Man, that's a rock. Why you got that rock in your pocket?
You're not gonna pick it up for me?
Why you bringing weapons to a dating show?
That's not a weapon.
Shut up your head. You always have a shirt.
That's not a weapon.
What is it?
If you pick it up for me,
baby, why you want me to pick it up for you? I'll be a
thank you. What are you doing? What are you doing? You about to pick it up.
What's up, man?
What are you doing?
So y'all can't get your thing clear, y'all get mad.
No.
Say, man, why you come back, man? Y'all get her. First I get tased. What the fuck? Bullets hold all up there in the socks. Get her. He keeping her. It ain't got a cutoff switch. It ain't got a cutoff switch. He keeping you. Police can't do it no longer than 10 seconds. This bitch go long. He with that motherfucker. Man, she come out here with her motherfucking pants tucked in the shoe like a gangbanger. Yeah, but just imagine it. It make great for content.
Hey.
Hey.
Y'all gonna talk to me or I gotta talk to y'all?
Yeah. Boy, that camel toe say she can stay. Boy, that motherfucking monkey. Boy, that monkey. That monkey. Fuck them toes. That monkey. You see that monkey? Oh, that's a real pretty toe.
I mean,
okay, I seen. Okay, it's okay. You can stay for me. You must be mixed.
No.
You're not?
I'm all black.
Yes, all black.
Damn.
Hell no. I know y'all know. Hell no. She came out speaking without speaking. And we speaking the same language. She can stay.
So yes.
Yeah, she can stay. You already know that motherfucker that went to Holland when you were walking out here. Look at me, look at me, look at me. Shit, boy, that motherfucker, man, shit. You can see the spit down that motherfucker. Let me get the next lady.
Hey.
Hey.
What's up?
You must be from Bankhead.
No, I'm from Montgomery, Alabama.
Oh, Montgomery?
Yeah.
Already.
My name Kinky.
I was told don't trust girl that had his dad right there. You got something to hide?
Nah. Oh, I ain't got nothing to hide. Yeah. Oh, yeah.
Right, I wasn't trying to.
I know.
Why you push your bottom lip like that? What if nigga want a tongue kiss?
Making tongue kiss.
That's your lip gonna be irritated with that thing.
No, it's not. I promise you. I can stay. Okay. You good?
You don't want to hear what he had to say about
you? He didn't even say nothing. We just standing there like, okay, he's thinking. I'm going to stay with you. What's up?
Yeah, you can stay.
I can stay.
Yeah, your ghetto ass can stay.
Oh, I'm ratchet medium, not ghetto.
Okay.
What's that right?
What's ratchet? You already said she can stay. You can't renege now, nigga. I just want to know what the meaning is.
I mean, it's a little ratchet and I can be a little classy.
Oh, okay.
In the middle.
Already.
Little something, you know.
What part of Alabama you from?
Montgomery.
Okay. And she like to fight. Body language say she like to fight. All that. Yeah, she like to fight. I was looking at that gap, and it looked like ain't nobody been pulling on them lips with a big dick. That pussy was intact.
Hey.
Her pussy was intact. Hey, how you doing, Mom? I'm sorry.
You good?
Yes, man. I was talking about her, not you.
I know.
Yes,
you weren't talking about me.
Not at all. I can't see your pussy.
Hey. Whew, I'm getting tired of seeing you for real.
She can stay. So I want to come up here and say something with some sense. Tired of seeing this nigga. She already said she tired of seeing you, so she said she tired of seeing you.
I mean, I might.
I done kept you already.
You kept me already?
Yeah, I
okay.
kept you already, baby. Yeah, I like the kangaroo pouch, so she all right.
They can't. That's all right, baby. You hear me? Ain't nothing else to get.
How many times you gonna come out? You can't change your hair that fast?
I ain't never been over here, folks.
You ain't.
It's my first time. How y'all doing?
Hey, what's up, little bitch?
What's up?
Oh, what's up, little bitch?
I fuck with y'all.
Man, smart nigga lift you up and pounds you around like the boy on Baby Boy.
Oh, see, not too much though. Man.
Can I go rough?
What the fuck?
I want to do you like the boy did Baby Boy Mama lift you up. Yeah, you can do that with you.
Do it. I'm like, okay, cool. All right.
You can stay.
I can stay?
Yeah, you
okay,
can stay.
Okay, good.
Yeah.
Who did your teeth? They did a great job.
My dental design Miami.
They did a great job.
Little low apple bottom and all that.
Little who?
Little poop box.
You gotta go find
She got
it.
a poop box.
All right, so look, we far in the first round. We far in the first round. Out of y'all two, who you think got the best taste when it comes to women? This is based off who's swiping right, who's swiping left. You think Woody got the best taste?
Yeah, he's scraping the bottom of the barrel, nigga, and I'm climbing the tree to get the shit.
The best taste in women.
He picked the one with the green dress on.
He grabbing for low hanging fruit. Nigga, I'm climbing to the top of the tree, picking wisely. He just grabbing low hanging fruit.
Go find out at the end.
All right, man, we gonna see. Look at my next lady to the floor.
What's up, baby?
Hey, how you doing?
All right, how you doing? What's your name?
My name's Cynthia.
You look like you don't want to be here. They made you come here.
Why would you think I didn't want to be here?
Body language. Or would you like Woody?
I
don't like him either. I just met him. I'm trying to get to know him to like him.
Okay. But he looking at me like he about to beat me up or something. You all right? Oh, okay. You lying? Are you lying?
So what we doing?
I won't keep it.
You gonna keep it?
Just because he did that shit to him. Yeah, no, man, let the lady stay, man. Just don't do the man. Yeah, no. Yeah, let's try. We're going to try to get better reacquainted next round. I don't know what made that nigga do that, man. God damn.
So is he really dead?
Man, you see the problem they having out this nigga in court, don't you?
Yeah, no, I know.
Come on now, yeah, I know. Playing, they have a problem out this nigga ass in court. So yeah, he doing all kind of stuff.
Yeah, he going to hell.
Baby.
Okay.
You kept you good. You can walk off.
Why you didn't put no orange paint on your fingernail? The master toes. Yeah, come on back. Come back.
Oh,
Yeah, I just saw your toes walking off. That's all. Why you didn't paint your nail?
I didn't have time because
Okay.
this was very last minute.
Okay, all right. Yes.
Okay.
All right.
Can I have up?
Yes.
Left. Ooh.
Hold on. You
Swipe left. She got her on the leg. Harry leg. What in her, man? And her, I ain't even looked at the scar. I can't see a scar. I see fur. I didn't see a scar. I see whiskers. I see whiskers.
I don't argue with y'all short niggas. First of all, y'all short to be trying to talk shit. What's up?
So you saying there ain't no hair on the leg?
Cool, you got that. But you coming down. Look at me before you try to do that. Look at me.
What are you looking at?
And then you sweating on your shirt. Chill out. Relax.
I'm nervous. You hold got me. I'm sorry.
I'm nervous too, but you ain't got to come at me like that.
I'm sorry, baby.
Hype on, man. You left me. I'm so just. Y'all want to talk shit? We can go for it. I don't do that. Relax.
Hello, what we doing? Y'all both swipe left?
He told you I like the bottom of the barrel. That's too tall for me to try and climb that tree.
She told me to look straight, so swipe left. I'm still looking straight. And she was aggressive and tall.
She ready to beat
you up. Man, she ready to put her hand on something.
I'm still looking straight.
Man, no. Man, I don't want to fight. Security?
It's the man on space 3, 4.
Security? I want to put her in jail now. She got mad. I didn't see no scars. I see her on the leg. Man, I'm sorry. Man, listen, ma'am, whenever you go home and watch this, I'm sorry. I didn't see no scar. I seen whiskers coming out of the pool.
They longer than my feet.
They wanted to come as two. It's 2 of y'all, so why not come as 2?
What up, though?
Oh, no.
Who you looking at?
I don't know, but oh, no. Swipe left for both.
Ooh.
What up, though? What up, though?
You don't like that?
No, ma'am. I'm
I
sorry.
don't give a fuck. How you doing today?
Hey,
How you feeling?
chilling.
All right. You all right?
Yeah, because he told y'all to go left. I'm saying.
But you ain't even talked to us yet, though.
I was just gonna say go to the right.
I know, but you can't say what he say. You gotta just go off of what you say.
I'm gonna say left.
I ain't going left.
Well, beat him up.
I don't want to fight him.
He got some for
And you cute. Nah, I ain't got that for her. She too cute for me to be talking about having that for her.
So why you say go left?
You came up, what up, though?
That's how I talk. I ain't gonna change for you. You okay? You change it for me?
Yeah, I'll try to be a gentleman for you.
Oh, well, I ain't no lady.
And you smack your lip. You ain't no lady? Hell no. Man, just give me a lady, please. Did you a hoe?
No.
I'm looking for a lady or a hoe. I'm looking for a lady or a hoe now.
Me. I'm kind of like, look, I be changing tires. I hang up TVs. I be cooking and shit.
What you be cooking?
Everything.
Chicken noodles.
That's kind of like limited.
Yes or no?
Yeah.
Okay.
For my kids.
She can stay.
You already told her left.
I changed my mind.
You made me love the other girl.
I changed my mind. She said she can cook.
Hello?
Everything done.
What you want to eat? I'm going to cook for you too.
Fried pork chop with some lemon pepper on it.
You like turkey chops? Let me go turkey chops.
Hold on. He just said you finna take your bean.
See, I can do turkey chops. You ain't never had that. And I got a mean ass sauce. So let's do it. It's called mean ass.
Ain't no such thing as turkey chop. Nah, I don't want to.
You crazy?
I'll change my motherfucking mind. Ain't no motherfuckers. Ain't no
Who
such
raised
thing
you?
as turkey chop.
Who we cooking for you?
Man, I was born in 1977.
You
I ain't never heard no motherfucking turkey chop. I done heard turkey bacon.
You heard of turkey chop?
No.
Look at my Instagram.
Little girl making up stuff. Got to go.
Man, I'm a big girl, baby. I'm 31.
Oh, yeah. I'm sorry, baby.
Ohio, Toledo. Yep. You all right? You want to talk? Come on. Say something.
Yeah, shit, that work. What's up? What's going on with y'all?
What's up, Auntie?
My name Peachy.
Peachy.
Yeah, J5 throw, whatever you want to call me.
J5?
Yeah.
Throw?
J5 got 5 kids.
What?
But you said throw, though.
Yeah, that's my rapper name.
You got 5 kids?
What
Yeah.
throw mean?
You up? Yeah. I'm from up top.
Where you from, New York?
Yeah.
Y'all got to came here for him. y'all had to come here.
Tight.
No,
I
hell
really
no.
don't like your type.
I know.
But you look cool. Like you could be my.
I'm laid down, chill. I
She like-
ain't with all that. I'm being my vibes. I'm cool
I
people.
hate that. I don't do no pull-ups.
You can't be that pulled up aggressive.
Because
He left you. I was finna put y'all to the right, Jim, because he left y'all, and you just put me in my face.
I have to sometimes.
Who I bet y'all dang?
That's why I
Who I
said
bet y'all dang?
because I feel like we equal. But because you try to say
Okay,
what
let me
another
get
man
off
say, you
here.
can't
I
say what another
can
man say.
watch
You
this all night.
I'm like,
And, you know,
I'm
massaging my
face.
face.
Talking. You know what I'm saying? It's based off of appearance.
My lips ain't bad today, so I'm massaging my face. But anyway, hey y'all, if I don't see y'all for the holidays, honey, listen. Make sure y'all have a happy and safe and wonderful holiday. Be around your friends and family and have a good time. Life is short. And love is short. But anyway, I love all those who love me, and the ones that I don't, that's what you get, nothing. Anyway, hey, do something good for yourself and someone else. Make today a good day and tomorrow a better one. And guess what? Guess what? Guess what? Guess